Land acquisition, fresh matter.
Day after tomorrow, the trial for tomorrow. May I pray for tomorrow? CRP, my lordship.
Your Lordship, 2018 matter, Your Lordship, final hearing, Your Lordship.
After 2 weeks, move.
Yeah, Your Lordship.
Move after 2 weeks.
Much obliged.
Appear for the petitioner. The respondent had filed a suit for bare injunction. We made an application on the order 7 rule 11, saying that they are very cleverly glossed over areas, which if they had revealed, would disclose that they had no title. They produced documents along with the plaint, which I'm entitled to have a look at. Court should be entitled to have a look at the documents. What they say is the original owners had executed a power of attorney in favor of one Huchappa, who was then the secretary of some society. He executed a sale deed in favor of the father of the plaintiff. They produced the power of attorney. If they had not produced it, maybe I would have been some difficulty. They produced the power of attorney. Please see page number 57. In this power of attorney, there is no provision to say that he could execute sale deed, appear before the registrar, or register the document. There is only one portion, if your lordship sees, at page number 62.
But then this is a matter for trial, isn't it?
No, it's
How
not a
can I
matter of
look
trial.
at-
The reason is like this, because the Supreme Court has just passed on a latest judgment of the Apex Court. Please see this. What it says is this. That is Uma Devi Nambiar, no? Uma Devi Nambiar. Please come to para 18, my lord. That is it. Page number 6, para 18. No, 17. We do not know the ratio, how the ratio laid down the
Which
aforesaid
judgment?
decision.
Para page number?
Page number, ink page 6. Ink page 6, para 17, second line. As a matter of plain and simple fact, Exhibit A1 deed of power of attorney did not contain a clause authorizing the agent to sell the property, though it contained two
which-
express.
I have 2022 live law Supreme Court, Uma Devi Nambiar.
Yes,
Paragraph 17 starts off, we do not know how the ratio.
yes, second line of that paragraph. As a matter of plain and simple fact, Exhibit A1 deed of power of attorney did not contain a clause authorizing the agent to sell the property, though it contained two express provisions, one for leasing the property, other for executing necessary documents if security had to be offered. Therefore, by convoluted logic, punctuation marks cannot be made to convey a power of sale. Even the very decision relied upon by the learned counsel makes it clear that ordinarily a power of attorney is to be strictly construed by the court. Para 18, as held by this court in Church of Christ Charitable Trust, the document should expressly authorize the agent to execute a sale deed, to present it for registration, and to admit.
This judgment arose out of a decree passed for partition. How can we borrow this
No,
principle?
no, please,
from Order
please,
7 rule 11?
please see the next judgment. Church of Christ Ponniammal Trust.
Hold the 7 to 11 rejections.
My lord, they, in this
Only a
case,
suit for injunction, isn't
no,
it?
here they uphold, because of this, they uphold
But
the,
it is a suit for injunction. They're not seeking for a declaration.
no, the reason is,
Established lawful possession.
no, my lord, they established lawful possession, but the reason is in Ponniammal Trust, if I could just point out, the next judgment, please see the next judgment.
That was a suit for civic performance, isn't it?
Yes, my lord, please see the next judgment. As a matter of law, the Supreme Court at paragraph 13 says, para 13 of that judgment, page 715 of that judgment, says,
That was a suit for cancellation.
yes, my lord, maybe, but the point remains is,
In those cases, they.
I will point out the power of attorney. What they say is, the owners got possession through the power of attorney and which was conveyed to the father. The Supreme Court says that where the power is not there to alienate, possession still remains with the owner. The possession could not have come, and if your lordship sees the cost at,
In the context of a suit for cancellation, that may not disclose a cause of action from the statement in the plaint itself. But in a suit for injunction, if the only requirement is to establish lawful possession.
no, the reason is the cost title to the plaint doesn't show this address. The cost title to the plaint shows a very different address where they are residing, one. Two, the documents they have produced, now they have glossed over this power of attorney not having the requisite details. Also, what happens, they say there's an agreement of sale. There is no signature by the vendors, by the purchasers. There is a sale deed, there is no signature, there is no thumb impression. This is only from what they have produced in the plaint and the documents they have produced in the averments they have made in the plaint. I have not gone into any other contention there. They are not in possession. Possession could not have come to Huchappa or to the father of the plaintiff. My lord, and also the court. Please see, my lord, the court has tried to make out a case for the,
The plaint is at page 36, right?
yes. Please see, my lord. My lord, please go to the trial court order itself. It's very clear, my lord. Please see what they say. What the trial court says. Page 32, your lordship, you see what the trial court says.
Give me 1 moment.
Power of attorney they have produced. Page 38 refers to the power of attorney which they have produced. So I'm looking at that document which can be looked into for rejection of plaint. Even if it goes for trial, my lord, they can't improve on what is said in the power of attorney.
Which?
Page 38 is where they produce the power of attorney. It's not something which I have produced, they have produced. They have produced the power of attorney. And then at para 7 in the same page, they say they obtained it through a sale deed executed by the power of attorney, referring to page 57 power of attorney. That is one issue. Secondly, my lord,
That
what
issue
the
will
trial-
not, that issue may not rise for consideration at all in this suit. Because that is not, he's only seeking for an injunction.
No,
He only says he's in possession.
he says he's the owner in possession. My lord, please see the averments. Please see. Thereafter, BEML Society had delivered page 38. If he had only said that I am in possession, I don't have a case, my lord. He says that I am the owner. The Huchappa, who was the alleged power of attorney of the society, of the owners, could not have delivered possession to him, which is what the Supreme Court says. If they had not, so he says, I got a sale deed, but he's not in possession. The point remains is it's only a suit for injunction. If he had said, no, I'm in unauthorized possession, I've been in settled possession, I don't have a case. He claims, please see last page.
Strictly speaking, he did not have to state all this. He simply had to say, I'm in possession.
That's all.
He has said something about his statement.
Having said that, he has to face the
That can't be a
consequence.
ground to reject
My
the
lord,
plaint.
my lord, please. Yes, my lord. The point remains is, may I request your lordship to see this one judgment? Please have a look at this judgment. My lord. Here it says, page 715 of Ponyamal Trust.
In this compilation.
Yes, second judgment. Paragraph 13.
Yes.
While scrutinizing the plaint averment, the
Page.
bound and
Internal page.
internal page is 16. That is page 715 of the judgment.
There are 3 judgments you have referred to. Umadevi Nambiyar's Church of Christ.
The second one. Second one.
In that paragraph,
Paragraph 13, page 715 of the judgment. While scrutinizing the plaint averments, it's the bounden duty of the trial court to ascertain the materials for cause of action. The cause of action is a bundle of facts which, taken with the law applicable to them, gives the plaintiff the right to relief against the defendant. Every fact which is necessary for the plaintiff to prove to enable him to get a decree should be set out in clear terms. It is worthwhile to find out. My lord, here the trial court, what it does, it doesn't go into any of these facts, merely says he has produced Xerox copies. We'll wait for the trial for him to produce the originals. Order 7 said that you have to produce all the originals. He could have deferred decision on this, asked him to produce the originals and had a look at it then and there. Because signatures are not,
Strictly speaking, in order 7 rule 11, from a statement in the plaint,
yes. The statement in the plaint also the Supreme Court says, please see, my lord, please come to para 19. Next, we have to consider power of attorney. It's settled law that a power of attorney has to be strictly construed. In order to agree to sell or effect a sale, power should also express the power to the agent to execute the sale agreement, present the document, to admit execution, and in present case shows only authorize certain specified acts, but any other things so also. Well, the point remains is here, on the face of it, they cannot produce any better evidence at the stage of trial than what they have produced now. And they say they'll produce the original, very well. They produce it later. How can it go beyond this power of attorney now?
Having suit for, unauthorized.
Or else he could have sought for declaration. He didn't do that. He claims title and then he filed the suit for injunction.
when both the suits are,
Identical.
these two revisions arise out of an order passed by the trial court.
But one last submission. Please see the trial court order at page 32. This finding cannot be supported. One more contention of the defendants is that power of attorney, there is no authority given to the power of attorney to sell the property. There is no specific recital, etc. There is the recital to show shall have authority to execute any necessary deed. Therefore, at this stage, it cannot be said, it has to be decided. Supreme Court says you can't have all that, you should have specific averments. This is not sufficient.
These two revisions are directed against the order of the trial court, by which the trial court has refused to entertain an application filed under order 7 rule 11 to reject the plaint. Next, the respondent plaintiffs instituted a suit seeking for a decree of injunction to restrain the petitioner defendants from interfering with their peaceful possession. It was their case that the property was sold to Bemel Society and to a duly constituted attorney and an authorized official of the society had executed a registered sale deed in favor of T.R. Radhakrishnan, the husband of the first plaintiff and the father of the second plaintiff, and on the basis of which they were in possession. In this suit, an application is filed to reject the plaint on the ground that the GPA which is produced, the GPA dated 7392, correct?
Yes.
Which is produced as document number 2, did not contain a recital which authorized Javrappa.
Huchappa.
Javrappa, alva?
No, Javrappa is the owner. Huchappa was the secretary of the society.
The Javrappa has executed the GPA, correct?
Yes, Javrappa and another.
Javrappa had not authorized Uchegowda to sell the property. And therefore, from the admitted averments in the plaint itself, the plaintiffs did not have title. In other words, it is contended that there was no flow of title to the plaintiff on the basis of the very documents produced by them, and therefore their suit for injunction could not be entertained. The trial court has taken the view that the question as to whether the GPA empowered Javrappa to empowered Uchegowda to sell the property or not was not a question which we decided at this particular stage. And therefore, the entire arguments of the respondents could not be entertained. It is to be borne in mind that in a suit for injunction, the elementary adjudication that is required to be done by the trial court is to examine whether the plaintiff is in possession and whether that possession is entitled to be protected by a degree of injunction. In such a suit, the decision on the question of title could be incidental or could even be ignored, and only the factum of possession, if lawful, can be entertained. In such a suit, the defendant cannot really contend that the plaint is to be rejected because the GP on the basis of which title was claimed did not authorize the sale of the property. In my view, the trial court was justified in refusing to entertain the application of Order 7 Rule 11. I find no reason to entertain the revision. Revision is therefore dismissed.
Next one also.
Same.
And BDA my lords allotted the site. I have paid the sale deed, consideration also. I have produced the photographs to show that my lords, they have not developed the layout. Per contra, my lords, whenever we request them, my lords, to
What is your prayer?
please, my lords.
Not an alternative site.
Banshankari, my lords, sixth phase. My lords, in the connected similar set of facts, my lords, I am told. Lords, this court directed them to allot alternate site. Lords.
Shri H.T. Basaraj to take notice for respondent, relist on.
May I request for date?
2 weeks on date.
50. Please.
Petitioner is a land loser. He's seeking an alternative site, and the BDA has already issued an allotment letter at page number 31. We have already paid cital value also.
Shri
I'm
Pawan
thinking-
Kumar ji to take notice for respondents 1 and 2, relist on.
Much obliged.
I pray for the petitioner in this matter, my lord. KIDB has issued a notification for acquisition in the year 2001, 2021. There is a difficulty with regard to the petitioners. All of them are suffering.
To pay
Therefore,
compensation.
Yes.
Shri D. Boregoda to take notice for respondents 2 and 3. AJ to take notice. For our, why do you want this cooperative bank?
We have taken loan from the cooperative bank. Now they are pressurizing, we are not able to make the payment.
Why do you-
Even in that, if this property is acquired, we wanted to sell this property actually. But since acquisition
where-
notification, huh?
Are you agreeable for the KDB to pay the compensation directly to them?
No problem. If that is done after
Only delay
acquisition
the
balance,
proceedings. This will only delay the proceedings, that is all. Until they are served, until they are notified, you can't get any order. Issue notice to R4.
Think for the petitioner in this case, my lords. My lords, the respondent BDA had acquired certain lands for formation of Kempegoda layout, my lords. The
It is
petitioner's
an
land.
actuary.
My lords, it is an endorsement. I had given, my lords, there was a scheme. The BDA had offered 80 lakh rupees per acre, my lords. And similarly placed petitioners, now they are given, earlier the scheme was 40-60 basis, my lords, that 40% of developed land will be given to us.
You have taken the money.
We have not yet taken the money, my lords. Then we said that, no, accordingly, similarly placed other parties are being given 40-60 ratio. So I requested the BDA to cancel that agreement and to offer me the same 40-60 as earlier, my
AJ to
lords.
take notice for R1. Shri Kiran CV to take notice. For
My
respondents
lords, this matter may be connected with,
relist on along with.
my lords, identical cases are there. Okay, my lords, writ petition number 1433.
Piece of paper.
Much obliged. The matter is listed on 4, directed, so maybe also take much of that. Much obliged.
The petitioner, your lordship. Lordship, this is a case where the BDA has allotted sites in Banshankari 6 days 5th block. However, the forest department is claiming that it falls within the buffer zone.
Vijay to take notice for R1, the Vinayak Pandit to take notice for, AJ to take notice for R2, Vinayak Pandit to take notice for R1.
Your lordship, there are 3 other matters. Serial number 9.
Number
Serial number 9, your lordship.
7 and 9.
And 2 other law. I will write it in a piece of paper. In
Relist on so and so along with.
4 matters in total, your lordship. Much obliged.
Index.
This case I am for the petition. Lords, only preliminary notification in the year 1998, Lords, till date, Lords, they have not proceeded.
HL Pradeep, we have filed Wakalat for KDB, R2 and R3.
Pradeep Kumar submits that he has ended appearance for R2 and R3. Nice, Kevin. Nitin Prasad to
Nitin.
take notice for R4, AJ to take notice for R1. When do you want it? When do you want it? Yavat beg nimge?
Anytime, anytime next, 2 weeks, Manoj.
Relist on.
Here for the KDP. This matter has been entrusted to me. I can undertake to file Wakalat in favor of the R2 KDP.
AJ to take notice for R1, she wants to accept notice for R2.
R2.
R2. Yes, appear for respondent 2 and 3, please, Lord. R1 white.
Who's R1?
I representing R2 and R3.
Who's R1?
R1 is the plaintiff number 1 before the trial court. Now she is staying at abroad. I have given a correct address to the other side last occasion.
Matter is pending, Alain.
Out, pending it.
I appear for the petitioner.
The petitioner is permitted to take out notice. on
Notice is already taken out, my lords. We have paid the
No, take-
process.
Take out notice on the counsel who appears for R1
Please,
in the
Yes.
trial court.
grateful.
Directed me to take out notice to the respondent and also serve a copy on the counsel representing the plaintiff in the trial court.
ತಗೊಂಡಿದ್ದೀರಾ?
Notice ಹೋಗಿದೆ, our plaintiff lawyer ತಗೊಳ್ಳಿಲ್ಲ. Instructions ಇಲ್ಲ ಅಂದ್ರು.
ಅಫಿಡವಿಟ್ ಆದ್ರೆ ಹಾಕಿ ನಂಗೆ
ಇದೆ affidavit ready.
ಪ್ರೋಸೆಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
Process ಕಟ್ಟಿದೆ.
Post after service of notice to the respondents. Interim order to continue to the next date of hearing.
My lord, I've served a copy to some of the respondents.
But my lordship, we still not filed a Wakalat. If parties are not received, given the Wakalat to me, child is not accommodation.
You appear for the trial, for the respondents in the trial court.
Yes, my lordship.
Mayanagowda.
Yes, my lordship.
Sri Mayanagowda accepts notice for R1 to R4, R8 and R9. He seeks for a week's time to secure instructions. Relist on.
No award is passed. My learned friend said the consent award, we have not agreed for anything. 2002 acquisition, no award till date.
Affidavit ಹಾಕಿದ್ದೀರಾ?
ಆಗ್ತಾ ಇದೆ, some of the patients are given an ಅಲ್ಲ ಏನು ನಾವು ಒಪ್ಪಿದೀವ ಒಪ್ಪಿಲ್ವ ಅಷ್ಟೇ. ಅದೇ ನಾವು ಒಪ್ಪಿಲ್ಲ. There is no consent award.
What have they said?
In the first case, petitioner has not given any consent. The other persons of the same survey number are given a consent.
There are motions are required. Yeah, the petitioner, yeah, Devraj. Yes, Allah.
Otherwise notified ಕಳ್ಸಿದಾರಾ?
ಮಾದೇವಯ್ಯ ಇವರು ಇದಾರೆ, ಅವ್ರ ಪೋರ್ಷನ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ, ಇವ್ರ ಪೋರ್ಷನ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
Then what is the effect now if no award is passed?
Kada,
At least if you passed an award for in respect of Madhavaya.
no, they are given a consent to accept the compensation. And in the meanwhile, what has happened, there are several writ petitions filed before the Dismissal court. And there was an interim order. Now, my lord, most of the writ petitions dismissed and that up to Supreme Court also. Up to
Then how-
the appellate.
The prayer here is to pass an award, ತಾನೆ?
The prayer is not just to pass the award, pass the award under the new act. That they are disputing. And
Prepare to
secondly,
pass an award or what, or should we?
The question is, my lord, whether they have to pass, this equation is about 2002, 4 preliminary notification, my lord, 2002. Whether they are entitled under the new act or final act, your lordship has decided. Again, at that, there are appeals are pending, there is an interim order operating. Identical matters also pending before the division bench.
No, I'll follow my order. You take it up in appeal along with other matters.
My submission is, my lord, till, because.
Now, how can you sit on this acquisition after 20 years? At least under the old act, if you had passed, I can understand.
ಕೊಟ್ಟಿಲ್ಲ.
You don't even pass an award.
We are ready to pass under the old act.
Ready alla, you're not ready, therefore I'll quash the acquisition.
What has happened earlier, the writ petitions are filed, that is interim order. Therefore, it's not.
They had filed writ petitions.
ಮೂರು ಆಗ್ಬೇಕು.
ನಾವು ಹಾಕಿಲ್ಲ.
17.
ನಾವು ಹಾಕಿಲ್ಲ.
What was the impediment for you to pass an award in respect of people who had no objection for the acquisition?
Some of the land.
Sir, because in the, they admit in para 9, some of the.
Petition 1 and 2. And the petitioner 1 and 2. And the petitioner.
In para 9,
Para 9 of
para 9 of the
Writ
writ petition, madam.
writ petition, huh?
First, 4800.
48?
ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ.
Para 9.
002.
ನಮ್ಗೆ entry ಮಾಡ್ರು. There was no entry order also in that case.
Directly dismissed. In the year 2010.
Even this dismissal was in 2010, Chandrasekhar.
Then again, my lord, some of them, my lord, with published
No,
details.
they are the notified Kadidas also.
Yes, certain posts.
They have not challenged the acquisition.
Certain persons, other persons are notified copies also. There are number of.
So I'll quash it only insofar their land is concerned. Because you have no interest in the lands because you're not passing compensation, powered coil, the quash.
The prayer is to, of course, my lord, they sought for payment of under the new act. The question-
Alternatively ಅಂತ ಕೇಳ್ತಾರಲ್ಲ ಅದನ್ನ ಕೊಟ್ಬಿಡ್ತೀನಿ ಅಷ್ಟೇ.
When they sought for alternative relief for payment of compensation, question.
ಅಲ್ಲ,
was
first
not
prayer is
arised.
to pay compensation under the 2013 act. ನೀವು ಕೊಡಕ್ ರೆಡಿ ಇಲ್ಲ. Alternative prayer I'll grant.
Lord, my submission is, my lord, and the matters are pertains to the 2004, much prior to the coming into force of the act. Even for amendment to section 30 also, my lord, payment is made payable under section 29 of the KAD Act. There is no amendment to that act, section 29 also, my lord. That is the.
ಇನ್ನೇನ್ ready?
Payment of compensation is under section 29 of the KAD Act. In section 30 of the amendment, section 29 also not incorporated. Not sure.
29 is by consent. How can it be incorporated?
For 29 also.
In case you don't want to pass an award by consent,
There-
then section 30 will come into.
If no award is passed, then section 29(3) it has to reference to made.
29(1) and 29(2) talk about negotiated offer
Then one is a notice will be issued, 29(2) compensation. will be
By consent.
By agreement.
If there is no consent, you'll have to refer to the deputy commissioner.
The
Deputy
section
commissioner is supposed to pass an award.
Section 30 says, only for procedural aspect. So if our holding inquiry, reference to the court, apportionment that to that extent only, not for other purpose.
Then what is the methodology according to you?
Methodology according to me is malad. Since malad,
There is no consent. We will agree there is no consent.
then we have to
then-
pass award under the, by way of issuing notice to the parties and determine as per the, says available under the, sub-register getting a
Then they go and seek for reference.
reference under it.
You have not done both.
The reason is, my lord, because there are several petitions are pending, it could not pass.
I'll grant the alternative prayer. You're not interested in the land. You can't say that the property is vested in you and sit on the compensation for 14 years.
Compensation, we are not saying we're not paying. We are paid, my lord. Question is whether under old act or new act.
22 years.
What is?
Whether under the new act or old act, that is the only.
You under the new act, obviously, because you had the power to pass an award under the old act before 2013.
My submission.
If you do not do that, you lost that chance.
My submission is they are entitled only under the new act, but old act.
I will hold that under the 2013 act, they're entitled.
My submissions may be recorded, lordship, and those matters are pending before the division bench, and there is an interim operating against that order, and several petitions are appealed.
Your choice. You want me to pass an award or you want me to quash the notification? Your choice.
Washing up notification does not, because already this on court and Supreme Court has upheld the acquisition.
No, this is on the ground that you not pass the award. There was no impediment for you for 14 years.
Oh, so far not, no, lordship kindly says there are it's not a piece of land is involved. There are number of petitions are involved in the interim order operating. There was a prohibition as to pass on our awards.
How much do they own? How much do the petitioners own?
It's about 1 acre and that some.
There's nothing preventive from passing an award in respect of.
Several 5 survey numbers or 4 survey numbers, pieces of lands are involved.
That means you don't want it without the others, you don't want this land also.
We want land, well, I will not saying that, not.
Not for 14 years, you can't, you have taken possession?
Yes.
Then,
My lord, BMRCL is concerned 1,619, 1,169 square feet area, my lord, we have deposited the compensation amount as per the KDB resolution under 29(2). We are deposited with the KDB. And that land is handed over to me, as my lord, we are the work.
you are agreeable for that 29 to amount deposited by BMRC?
No, 29 to
12, per acre, 12.10 crores rupees.
140 credit. We are not agreeable for that consent award. Metro is now acquired and they have determined.
No,
that
we have taken
22,000
from the
per square,
KDB, my lord. KDB acquired from,
22,000.
Metro is not acquired. We have taken the land from the KDB.
21,000 per square feet is award. My lord, there are two issues. One is that 2002 acquisition. Though we filed the writ petition, there was no interim order there, it came to be dismissed. Now for 22 years, they don't pass an award. Now, how do they take over the land without paying a single paisa to the landowner? It looks as if that the landowner is virtually has no right at all in respect to this property. Now for 22 years, they don't give us any money at all. Now KDB appears to be, my lord, no doubt this period will not apply the view taken by the Supreme Court. But in a case like this, now, even today they have not passed an award according to whatever they deem fit. And secondly, my lord, since they have not passed the award till date, they should be, I am entitled for compensation as per the market value prevailing as on the date of passing of the award. In similar cases, my lord, court has postponed the date of preliminary notification. Alternatively, since they have not.
What is the acquisition for?
This acquisition, my lord, 25/11/2002 for.
Red notification is, yeah?
Page 33. Page 33 is the preliminary notification. ಅದರಲ್ಲಿ ಏನು ಹೇಳಲ್ಲ ಅವರು ಬರೀ ಕೈಗಾರಿಕಾ
Commercial pass ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ ಅವ್ರಿಗೋಸ್ಕರನೇ ಇದು?
ಅಲ್ಲ, ನಾವು we have KDB ಇಂದ ತಗೊಂಡು, KDB acquired.
ಒಂದು portion ಮಾತ್ರ small extent railway track ಅದಕ್ಕೆ ತಗೊಂಡಿದ್ದಾರೆ ಅಷ್ಟೇ.
Metro has taken about 12,000 square feet.
ಅದಕ್ಕೆ ಅವ್ರು ಎಷ್ಟು 12 crores per acre ಕೊಡ್ತಿದ್ರ?
Per acre
ಅವರು
12.1.
ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ, ಅದು ನಮಗೆ
10
ಅದು
crores.
ದುಡ್ಡಿಲ್ಲ. That they have deposited with KD.
ಅದು ತಗೊಂಡೇ ಕೊಡ್ತೀವಿ ಅದನ್ನ.
ವಾಶ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಬಿಡಿ, ಯಾಕೆ ಸುಮ್ಮನೆ?
Then my lord, your lordship may, acquisition already upheld. Your lordship may.
Acquisition upheld, I have no problem with that. But you cannot sit on the acquired land without paying compensation for 20 years.
Has to follow your lordship order, my lord, if they have filed a period, then you have to prepare appeal. That's my submission is, my lord, since under the old act, they are entitled, not under the new act.
After 24 years, you want to make the submission. Even after 20 years, you can, let us say, wait for another 20 years and then pass under the old act.
Because of the circumstances, to prevent the petitioners himself and some others also prepared.
They did not challenge the acquisition.
They challenged, my lord, it was dismissed.
When was it dismissed?
Then, my lord, the tape also filed. I said, my lord, the tape
2010.
One of the petitioner challenged it in 2005, no interim order, dismissed in 2010.
Writ appeals also dismissed, my lord.
Only petitioner number 1 and 2, other petitioner did not challenge
Then
it.
SLPs were filed, then review petitions were filed. It's not it as if they're saying a straight.
If you talk about the old act, I'll quash the notification. On the count that you have not passed an award after 24 years.
And I am saying that, my lord, since in view of the earlier notifications are upheld by the Salem Court, they are not
Correct.
entitled for. that.
I'm not setting aside the acquisition on the ground that the acquisition is invalid. I'm setting aside the acquisition only on the ground that you have not passed an award. You cannot take somebody's land free of cost for 20 years.
No, no, that, for that.
Redeliver possession and damages, let them fight it out in the civil court.
Then, my lord, your lordship has to follow that, your lordship.
ನೀವು ಮನ್ಸ್ ಮಾಡಿ
ಅಲ್ಲ,
ನೀವು
ನಾವು consent
ಹಿಂಗೂ ಹೇಳ್ತೀರಾ
ಮಾಡ್ತಾ-
ಹಂಗೂ ಹೇಳ್ತಿದ್ದೀರಾ ನೀವು.
I am opposing that, my lord, your lordship has to pass then, that's all.
2013 act ಮಾಡ್ರೆ ಸಾಕ ನಿಮ್ಗೆ?
But
That is a prayer.
2013 act.
That is a prayer.
now, the other relief which I am asking is to defer this date of market value of this property, since they have not.
No, but you will get 15% compensation on that.
15% interest ಬರುತ್ತೆ, ಅದೆಲ್ಲ ಬರುತ್ತೆ ಅನ್ನೋದು ಅಷ್ಟೇ ಹೊರತು ಯಾವ್ದು ಇಲ್ಲಿ ತನಕ ಬಂದಿಲ್ಲ. Even otherwise, my lord, kindly look at the conduct of the acquiring authority. Supreme Court has held that right to property is a human right. You are deprived me of this property, and after 22 years also no award is passed. Till date award is not passed. So therefore, my lord, this is a just case where they should give the market value as on the prevailing date.
Please make an offer to them and get it settled. Why do you want to invite an order?
Then your lordship may.
How can you sit on this for 22 years? If he insists on that alternative prayer and does not press the main prayer, where do you stand? Then, luckily for you, he's saying, just pay me more market value.
Under the.
And you've enjoyed that property for so many years now.
Then it may take next year, so that I will ask and, or I will have to lay upon judgments also.
ರಿಸರ್ವ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ಲಾ ನೀವು ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹಾಕ್ತೀರಾ? ನೀವು ಅವ್ರು ತಗೊಳಲ್ಲ, ಏನು ಡಿಸಿಷನ್ ತಗೊಳಲ್ಲ ಅವರು.
ನೋಡೋಣ, next week ಅಲ್ಲಿ ಒಂದು ಚಾನ್ಸ್.
Realist, finally. Affidavit of. ಎರಡು ಸಪ್ರೇಟ್ ಆಗಿ ಹಾಕಿದ್ದೀರಾ?
ಎರಡು separate.
Affidavit of. these
ಅದರಲ್ಲಿ
specification officer.
ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ one of the family member, petition filed one form, brother, another brother given a consent.
For those who gave consent, nothing prevented you.
Same property, ಅವರ ಇದೇ ಪ್ರಾಪರ್ಟಿ ಅವ್ರ ಬ್ರದರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಕನ್ಸೆಂಟ್.
ನೀವು ಡಿಪಾಸಿಟ್ ಮಾಡ್ಬೋದಿತ್ತಾನೆ ಅವಾಗ?
ಇಲ್ಲ, ಈಗ ಆಗಿರೋದಲ್ಲ.
ಯಾರು brother ಕೊಟ್ಟಿದ್ದಾರೆ?
Affidavit of Sri so and so is filed in the same as taken on record. Released finally.
ಬ್ರದರ್, ಓನ್ ಬ್ರದರ್ ಕನ್ಸೆಂಟ್.
ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ? ಅವ್ರ lawyer ಯಾರು?
ಸ್ವಲ್ಪ
ಹಂಗಪ್ಪ, ನಮ್ದ್ರಲ್ಲಿ ಏನು ದೇವರಾಜ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ.
In the last location, they have filed an application quoting the estimate of rupees 30 lakhs, your lordship.
Pollution, STP.
Estimate of 30 lakhs to install STP, your lordship. The executive meeting of the society has been called the next week. I request for 2 weeks time, your lordship. Simultaneously, your lordship has also directed the BDA to ascertain the value of the STP proposed to be installed.
ಲಕ್ಷ್ಮೇಶ್, ಗೊತ್ತಾಯ್ತು ಏನಾರು ಎಷ್ಟು ಅಂತ? ಅಲ್ಲ, ನೀವು ನಿಮ್ಮ ರಿಲೀಸ್ 2 weeks ago not yet.
Respond. The last occasion, your lordship had asked, there any building bylaws for the BDA? But there are no building bylaws for the BDA, Lord. We know the National Building Code only. And Lord, in that, Lord, based on the National Building Code only, the BBMP also has adopted those provisions.
No, when you granted them the approval.
Yes.
To form that layout.
Yes.
What was the conditions for erecting a building?
But that they'll have to follow the approval.
Do you have a copy of that approval?
I have.
Lord, there are two sets of plans which they have approved. One is on the development plan by the authority. Another on the building is approved by the engineering section.
No, the order that is referred to here, that is the first one, 17/4/2017.
That is modified and this is the latest, my lords. That there is no
You
dispute.
have the original approval.
This is a copy.
Indicate what is the conditions that they've imposed.
Conditions are here, my lords. The conditions which are imposed in the extract which are produced, they are the same throughout. This is the final approved development plan.
And what is this bylaw 5.5.1?
Lord, that is wrongly typed. It should have been 6.1, Lord, which says commencement certificate.
A work order alva or conditions hakkadu. This is only the plan approved.
Plan approval, Lord, the building, even the building structure is also approved as to what is the base, everything is.
It has to be approved, my lords. I am not disputing the fact I need their consent. I am not disputing the fact, my lords, that I need their consent because they are the planning authority. My grievance is with regard to the action they are trying to initiate for alleged deviation.
Your lordships could take.
ಕಟ್ಟಡವನ್ನು ಪ್ರಾಧಿಕಾರದಿಂದ ಮಂಜೂರಾದ ನಕ್ಷೆಯಂತೆ ನಿರ್ಮಿಸುವುದು ಕಡ್ಡಾಯವಿರುತ್ತದೆ.
I am concerned
Of you going to the Gram Panchayat and getting the approval, you have not challenged this particular condition.
No, my lords, in spite of that condition, in addition to that condition,
Sure, you have obtained an approval. The approval incorporates a condition saying that for construction of a building, it should be only with them.
no, my lords, that I have to take their consent. I have no dispute.
No, this is the word that is used. ಪ್ರಾಧಿಕಾರದ ಮಂಜೂರಾದ ನಕ್ಷೆಯ ಪ್ರತಿಯನ್ನು, ಸಾರಿ, ಕಟ್ಟಡವನ್ನು ಪ್ರಾಧಿಕಾರದಿಂದ ಮಂಜೂರಾದ ನಕ್ಷೆಯಂತೆಯೇ ನಿರ್ಮಿಸುವುದು ಕಡ್ಡಾಯವಾಗಿರುತ್ತದೆ.
Yes, my lords.
So the approval list should be given by them.
It should be given by them. It should also be given by Panchayat is my submission, my lords.
No, you cannot interpret the approval in any way that you want. This is the approval that you have got. You have not challenged the condition.
I am not challenging the condition, my lords. I am only saying that approval is required. I have taken it under the Town and Country Planning Act because I need to take their approval also. I cannot violate their
In
conditions.
the approval granted under the KTCP Act, there is a further condition imposed that even for the building that is to be approved, it is to be approved by them. Did you obtain approval from them?
Yes, my lords. That is the engineering section approval which they have given.
The approval is for each building?
No, my lords. That
Then-
is for the entire complete set of buildings which are to be put up. This is the sanction which they have given from the engineering section. My lords, I'll explain the project, my lords. It's over a vast tract of land. There's a group housing scheme where individual houses or villas are constructed based on individual sanctions. There's an overall development plan where the identification of where the parks are, where the roads are is done, and where the sites for the buildings are done by the planning authority. And then they issue a condition saying that this is the extent to which you can construct. They also say this is the construction which you have to do. After this, I am supposed to go to the Panchayat, take a building license because I'll violate the Panchayat Raj Act if I don't do that. Therefore, my submission, my lords, is what they've issued to me now
Your
is that,
argument all the other day was that you don't have to, you only have to go to the Panchayat.
no, my lords,
Building plan is to be approved by them.
building plan has to be approved by them to the extent
Commission on the last occasion. Give me that plan, whatever that you have.
Panchayat Raj.
That building plan.
My lords, in view of the fact that they are the planning authority, I cannot violate any condition which they impose. But they do not have the authority to take action against me for violation of the plan because the building plan is actually approved only by the Panchayat Raj. This is the consent given to me for construction.
This is the same plan.
No, my lords, here the signature is not by the planning authority. The signature is by the department. And they say that this is the approval which you have to take. Based on this, I approach the Panchayat Raj
To take an approval for individual buildings,
from the Panchayat, my lords.
not from them.
No, my lords. The license is granted to me for construction of the,
Your own interpretation of the law.
my lords, based on the notification.
Without challenging the condition imposed by BDA, you will decide where you will go take a license.
No, my lords, this is the condition which is followed by everybody, my lords, because it falls under two jurisdictions. If my lords, if I may.
I will not go into that legal question now. The approval that was granted to you was subject to a specific express condition that you obtain the approval of the building plan from the authority. You admit that you have not obtained approval.
No, my lord, this is the approval which I have obtained, my lords.
If this was already an approval granted, where was the question of having a condition to get the approval of the authority for the building plans?
That is the second plan which I have furnished, my lords. The first one is the
Same as the first plan.
first one is the development plan, my lords. The second one is an engineering plan which is approved, based on which I have to take approval of the panchayat, my lords.
What is the violation that they have done?
But they have, the basement car parking area has been constructed. The area which was shown as a basement car parking area is constructed. One,
My lords,
and
this is the
lot the
summary.
driveway is constructed. And lot they have encroached upon the area which is relinquished to me for park and open space.
No, my lords. Park and open spaces is not done, my lords. I have just handed
Not
over a
have.
summary.
What are the violations as compared to the plan that you had approved?
Lord, in Lord, WP 23101 of 2022, Lord. Lord, it is illegal construction in a car parking slot.
Then?
And erection of RCC columns and beams by encroaching car parking meant for residential visitors. This is the first one. Lord. In the 23037, encroachment of a landscaping and setback area that is on western side of a villa number 39 by erecting concrete compound wall causing obstruction to the said landscaping and setback areas. Third one is WP 23106 is encroachment of a setback and landscaping. Lord. 23102 encroachment of land, same Lord. And 23103 is expansion of building in villa number 73 over the above permissible sanctioned measurement of additional building on the northern side. And Lord, has been encroached upon car parking, illegal construction of a car parking slot still in progress. Lord. And Lord, in 23097, this is again by setback and landscaping.
My lords may refer to the summary which I have just handed over. I have listed out what all they have alleged is the violation, except for the first instance where they say visitor car park is constructed. Everything else is additional construction of literally compound wall, my lords.
We now given one more modification to this plan.
Yes, my lords, that is pending. Only to the limited extent, my lords, that the visitor car parking is being shifted so that this violation is no longer.
Suppose that modification is granted, will these violations go?
Lord, that they'll have to work out in that manner.
No, whatever they have submitted now.
Yes.
If that modification is allowed.
Yes.
Then will all this irregularities or contraventions be nullified?
Yes, my lords, that is.
So far as that visitor car parking, Lord, if he gives us an.
No,
yes.
all the other four violations that you referred to.
Yes.
Suppose you approve the modified plan.
Yes.
Now all of them will stand cured?
Not few of them will stand. To the land which has vested in us by virtue of a release deed, insofar as the park and open spaces area.
We have not considered on that.
Unless until they relinquish they execute a modified relinquishment deed to giving us that area in the same locality there.
That is after you approve the modified plan, isn't it?
After I approve.
And
Before
if they refuse, only then that will.
Yes, yes.
But even if that is done, your problem is solved.
Yes, that will have to be sorted out in a manner permissible. In the sense, not if a visitor car parking is shown here, not if they and some area is encroached upon, and not then if they have to give me a visitor's car parking area somewhere else to a same extent, not I'll have no problem. It is
How long
only
will you take to examine that whether the modified approved plan could be granted or not?
3 weeks. By 3 weeks, we'll.
It is actually pending with them, my lords. They have said because of pendency of writ petition, we will not consider. So let them consider.
You require 3 weeks, I mean.
Now, the problem is shortage of hands.
No, you want to demolish the structures, once you give the modified plan, do you think you should act fast and say whether they can be granted that or not?
Yes, we are in the process, my lord, but now at the moment, my lord, shortage of staff because of the election duty. That's why I asked, only 1 or 2%.
Will I record the fact that within 3 weeks you will consider their modified plan and then pass orders?
Yes,
It is submitted by learned counsel for the BDA that the modified plan submitted by the petitioners is pending consideration. And in all probability, the same would be considered and appropriate orders will be passed within a period of 3 weeks. In the light of the above, release these petitions on so and so. Interim order granted earlier is extended to the next date of hearing.
but may I make one request. But in fact, even after, my lord, and my instructions are, even after this, my lord, he's been continuing with certain construction, let him be put on terms also, my lord, that he is.
What is he doing?
But he is now putting up sports, this one on the area which has been put up for open spaces and park and by.
Want me to injunct you or you want me to?
No, my lords, my specific instructions are park and open spaces, absolutely no construction is being put.
Record your undertaking. Shall I record
Park
his
and open spaces, there's nothing being constructed.
What is it that he's putting up?
But he is putting up some construction over the area which has already been relinquished to BDA.
If at all,
That, can you specify which area so that I can take undertaking from him
At
specifically?
least from the area which has been relinquished to BDA, let him not do any other work.
That is for the BDA submits that despite the fact that relinquishment has been executed in favor of the BDA, the petitioners are putting up constructions in those areas. In the light of the above, Sri Learned Counsel appealing for the petition submits that in respect of the areas which have already been relinquished in favor of the BDA, be it civic community sites, from open spaces or parks, no construction be carried out by the petitioners. Released on. Yes.
Next, sir. LDs and challenge.
What is the next?
Next, sir, N matter, page number 66. The endorsement given. Prior to that, I'm kindly permitted to drive lordship to the writ petition filed by me, which was
Consent
directed.
ಆಗಿತ್ತು ಅಂತಂದ್ರೆ
Pardon?
consent ಆಗಿತ್ತು ಅಂತೇನು?
Consent ಆಗಿತ್ತು ಅಂತ ಆಯ್ತು, but actually that consent is not acceptable, but over my lord, permanent lordship. ಯಾಕೆಂದ್ರೆ consent according to them, permanent lordship turn to the annexure J1, my lord, J1. That is the agreement, my lord. J1, it was dated 26th April 2018, my lord.
Next year, A.
26th, annexure J, my lord. J1, 26th April 2018, permanent lordship turn to the
Page?
page 42, my lord. These are the agreement, my lord, permanent.
Yes.
42. Whereas section 20, the Karnataka Area Development 1960 provide that way the amount of compensation has to be determination by agreement between the government and the persons to the compensated shall be paid in accordance to the agreement. Whereas the part, pardon?
Page 46.
last pair 42 mil.
42 na?
42 mil. J1.
Whereas the parties have mutually agreed.
Yes. Mutually agreed to compensate total rupees 15 crores, 55 lakhs, 42,000, so on, so on. Then the owner has issued some of rupees, so on. So then these are the conditions, my lord. Then your lordship to page number 44, my lord. They have passed one more order. Because Colchim was paid less, then again they have passed an order on permanent lordship, page number 44, my lord. 44 last notice. ಧನವನ್ನು ವಿಶೇಷ ಭೂನ 10% ಆದಾಯ ತೆರಿಗೆ ಹೂಡಿಕೆ ಬಾಬತು ಸಮಾನವಾಗಿ
ನೀವು
44 ಪೇಜ್ ನಂಬರ್ ಇದು ಕೆಳಗಡೆ ಸಾಹೇಬ್ರೆ ಭೂನಗರ ಜಿಲ್ಲೆ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಪೇಜ್ ನಂಬರ್ 44 ಸಾಹೇಬ್ರೆ ಆಫ್ಟರ್ ದಿ ಅಮೌಂಟ್ ದ ಟ್ರಾವೆಲರ್
ಒಟ್ಟು 31,362 ಚದರ ಮೀಟರ್ ವಿಸ್ತೀರ್ಣದ ಮಾಲೀಕರಾದ
ಎಸ್
ಫಂಡ್ಸ್
Yes. ಇದು
ನಾನು
ಬೆಂಗಳೂರು-
ಭೂಮಿ ಮತ್ತು ಕಟ್ಟಡ ಪರಿಹಾರ ಧನವನ್ನು ವಿಶೇಷ ಭೂಸುವಿನ ಕರೆ 10% ಕಳೆದು ಉಳಿಕೆ ಬಾಬ್ತು ಸೋನ್ಸು ನನ್ನ RTGS ನಮ್ಮ ವರ್ಗಾವಣೆ ಮೂಲಕ ಚೆಕ್ ನಂಬರ್ ಸೋನ್ಸು ಪಡೆದು ಆದಾಯ ತೆರಿಗೆ ತಂದು BMRC ಎಲ್ಲರೂ ನೀಡುವ ಒಪ್ಪಂದ ದರದ ಪೂರ್ವ ಪ್ಯಾಕೇಜ್ ಅನ್ನು ಸಂಪೂರ್ಣ ಒಪ್ಪಿ ವಿಶೇಷ ಭೂಸುವಿನ ಕರೆಯಿಂದ ನಾನು ಪಡೆದಿರುತ್ತೇನೆ.
ಅದೇ ಇದಕ್ಕೆ 40 ಪೇಜ್ ನಂಬರ್ 44 ಮೇಲೆ ಇದು 44.
He says that he has received the entire amount.
ಅಲ್ಲ ಇದರಲ್ಲಿ again ಪೇಜ್ ನಂಬರ್ ಡಿಸ್ಟರ್ಬೆನ್ಸ್
The same page 44 ಫೋಟೋ ಇದೆಯಲ್ಲ.
ಫೋಟೋ ಇದೆ ಅವ್ರದ್ದು. ಅದರಲ್ಲಿ ಕೆಳಗಡೆ ಇಲ್ಲಿ ನೋಡಿ sir, ಕೆಳಗಡೆ ಇಲ್ಲಿ ಬನ್ನಿ ಸರ್, ಧನ ವಿಷಯ 10% ಆದಾಯ ಅಂತ ಇದೆ.
That is TDS.
ತೆರಿಗೆ ಉಳಿದು ಬಾಬತ್ತು 13,99,99,78 ಸೋನ್ಸು ಪಡೆದಿರ್ತೇನೆ. 100 ಬ್ಯಾಂಕ್ ಸೋನ್ಸು ಮತ್ತೆ 5,7,2000 ಪಡೆದು ಆದಾಯ ತೆರಿಗೆ 10ರಂತೆ ರು 1,55,00,000 1,55,00,000 289 ಸೋನ್ಸು BMR ರವರು ನೀಡುವ ಒಪ್ಪಂದದ ಭೂಪರಿಯ ಪ್ಯಾಕೇಜ್ ಸಂಪೂರ್ಣ ಒಪ್ಪಿಸಿ ದೇನಿವಲ್ ಆಡಿಸಿಪಟ್ಟು ದಿ annexure. Next page number 48 ಮೇಲೆ 48 again the photograph is ಅದರಲ್ಲಿ ಇಲ್ಲಿ ನೋಡಿ ಸರ್, ಸೇಮ್ ಡಿಸ್ಕಷನ್ ಇಸ್ ದೇರ್. ಲಾಸ್ಟ್ ಲೈನ್ 29/12/2018 ನೋಡಿ ತಂದು ಪಡೆದು ಆದಾಯ ತೆರಿಗೆ ಅದರಂತೆ ಪಡೆದುತ್ತೇನೆ ಮಾತ್ರ ಚೆಕ್ ಸೋನ್ಸು BMR ನೀಡಿರುವ ಒಪ್ಪಂದ ದರದ ಭೂಪರಿ ಪ್ಯಾಕೇಜ್ ಸಂಪೂರ್ಣ ಒಪ್ಪಿಸಿ ನಾನು ಪಡೆಯುತ್ತೇನೆ. ಅದರಲ್ಲಿ ಹಿಂದೆ 1.5ರಷ್ಟು ಪಾವತಿ ಮಾಡೋ ಬದಲು 1ರಷ್ಟು ಪಟ್ಟು ಮಾತ್ರ ಮೂಲ ನೀಡಿ ಈಗ ಉಳಿದ ಅರ್ಧ 0.5ರಷ್ಟು ಪರಿಹಾರ ನೀಡಲಾಗುತ್ತಿದೆ ಅಂತ ಎಕ್ಸ್ಟ್ರಾ ಈಗ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಆಫ್ಟರ್ ದಿ ಅಗ್ರಿಮೆಂಟ್ ದಿಸ್ ಆರ್ಡರ್.
ಅದಕ್ಕೂ ಒಪ್ಕೊಂಡ್ರಿ ನೀವು?
ಅದನ್ನು ಒಪ್ಕೊಂಡಿಲ್ಲ ಅಂತಲ್ಲ. ದೆನ್ ಮೇಲೆ
ಲೆಟರ್ ಒಪ್ಕೊಂಡು ಚೆಕ್ ತಗೊಂಡಿರ್ತಾನೆ ನೀವು RTGS ಮಾಡಿರೋದು
ಚೆಕ್ ತಗೊಂಡು ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ ಮತ್ತೆ. ದೆನ್ you will also turn to the annexure F ಮೇಲೆ after the passing of the order. This annexure F ಮೇಲೆ prior to that you will also turn to annexure E ಮೇಲೆ. Annexure E, this is the direction issued by the this honor code in WP number 27/392/30 so and so dated 17 September 2019 ಮೇಲೆ. There the direction petition dated last page number 27 ನೋಡಿ sir. Issued at any other so and so. Petitioner is stated to have been filed the representation before the competent for seeking enhancement of the compensation in their favor as is evident from the annexure A to D. The concerned respondent has not taken action either accept the reject the grievance of the petitioner in accordance with law. Therefore, the concerned respondent is hereby directed to consider the grievance of the petitioner and pass speaking order to communicate the decision of the so and so. Then you will also annexure F ಮೇಲೆ. ಇದು after the direction ಮೇಲೆ. This is 25/10/2019 ಮೇಲೆ. ಅದರಲ್ಲಿ ಪರಮೋಟಿ ವ್ಯವಸ್ಥಾಪಕ BMR ಸೆಲ್ ಬೆಂಗಳೂರು ಮೆಟ್ರೋ ರೈಲ್ವೆ ಕೆಂಗೇರಿ ಹೋಬಳಿ ಚನ್ನಪಟ್ಟಣ 27 ಮತ್ತು 23 ಜನರು ಭೂಸ್ವಾಮಿಗೆ ಬಿಡಿಸಿಕೊಂಡಿರುವ ಬಗ್ಗೆ ಪರಿಹಾರ ಪಾವತಿ ಬಗ್ಗೆ ಶಾಂತಿಲಾಲ್ ಬಸವಗುಡಿ ಬೆಂಗಳೂರು ಮೆಟ್ರೋ ರೈಲು ಯೋಜನೆಗೆ ಉಲ್ಲೇಖದಂತೆ ಶ್ರೀ ದುರಾಂತಲ ಮತ್ತು ವಿನೋದ್ ಕುಮಾರ್ ಅವರು ಚಳ್ಳಘಟ್ಟ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 27
ನೀವು ಒಂದ್ಸಲ ನೀವು if you accept under 29(2), how can you ask for more?
ಅದಕ್ಕೆ ಯಾಕೆಂದ್ರೆ this was not disclosed for them. That is regarding this, they have not fully understood what is the agreement. Because immediately even award pass ಅದಕ್ಕೆ ಮುಂಚಿತವಾಗಿ agreement ಮಾಡಿಲ್ಲ ಒಂದು. ಇಲ್ಲಿ again they are accepting. Yes, ನಿಮ್ಮ ಕೋರಿಕೆನ ನೋಡ್ತೀವಿ ವಿಚಾರಿಸ್ತೀವಿ ಅಂತ annexure F ಅದ. annexure F ಅದರಲ್ಲಿ they are 27 ಮತ್ತು ಸ್ವಾಧೀನಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಪ್ರತಿ ಚದರಿಗೆ 22,377 ರಂತೆ ನಿಗದಿ ಕೋರು ಮನಸ್ಸಲ್ಲಿ ಇದರ ಮನೆ ಬಗ್ಗೆ ನಾವು ಕಾನೂನು ರೀತಿಯ ಪರಿಶೀಲಿಸಿ ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ತಯಾರಿದ್ದೇವೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಇದು after the direction issued the representation given by the petitioner, then this endorsement has been given. Then subsequently there was a contempt petition, then this again they have gone back, not considering the representation. Again they have taken the agreement as a shelter. ಇಲ್ಲಿ ಯಾಕಂದ್ರೆ agreement ಬಗ್ಗೆ there is consensus.
Tell me in law, once you agree for receiving this compensation.
Yes, madam.
Of this particular amount.
Yes.
How can you go back and say that that is low now, give me more?
No, in
The
fact,
very purpose of the consent award is to ensure that there is no litigation or no further demands. Once you accept the demand, how can that be set aside?
I'm not seeking, I'm seeking mandamus only because to consider my reputation.
That has been considered and refused.
No, not refusal.
Taking for quashing of annexure L.
Yes, yes.
Annexure L is refusal. Because you've already received consent award. You can't ask for more.
No, in fact, my lord, can you permit it to refer a judgment, my lord?
In consent award ಇದ್ರು quash ಮಾಡಬಹುದು.
ಇಲ್ಲ ಸೇಲ್ ಡೀಡ್ ಆಗದ ಅದೇ ತರ ಸ್ವಲ್ಪ ಸಿಮಿಲಾರಿಟೀಸ್ ಇದೆ. The facts ನೋಡಿ, facts. Are para number 7 and 8 ನೋಡಿ.
This was not, this is something else. Statute 29 to get agreement ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ ನೀವು. How can this judgment help you?
Agreement ಇದ್ರಲ್ಲಾದ್ರೂ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಂಡು ಅವ್ರಿಗೆ ಸೆಪರೇಟ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಂಡು ದಟ್ ವಾಸ್ ನಾಟ್
ಅವರಷ್ಟು ಅವ್ರಿಗೆ ಸೇಲ್ ಮಾಡ್ಕೊಟ್ರೆ ಆ ವಿಚಾರದಲ್ಲಿ ಹೇಳಿದ್ರಿ ನೀವು ಅಲ್ವಲ್ಲ. ನೀವು 29 ಟು ಕೋರ್ಟ್ ಮಾಡಿ ಅಗ್ರಿಮೆಂಟ್ ಬರ್ಕೊಟ್ಟಿದ್ರಲ್ಲ.
agreement is that it was not, the agreement is not accepted by the petitioner. That's why the main reason.
Signed the agreement, taken the money, how can you say it is not agreed? You should not have signed it. ಅವಾಗ ರೆಫರ್ ಮಾಡೋರು ಇನ್ನೂ ಕಮ್ಮಿ ಕೊಟ್ರು ಅವರು. ಇಲ್ಲಿ 3ನೇ ಒಂದು ಭಾಗ ಕೊಟ್ಟರು, ಆಮೇಲೆ ಇನ್ನು 10 ವರ್ಷ ಕೋರ್ಟ್ ಕಲಿಬೇಕಿತ್ತು. ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಅವಾಗ ಬಂದು ಕಾಸು ತಗೊಂಡ್ರಿ, ಇವಾಗ ತಿರುಗಿ ಆರ್ ಹ್ಯಾವಿಂಗ್ ಸೆಕೆಂಡ್ ಥಾಟ್ಸ್.
No, because even the agreed terms in annexary ಪ್ರಕಾರ at least they would have enhanced it because they have agreed after the.
That means they are changing the agreement again.
No, according to them, they agreed that look into the matter regarding enhancement of the compensation, because here the petitioner land was even during the year 2014, our year ಪ್ರಕಾರ 2015 your acquisition land. On the contrary, the acquisition of the serial number 24 is of 2018, and but value of the property is same. Even during 2014, both lands were having the same.
You have agreed, what can we do now that you agreed? 10 ರೂಪಾಯಿ ಕೊಡೋ ಕಡೆ 8 ರೂಪಾಯಿ ಕೊಟ್ರೆ ಸಾಕು ನನಗೆ ಅಂದ್ಬಿಟ್ಟು ಇವಾಗ ಇಲ್ಲ 10 ರೂಪಾಯಿ ಕೊಡ್ಬೇಕಿತ್ತು ಅಂತ after taking the money.
In fact, dispute is regarding the agreement matter. They ought to explain.
Where have you said anywhere that the agreement was entered into by fraud?
No,
ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ ನೀವು.
ಇಲ್ಲ.
ನೀವು ಕಾಸು ತಗೊಂಡು ಆಮೇಲೆ ಗೊತ್ತಾಗಿದೆ ಕಮ್ಮಿ ಆಗೋಯ್ತು ನನಗೆ ಇನ್ನೂ ಜಾಸ್ತಿ ಬರ್ಬೋದಿತ್ತು ಅಂತ.
ಹೇಳಿದೆ ಸರ್.
ಇಲ್ಲ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ.
ಇದು ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಪೊಸಿಷನ್ ಆಲ್ಸೋ ಚಾಲೆಂಜ್ ಬಂದಿದೆ. ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ದಟ್ ಆಫ್ ಕೋರ್ಸ್ ಬಿಕಾಸ್ ಆಫ್ ದಿ ರಿಜೆನ್ಸ್ ಇಟ್ ವಾಸ್ ಅಕ್ವರ್ಡ್. But the thing is only the taking the advantage of the innocent person. The agreement.
Nobody is innocent. So
ಪರಮೋಟ ಯಾಕಂದ್ರೆ ನೋಡಿ ಸರ್, ಏನ್ರಿ ತಮ್ಮ ಪ್ರಜೆಯಲ್ಲಿ ತಗೊಂಡಿದ್ದಾರೆ, the agreement was kindly taken. Annexure J1 matter. Annexure J1, page number 45. This is the agreement dated 26. There are two agreements, two lands are there. 2 ಲ್ಯಾಂಡ್ಗಳಿದೆ, 22, 23. ಅದಕ್ಕೆ ಈ agreement. ಈ agreement, whether this agreement is valid, that is to be looked into it, because only on a paper of rupees 100 or 200, they have taken the 100 rupees paperly, this agreement is taken. Whether this agreement is valid, that is to be considered.
So go to the civil court, then seek for a declaration. I can't in the writ petition decide that this agreement was fraudulent or otherwise. ಈ ಅಗ್ರಿಮೆಂಟ್ ಹೋಯ್ತು ಅಂದ್ರೆ ನೀವು ತುಂಬಾ ಕಮ್ಮಿ ಕೊಡ್ತಾರೆ, ಆಮೇಲೆ ನೀವು ತಿರ್ಗಾ 18 ರೆಫರೆನ್ಸ್ ಅದು 10 ವರ್ಷ ಆಗುತ್ತೆ, ಅದಕ್ಕೆ ನೀವು ಸುಮ್ಮನೆ ತಗೊಂಡಿರೋದು. ಈಗ ಒಂದು ಚಾನ್ಸ್ ನೋಡೋಣ ಅಂತ ಬಂದಿದ್ರೆ ಅಷ್ಟೇ.
ಇಲ್ಲ, ಹಂಗೇನಿಲ್ಲ ಸರ್. Otherwise there was no occasion for me to. Then option may be given to challenge this.
Draw the writ petition, then go. I will not give the option.
No,
for you.
Agitating civil court observation.
Not consider the petitioner seeks permission to withdraw a writ petition and submits that he would approach the civil court for redressal of his grievances. So, in view of the said submission, the petition dismissed as withdrawn. For the respondent. My lords, in this matter, my lords, they have asked for a writ of mandamus, my lords, to execute the sale deed.
Okay, for the petition. My lords, I've sought a mandamus for execution of sale deed, my lord. The agreement is of the year 2007. The 10-year period of non-eligible.
There's some settlement or something.
Yes, my lords, they have agreed to execute the sale
In
deed.
accordance with law, my lords, we will. Yav sale, yavaga? My lords, in a period of 8 weeks' time may be granted, my lords. The prayer in the state petition is for issuance of a direction to the respondent to execute a sale deed. Yav site bage in respect of? Is there a site number
Yes, my lords. It's scheduled property, my lords, writ petition scheduled property.
in respect of?
Site number 249.
249. Arkavati layout 5th block. Situate in cell number 58 of KNR and Pola village, measuring 15 into 24 meters. When counsel for the petitioner submits that the BDA has agreed to execute a sale deed. And this submission of the petitioner is also accepted by the Lord counsel for the respondent. So in view of the above, the petition is disposed of, directing the BDA to execute a sale deed for the petitioner within a period of? In accordance with law. In accordance with law, under, my lords, whatever, within a period of 8 weeks, my lord. 8 weeks in date of reserve copy.
Much okay.
Speaking of password, I'm led by a senior advocate. He is held up in court hall 29.
Next week, a lot.
In matter,
Supreme Court matter is pending. Our notice put is 20 possession certificate.
We have challenged the possession certificate issued.
already there.
Non-file ಮಾಡಿದೀವಿ, judgments are filed by both of us. The acquiring authority and the beneficiary, both of us are filed.
Next week.
For 6th, 7th round of litigation, it's my lords.
He wants a pass, he wants a passover. Passover.
Next week,
DPM have to go to commercial. court.
Relist.
Second.
Office objection is in only respect to KIDB copy serve madilla anta ಇದೆ sir. Copy serve ಮಾಡ್ತೀವಿ.
The petition's father name differs with the verifying affidavit.
That is complete. Kindly 1 week time.
In matter, no?
Award na challenge ಮಾಡಿರೋದು sir.
BDA to take notice for respond number 1. Shri Vinod Gowda take notice for respondents 2 and 3, relist on so and so, by which time office objection to be complied with.
Bless.
May please.
Respondent, my lords.
May please your honor. Last date of hearing, your lordship, there was a 29/11/2023, the order was passed for payment of arrears of rent. For recalling the reason, my lord, last date of hearing, what has happened, the petitioner was present and he was asked for the deposit the rent. Actually, so because he only was present, so court was ordered to pass an order within 4 weeks, arrears of rent to be deposited. Because why the recall application is filed, my lord, actually, see, within the 30 days it was filed. The reason is in the judgment page number 70, it is observed. As per the evidence and as per the, they have not sought
This
for the
order was
rent.
made- this
They are
order
not
was-
sought for the rent and arrears of rent is also not ordered.
Was made by consent.
No, my lord.
No, no.
No. Actually, what is happened is, in the judgment itself, I'll just produce, page number 17, my lord, of this petition. The trial court has said that the petitioner himself has not sought for the arrears of rent.
The
Because
petitioner-
of that, he is not passed orders, my lord.
Is the petitioner saying that he did not make the statement?
But he was present and the court was passed an order because the reason is.
The court has recorded, the petitioner is present and admits that he has not paid the rent from the date the suit has been filed with the trial court.
Please, he might be admitted, but my request submission is herein. The judgment in the trial court is now, it is specifically mentioned in the para 17, wherein the petition plaintiff himself is not supposed.
Before the very judge who passed this order, will know better than.
My one more thing is here is
Let
what.
come up before that very judge who passed the order.
I can understand, my lord.
But
Yeah, he was very much present before the court. I don't know. On
he is
consultation
either-
order-
and moreover,
Now
my
he
request
comes
submission is,
it is a
either what
different
is
version.
happened is regarding arrears of rent is concerned, writ petition is filed wherein it is stayed
You
in
cannot
another
argue-
proceedings.
You cannot argue on the merits after having suffered an order.
Please.
How can you argue on the merits saying that this order ought not have been passed? I'm not sitting in appeal over this order.
Please.
Either you comply with the order or you face the consequence.
Because of my submission is because already the same against arrears of rent is concerned, writ petition is stayed by the other proceedings.
If you want to press this IA, I'll post it before the judge who passed the order.
It may be because it may be posted before the same judge. It may.
Post before the learned judge who has passed the order on 29/11/2023.
Next week, madam, today increments.
ಇದು ಎಷ್ಟು ದಿನ rate ಅಂತ?
Copy not served, my lord. My lord.
Released on. You will not argue, I'll. simply-
next week. Office. Petitioner policy, madam. Office. Petition for the government.
Okay, for the petitioner, my lord. I filed this application for amendment of the prayer, my lord, to include a mandamus as a certiorari to quash the acquisition proceeding insofar as the land.
The records,
My lord,
there was an order to produce the records.
that's, records were not directed to be produced on the last date, my lord. No, my lords, this, photographs to show that, already land has been allotted to the beneficiary. Look, what has transpired is his relief, what he had sought is only not to construct, not to form the layout.
No, I'm sorry. Let her read the prayer properly.
May, ki-
Every time this is the,
my lords, may kindly see the prayer, what he has sought.
not
My
to
objection
proceed with the acquisition without the,
My objection was filed in 2013, wherein I have raised this objection that he has not challenged the preliminary and the final
different.
notification.
Matter argument ಆಗಿತ್ತಲ್ಲ ಒಂದ್ಸಲ ಇದು.
just preamble ಕೇಳಿದ್ರಿ ಅಷ್ಟೇ. And then records produce ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರಿ. Then my lord, you lordship directed me to produce the copy of the registered sale deed.
Please, my lord.
You're saying it has been acquired?
Yes, my lord's possession
No,
is
no.
taken.
No.
Entire compensation has been deposited before the trial court and beneficiary has been allotted. All of them have has put up construction in that area. my lord.
I am sorry, my lord. Lordship may kindly appoint a
Maybe
commissioner today.
Please wait,
My
please,
cause.
let her finish, let her finish.
Please, my lords. My
Where
lords,
is the record of acquisition?
my lords,
Where is the 28/1 and 28/4?
please, my lords. My lords, we have produced the final notification. They have only produced the final
no.
notification. And my lords, the final notification, my lords will get it at page. Objections. Additional objections that we have filed on 28/3/2023, my lords.
Lord, before that, may I submit few facts, my lord, not to appreciate the case. Few facts.
My lords, let me complete, my lords. I will complete the whole thing.
Yeah.
In the final, in the petition itself, he has produced. That is what he has produced. He has produced his preliminary notification. My lords, the preliminary notification, my lords will get it in his petition at page 21.
Page?
Page 20 of his petition, my lords, is the preliminary
I'm
notification.
sorry, that is final notification.
No, they don't.
Please read the annexure, my lord, that is annexure C, in page
28
20.
My lords, it's 28/1 notification,
Yes.
page 21 of his petition.
It's a final notification. Dated 5/12/2006.
28/4.
28/4, my lords. Yes, my lords.
Serial number?
My lord, serial number 175. page number 27. Lord, here there is a mention, survey number 159. Last you got it, my lord? There, my lord, the names that have been mentioned. My lord, extent of the land is 16 acres, they have shown 16 acres and 15 guntas, my lord. The names of the portion only in respect of 7 acres and 38 guntas has been shown, not in respect of 8 acres. This 8 acres was purchased by my great grandfather in year 1965. Your lordship wanted me to produce the Lord,
So
sale deed.
15 acres, 8 gunta, 16 acres, 15 guntas is notified.
Please, my lord.
That has been notified. In fact, 1965, I have purchased from out of this 15 acres, 8 acres. The other 7 acres, 38 guntas was purchased by some other person, against which, my lord, for number 7 before filed before the land tribunal. And that matter, those in respect of 7 acres, 38 guntas, for number 7 was filed and before the land tribunal, my lord, the tenants were agitating the matter. Now, lordship may kindly see, without showing the names in respect of 8 acres, they have shown only the names of the tenants who are in respect of 7 acres and 8
Do not challenge the declaration then.
Then what?
Should you not challenge the declaration saying that it is illegal, I have not been heard in the matter?
That is what I have said, my lord.
That is not the prayer in your writ petition.
Yes, my lord, this is what I have
There
said.
should have been to quash this notification of 2006.
That is
That it is illegal.
Yeah, yes, my lord. That is because without notice, no notice.
Where is the prayer?
Now I have sought for amendment of that prayer, my lord. That is the IF posted before your lordship today. Last occasion, my land print took an objection saying
My
that
lord, this
I have
objection
not
I have
sought for.
taken in 2013, my lords. May kindly see my objection filed in 2013. At para 8, I have raised a specific objections that writ is not maintainable for this prayer. My
In
lords,
fact,
kindly see my objection which I had filed it on 26, 2013, my lords.
Lord,
I have raised the specific objections. He has filed a rejoinder also to that objections.
You preliminary notification ಮಾಡ್ಬೇಕಿದ್ ನೀವು ಬರೀ ಇದ್ ಮಾತ್ರ ಮಾಡಿದ್ದೀರಾ?
ಯಾವ್ದು?
28 ಒಂದು ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕಲ್ವ? ಬರೀ 28(4) ಮಾಡಿದ್ರೆ 28 1 ಉಳ್ಕೊಳ್ಳುತ್ತೆ.
This is final notification, my lord.
You should also challenge the preliminary one, it's also, isn't it?
Preliminary notification has culminated into final. I have taken a contention that neither in the preliminary notification nor in the final
No, the
notification.
application.
My lords, LAC is pending where he is also party.
I'm
All
sorry,
these
no.
petitioners,
Allow the application, he is entitled to.
my lords, for the reason this, my lords, he is before the LAC court. He has filed objections there.
I'm sorry.
My lords may,
I'm sorry.
my lords may kindly see the LAC proceedings where he is also party. My lords, for the benefit, I have prepared one chart that
He not challenge the acquisition.
he has not challenged. He is appearing.
He not challenge it by way of an amendment.
Please,
Can
my
he
lord,
not challenge it?
at this stage, my lords, is it permissible when I have raised a specific objection in 2013?
Alright. It will be dismissed if it's belated, but why can't he challenge it? How can you prevent from
My
challenging?
lords, he can challenge it, but it at this belated stage, when I had sensitized him that it is not right, this prayer, my lords may kindly peruse my objections, 26, 2013. Wherein I have categorically stated, it is humbly submitted that the petitioner have not challenged, questioned the acquisition, notification issued by the state government, wherein the land in question, that is survey number 159, has been acquired long back.
No,
And
the fact remains that he was not notified.
my lords, my case is he has been, whoever's name is mentioned in the revenue records, I have produced a revenue record.
Suppose he's able to establish that he was the owner and his name should have been in the revenue records.
Please, my
That's-
lord.
That is my case.
In that is why, my lords, he has his LAC proceedings, he is impleted. He is one of the party which is initiated in 2014 itself. From 2014, he is before the LAC court to justify that he is the owner, my lords. May kindly see the LAC proceeding. 2014 onwards, it's going on. It has gone to the High Court also for enhancement. So therefore,
Did he seek for compensation then?
yes, my lords, may kindly see the,
I'm sorry, my
my
lord.
lords, may kindly see, I may be permitted to show
No,
that.
if you
my
have to
lords.
permit
What is
me.
the claim for compensation?
My lords, may kindly see the objections memo for documents that we have produced.
The objections, you not said that?
I have stated, my lords. I stated, my lords, may from the.
Where is the document to show that he had made a claim for compensation?
Yes, my lords.
Since there is only similarity of names in respect of tenants and so far as the owners, my lord,
My
now
lords,
they
with
want to take
father's name
advantage.
It is mentioned with father's name. We can, that is the reason, give me that.
In fact, they're in their own objection, not they have produced the document.
Because I have,
to show.
because of the name discrepancies, my lords, I have prepared a chart to that effect.
Yeah, put it in. Give me the-
My lords, may kindly peruse page 14 of memo for production which was filed on 21/7/2013. 23.
ನಿಮ್ಮ ಹೆಸರೇನು?
My lord, that's the reason I wanted to. Last occasion, my lord, I have produced.
The
One second,
petitioner
one
names.
second. I will answer the court.
Sir.
Lashmi, I have produced the order of the land tribunal, my lord. There the claimants' names are also shown. Who had filed for number 7. Now, Lashmi, kindly see, my lord, I have specifically stated who are the names. The persons, my lord, the names whom it appears. Lashmi, kindly take, my lord, may I request your lordship to kindly see.
ಇವ್ರು ಕೊಟ್ರ ಮೆಮೋ ಪ್ರಕಾರ
Ah,
second petition's name was shown in the notification.
second petitioner's name is not, that's the reason.
Son of Ningegoda.
My lord, that's the reason I am request your lordship kindly see. If I have given, I can give you the chronological names of the persons who are the tenants and who are the landowners. Since there is a similarity between the two, she wants to take advantage. In fact,
ಅಲ್ಲ ನೋಟಿಫಿಕೇಶನ್ ಅಣ್ಣಯ್ಯ ಬಿ ನಿಂಗೇಗೌಡ ಅಂತಾನೆ ಇದೆ.
ಅದು tenant Swami. Lashmi, kindly take the,
ಇನ್ನೊಬ್ಬ ಅಣ್ಣಯ್ಯ ನಿಂಗೆ
ಹೌದು Swami. I have produced the land tribunal order. There the same person has been shown. How can owner be shown as the tenant, my lord, before the land tribunal?
allow the application.
Then Lashmi, here in detail, my lord, I'll search.
My lords, one,
Suppose what he says is right.
yes, my
And
lord.
there are two Annayas.
Please, my lords. Please,
Both
my
of them are sons of Ningegoda.
please, my
And
lord.
if you have notified one person and notified this person,
Please, my
he
lord.
may have a ground to challenge the acquisition.
Please, my lords. My lords, I can show that there is no difficulty. to-
I'll allow the application, then I'll hear the matter.
Please, my lords.
The application. from
My lords, one small discrepancy that I will just show it. My lords, may kindly see for a moment that objections that we have filed on 24/3/2023. In that, we have produced the judgment of this honorable court where he had challenged the LSC order before the honorable high court.
24.
And LSC proceeding also I have produced LSC order.
Which objections?
My lords, objections that we have filed on 25th of March, 2023.
There's one 28th of March.
Thank
And
you.
11th.
Yes, my lord, that is the document. My lords, may kindly come to page 16 of that document.
Is the same Annaya according to you?
Same Annaya, my
No,
lord.
no.
And this Shivalinga
That-
Gowda,
that-
my
He
lord.
is saying this.
That is
Akshara-
not,
My lord,
that is where my lord, my
LR
land friend is trying to.
My lords, LRs of Shivalinga Gowda, whose name is there in the final notification. Their LRs also are there. And this Annaya Ninja Gowda's son of age also matches, my lords. Age cannot be identical for both the parties.
Let him establish latest.
My lords, only thing,
I will
application
establish.
may be allowed subject to he should not take advantage of this delay of challenging.
Application for amendment is allowed since it seeks to challenge the declaration. So it is over made clear that the allowing of the application should not be construed as condoning the delay, if any, in filing the petition. You want to file objections or sufficient?
We have filed objections, my lord. To the amendment, we have filed, application for amendment, we have filed objections.
Relist on date could hear.
Lord, may I request you, Lordship, I'll permit me to amend the petition right now.
ಅದು 4-5 ಪ್ಯಾರಾಗ್ರಾಫ್ ಸೇರಿಸ್ಬೇಕು, ಜಾಗ ಸಾಕಾಗಲ್ಲ.
ಅಲ್ಲ, ಒಂದೇ ಪ್ಯಾರಾಸ್. Mandamus.
ಅದೇನೋ ಫ್ಯಾಕ್ಟ್ಸ್ ಗ್ರೌಂಡ್ಸ್ ಎಲ್ಲ ಹಾಕಿದ್ರೆ.
Facts accounts ಅಲ್ಲಿ practically I have challenged it, but prayer ಮಾತ್ರ ಇಲ್ಲ.
Petition be amended. Release for hearing on.
No,
That's first.
any day.
Difficulty, my lord.
Any day convenient to my land friend, man.
My lords may kindly consider having it on 15th.
Whichever date you want.
15th.
R1 for state, my lord.
The description of land, then.
I am not the contesting respondent. In this matter, I have been wrongly made as a party. I am not the necessary party, respondent number 2.
The description of land.
With regard to name of the parties are not mentioned in the notification, that was under.
Name alla.
Notification ಅಲ್ಲಿ notification our name mentioned, but petitioner's name mentioned.
ನೀವು ಯಾರಿಗೆ?
Now, National Authority, respondent number 2 is not pertain to NHAI.
Where is that council who argued the other day? Prasad, huh?
I am for P. Prasad. My lord. We filed an application for getting a senior also argued on the same. So we need some clarification regarding the measurements and.
I granted time on 2 occasions.
Yes, my lord. No, you got this sketch. You got the sketch only given a copy only. They were not given any certified copies, anything. So we need a clarification regarding measurement and survey sketch, my lord. That's why the engineers are on election
What's the
duty.
notification? Because you cannot keep the sketch in Bangalore and ask people from Changiri to come and see the sketch to know whether their property is acquired or not.
Regarding the measurement, that there is some confusion, my lord. That's why. Need some instruction from the
government
engineer, sir.
Let's see, my lord, para number 4 of the statement of objections, my lord. Government side filed, my lord. The respondent submit that inquiry was conducted in Taluk office.
No, the argument that he advanced was in the notification. Yavalli madam adu? Which village was that? Valalkere. Next year, cake bunny pay 71.
Papers taken that council, my lord, not yet returned that entire paper. ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ ನಿಮ್ಗೆ ಇವರು.
I'll allow this because.
Kindly have it tomorrow, my lord. Kindly have it tomorrow, my lord. I will argue, my lord. Posted and tomorrow.
Tomorrow.
They ಕೊಟ್ಟಿಲ್ಲ, ನಮ್ ತಂದು ಕೊಡ್ರಿ.
ನಾಳೆ ಬಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲಿಲ್ಲ disposed of tomorrow.
ತಂದು ಕೊಡಿ. ತಂದು ಕೊಡಿ.
This is regarding 2 acres 9 guntas was proposed to be acquired. Out of which 13 guntas has not been, no layout has been formed and it has been abandoned insofar as the 13 guntas is concerned. For which I am ready to pay 40% of the guidance value of it, the tomb. A tomb and the constructed houses are there.
No such provision, Lord, under the BDA Act.
What is it reconveyance scheme that you collect 40% or 60%?
No, Lord, reconveyance scheme is stopped, Lord.
What is it? Give that copy to me.
That is, they themselves have produced in Junjamam, Lord, it was there for the site owners. Not
No,
for,
but for 40 years, if you have not taken possession there.
Lord, we had taken possession, we had allotted to him. Now before, after coming here, Lord,
Also say he doesn't want it.
he doesn't want.
Then
Your
at
Lord.
least you collect the market value and be done with it. What is the point in you keeping this land?
Please.
Give me that resolution. I'll take that as the source.
My lord, even the award has been deposited of rupees 1,71,000 in 2006, though the acquisition is of the year 1982. And that amount has not been received by him. Rashmi, kindly see along with the application at page 27, my lord, they themselves admit, my lord, no layout has been found. Page 27, along with the application I have filed for production of the documents. Page 27, my lord. They admit, my lord, no layout has been found.
Page number 108 tane sketch ada. Prepared by the BDA, correct? Murgesh? Page 108.
108, yes.
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 Rashmi, kindly see one more document, my lord, the BDA document at page 27, along with my application. Application 27. Page 27, along with my application for production of documents.
Yes.
ಯಾವುದೇ ತಂಟೆ ತಕರಾರುಗಳಿದ್ದಲ್ಲಿ ಅನಧಿಕೃತ ಶೆಡ್ಗಳಿದ್ದಲ್ಲಿ ನಾವೇ ಮೆಲಡ್ ಹಿಯರ್ ಮೆಲಡ್ ಬಲ್ಕ್ ಅಲಾಟ್ಮೆಂಟ್ ವಾಸ್ ಮೇಡ್ ಇನ್ ಫೇವರ್ ಆಫ್ ದಿ ಫೋರ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ದೇರಿ ಮೆಲಡ್ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ 132ರ ಭೂಭಾಗದಲ್ಲಿ ಬಡಾವಣೆ ರಚಿಸಿರುವುದಿಲ್ಲ. ಇದನ್ನು ಸದರಿ ಅರ್ಜಿದಾರರಿಗೆ ಹಂಚಿಕೆ ಮಾಡಬಹುದಾದ ಬಗ್ಗೆ ಮೆಲಡ್ ದೇ ಕೇಮ್ ಫಾರ್ವರ್ಡ್ ಮೆಲಡ್ ದಟ್ ನಾವೇ ವೀಕ್ ಮಾಡ್ತೀವಿ ಎಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. When they themselves admit ಮೆಲಡ್ that they have not formed the layout in this land in question, then ಮೆಲಡ್ it is abandoned. 82 notification. It is while allotting in bulk allotment in favor of the land loser.
This is a sketch you admit, isn't it? Page 108.
Yes, that's a sketch which has been admitted. But the fact that, my lord, they should also admit the very same sketch, saying that I have already found a road. Everything is there, my lord, insofar as only 15 guntas of the lands in 2 bits of pieces. Lordship may kindly see the sketch only.
13 guntas.
So 13 guntas.
For this, the 2 bits of land,
That too on 2 separate sides of the road.
it is 13.29 guntas. How much do you want that in that reconveyance? How much is the,
Lord, reconveyance, Lord,
what is the amount that you charge?
Lord, reconveyance, 40% was charged for the sites, Lord, not for the land.
For this, how much should that
For,
be?
there is no question of reconveyance of a land, Lord. It's a reconveyance of a site only.
No, but in such a situation, what will you do?
Lord, and those circumstances, you
You
all.
allowed them to stay there for 40 years now.
Yes.
Now you want to demolish them and
Lord,
has to collect
they're all dilapidated houses, Lord. There is absolutely, he himself is also not staying.
fact that you admit that you're not utilized for 40 years.
Yes. Lord, it was not utilized.
Want to take advantage of the
No,
rise in
we are not,
price.
we are not trying to take an advantage. Lord, here what has happened is, we have already formed a layout. Only 2 bits of us, sites are left out on the adjacent
That
side.
is the heartburn, isn't it? Because you allowed these two to remain without taking possession.
No, we had taken, the entire land possession is taken. They have come thereafter.
In one
My-
breath, you say you've taken
Lord,
possession.
at one hand, they.
ಸ್ಮಶಾನ ಇದು ತಗೊಳಕ್ ಆಗೋದಿಲ್ಲ ಅವ್ರಿಗೆ.
ಸ್ಮಶಾನ ಅಂತಂದ್ರೆ ಅವ್ರು-
ಸ್ಮಶಾನ ಇದು ಸ್ಮಶಾನ ನನಗೆ ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡಿ.
ನೀವ್ ಆರಾಮಾಗಿ ಮಾಡಿ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಹೋಗಿ ಮಾಡಿ, ನೀವ್ ಅವ್ರ ರಿಟಲ್ ನೀವ್ ರಿಲೀಫ್ ಕೇಳ್ಬೇಡಿ.
He's
ಇದೇನು
supporting
ಸ್ಮಶಾನ ಅಂತಂತಂದ್ರೆ, ಹೌ ಡು ದೇ ಹ್ಯಾವ್ ಆಲ್ಸೋ ಯುಟಿಲೈಸ್, ನಾಟ್ ಮೈ ರೆಸ್ಪೆಕ್ಟ್ಫುಲ್ ಸಬ್ಮಿಷನ್ ಇಸ್ ಯುಟಿಲೈಸೇಷನ್ ಆಫ್ ಅ ಲ್ಯಾಂಡ್, not it is not good for them also. Lordship may kindly see that they say that their own ancestors' tomb is there, but that is left out. Not one structure where 6 people were on a rental basis, which is a part of the records in an earlier writ petition itself. They say that some tenants were there in the house and they refused to sign on the master. That bit of land is allotted to the respondent. Now he doesn't want it, that he'll have to work out his remedy elsewhere.
2 bit land allot ಮಾಡಿದ್ರು ಅವ್ರಿಗೆ.
ಅದು ಆ ಕಡೆ
2 bits.
ಆ ಕಡೆ ಸ್ವಲ್ಪ ಏರಿಯಾ, ಈ ಕಡೆ ಸ್ವಲ್ಪ ಏರಿಯಾ ಅವರಿಗೆ ಅಲಾಟ್ಮೆಂಟ್. Because he had lost the land, he came and said, "Lord, I want a developed site, we have given." The entire stretch is developed.
How much did you allot him for? ಅವ್ರಿಗೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದು allotment ಗೆ?
Price.
ಹಾ.
Price, Lord,
ಎಷ್ಟು ಕೊಟ್ರಿ ಅವ್ರಿಗೆ?
ಅವ್ರೇನು ಪ್ರೈಸ್ ಇದ್ ಮಾಡಿಲ್ಲ.
My land in Kotnur has been utilized by the authority. Hence I was allotted this land.
And where have you said that you don't want the land?
I have, in the last occasion, my right has been confirmed by this Andhra court. My
ಈ ಜಮೀನ್ ಬೇಡ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದಾರೆ ಇಲ್ಲಿ?
I have stated in my statement of objection. My statement of objections is in 153 page.
ಯಾವತ್ತು ಫೈಲ್ ಮಾಡಿದ್ರಿ? When did you file this?
In page number, my lord,
ಯಾವತ್ತು ಫೈಲ್ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ ಇದು ಅರ್ಲಿಯರ್ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದೇನೆ.
Earlier, there was a writ petition was filed by the respondents, where I was also party.
Where is that?
In fact, that writ petition came to be withdrawn by them on the ground that there is no section, but 27 has not been into section 27 ಅಲ್ಲಿ ಇದ್ ಮಾಡಿರಲಿಲ್ಲ ಅದು.
ಅಲ್ಲ, ನನಗೆ for me to act upon ನಿಮ್ಮ affidavit ಏನಾದ್ರು ಇದ್ರೆ saying that you don't want to stand because
page
there are
150
tombs there.
Page 150 is my lord.
Oh, page 150, my
53.
153.
It was filed in earlier writ petition, which was withdrawn by me.
Page 153. In last para 7, my 158, it is
Page
submitted that
158.
it is submitted that since the land allotted to this respondent is in dispute or in litigation and in view of the
No, file an
report and
affidavit,
sketch prepared
file an
by,
affidavit that there are tombs there and you don't want the land.
please,
Therefore, I'll pass an order.
please, I will.
Because there's nothing here. 60%, ಅದಿರೋದು? Guidance value?
40%. But site land, here it becomes a land.
Make it 60% then. 60%. File the affidavit.
Please,
When do you want it?
tomorrow.
Petitioner, last occasion, my lord, I was pleased to ask about the plaint pleadings regarding the date of disposition.
What is the order that you're challenging?
Right? My lord, I have mentioned in the plaint. I am furnishing the plaint copy. In the plaint itself, there are 20 my lords.
ಇಲ್ಲ, ಯಾವ order challenge ಮಾಡ್ತಾರೆ ನೀವು?
I have challenged the judgment passed by the honorable trial court dismissing the suit filed by me. Appeal memo, page number 34, my lord. OS number 297 of 2018.
Section 6 ಕೆಳಗಡೆ.
A suit under section 6 of the specific relief act.
Where is the plaint?
My lord, a plaint commencing in page number 18, my lords, please, after order sheet. My lord, the defendants are Kamalamba and Gauramma, my lords, please. My lord, the particular regarding the details of disposition concerned timings, my lord, para 20, page 31, my lords. It is submitted that in fact the plaintiff is residing both at Osarli village in the residential house owned by him. So also for the convenience of his children and aged mother, he is also having a residential house at JP Nagara, Bangalore. And he visits JP Nagara quite often and residing at Osarli in the house owned by him.
ಎಲ್ಲಿ ಓದ್ತಿದ್ದೀರಾ paragraph?
Swami, paragraph 20, Swami, page number 31. He was away from the house of Osarli and residing in JP Nagara for his ailment, mother treatment for 10 to 15 days. 10th line and lady. Then in page 20, 32, para 21, my lord, he lodges complaint on 29/12/2017. And then on a two.
What is their written statement? Do they admit this disposition?
My lord, they have not appeared before the honorable trial court as well as before this honorable court in spite of service of summons, my lord.
Then why did the trial court dismiss the suit?
My lord, the honorable court may kindly reduce the judgment of the honorable trial court. My lord, there are 12, my lords. Page 43 to the appeal memo. May I read my notes, please?
Civil record. Item. Feasibility. Specifically. This revision is by challenging an order passed by the trial court by which the suit filed by the petitioner was dismissed. The petitioner instituted a suit under section 5 and 6 of the Specifically Act, read with section 26 of the CPC, seeking for the following relief. Page number 39. It was the case of the petitioner that, taking advantage of his absence, the defendants had illegally trespassed upon the property and they demolished half a portion of the house standing therein. The relevant plea in this regard is reproduced as follows. Page 20, paragraph 20 and 21, page 31, 32. A reading of the said plaint government would indicate that the petitioner complained that he was dispossessed without taking recourse to a procedure known to law. Police complaint
Police complaint is given also.
29.
On 29/12/2017.
Where is it? Which
It is in para 21 of the plaint. Even it is marked also at exhibit P56.
As could also be seen from the above, the petitioner also lodged a complaint with the police on 29/12/2017,
Exhibit P56.
2/2/2018, complaining of the trespass and encroachment made by the defendants. The complaint and the acknowledgement have also been produced. Next, despite service of summons, the defendants chose to remain absent and were placed ex parte. Next, the trial court thereafter has proceeded to assess the evidence produced by the petitioner and has come to the conclusion that the exclusive position of the plaintiff was not proved and he had only acquired 2 quintals of land. The trial court has also stated that the suit was only for an injunction and the only question before it was as to whether the plaintiff was in possession and enjoyment of the suitable property as on the date of the filing of the suit. The very preamble to the plaint indicates that the suit had been filed under section 6 of the Specific Relief Act. And this fact has been completely ignored by the trial court and it has proceeded on the footing that the suit was only for an injunction. It is no doubt true that the prayer sought for was in the nature of a mandatory injunction to remove the illegal structure that had been put up after the petitioner was dispossessed. This does not by itself would translate the suit to be one for injunction. Next, section 6 of the specific fact categorically states that if a person claims to be illegally dispossessed, he would be entitled to be restitution of his possession. And in such a proceeding, the question of title should not be gone into. In this view of the matter, the approach of the trial court to determine the title of the plaintiff and thereafter come to the conclusion that he had no title and he had not proved his possession cannot be sustained. It is also to be noticed here that the assertion of the plaintiff that he had been illegally dispossessed, bracketed as extracted above, was not denied at all and was not contested by the defendant, since the defendant had chosen to remain ex parte. So in this view of the matter, the averment of the plaintiffs that they had been illegally dispossessed was deemed to have been admitted, and the trial court ought to have therefore decreed the suit, reserving liberty to the defendants thereafter to approach an appropriate court of law to establish the right, title, and interest over the property. In my view, since the entire approach of the trial court that the suit was only for an injunction and hence was required to be dismissed cannot be accepted. Consequently, the impugned order is set aside and the suit of the plaintiff is decreed, since it is not in dispute that the plaintiff was in possession and he had been illegally dispossessed.
AF for rejection of plaint, my lord, is dismissed by impugned order.
What is the suit for?
Suit for partition, my lord, filed by the female members of the family, my lord.
Where is the plaint?
Please, in OS number 1275.
Where is the plaint?
Plaint, it is.
May I make on submission, my lord? May I make on submission before the, my lord? Lord, I did not receive the entire papers either from the petitioner or from a counterpart. Because for the last 1.5 months, I met with an accident, I could not come out to the court. I need some time, suppose if your lordship decide the matter on merits.
Next week, relist. It's a 2021 matter, so don't ask for time again.
Illa. 2nd April. Then ಇನ್ನೊಂದು ಪಾಡ. Papers ಏನು ಇಲ್ಲ. Paper appeal memo ಮಾತ್ರ. Matter relating to reverse possession.
Application for rejection of plaint was dismissed. Last time also, my lord, they didn't come. And they've never come.
I'll pass it over once.
I think, yes, I will. But otherwise your lordship may admit it in, because without admission, they may then say that they were not heard.
But post for hearing.
If they have interim order, you ask for an interim order.
It was
Stay.
not granted earlier, shall continue.
Petition of
Granted. Your lordship is granted interim order.
Interim order granted for the first time or?
No, not granted. Interim order.
But interim stay, that's all for. Post for hearing.
My lord, in this case, I appear for petition, my lord.
Yes.
Rejection of plaint, I have filed application, my lord.
Plaint elle? Where's the plaint?
Plaint, my lord. Page number 68, my lord.
68.
68.
In suit for?
Suit for declaration of gifted as a illegal, my lord, on the basis of it is against the public policy immoral. That is the ground urged in the plaint, my lord. Earlier, my lord, there was another suit was filed by the same person, the plaintiff's father himself, my lord. This is the facts of the case, my lord. The plaintiff's father himself, my lord, has.
Who had executed the gift deed?
Pardon, sir?
Who had executed the gift deed?
Gift deed on 16/10/2012 gift deed was. The father of the plaintiff in favor of his second wife, my lord. The first wife children have challenged this gift deed after death of that father.
My lord, I appear for the respondents in this, my lord. I'm the
Yes.
plaintiff for the court below, my lord. My suit has been stayed. Today I have a personal inconvenience, my lord. I had moved this since my suit has been stayed. Today there's a personal inconvenience if I can have, it can be had tomorrow, my lord.
My lord. Next week, my lord, please.
Realist.
Okay. Interim order may be continued.
Remote to continue with them.
2nd April, my lord, if it can be had on 2nd.
2nd April.
2nd, grateful.
Much.
Yes, I'm appearing for the respondent.
My lords, proxy counsel, my lords, senior is held up in another court anytime next week, my lords.
Next week.
Realist.
Yeah, date, kindly date maybe.
The lots. Lord, we are producing the Lord, the depositions and Lord, the exhibits.
Where were you last time?
Last time I have not issued the Millard cast Millard.
Yes.
My name is not correctly mentioned. KAL, KHAL. Correct. Therefore, I have not issued any message from this court.
Yes. Ready now?
Yes, Millard.
Yes.
The lordships wanted to see the depositions, my lord. Please come this side.
Settlement deed. Settlement
Deed, my lord. In fact, my lord, the lordship will see, my lord, that the appellant before your lordship, my lord, petitioner before your lordship, my lord, he was 10 years old at that point of time. The my lord, the brother also, the plaintiff was also, my lord, younger than him. And they are saying that by this settlement deed, there was a partition between the brothers, my lord. And if your lordship sees the settlement deed, my lord,
we produce a plaint here.
Lord, the plaint is not produced, my lord. Plaint is not produced. My lord, in law, my lord, even if your lordship considers this as a gift, my lord.
1 minute, let me go through this.
Your Lordship, permit me to show the relevant cross-examination. Page 13, para 2, my lord. First line.
Yes.
ಪ್ರತಿವಾದಿ ನನ್ನ ಬಳಿಗೆ ಬಾಡಿಗೆದಾರರು ತೋರಿಸಲು ದಾಖಲೆ ಇರುವುದಿಲ್ಲ. Now your Lordship will see regarding the settlement.
Where is the quit notice that was produced?
Yes. Lord, it's at page 67, my lord.
Page?
67. Statutory notice under 106 of the Transfer of Property Act.
The reply ಕೊಟ್ರಾ?
ಇಲ್ಲ, ಕೊಟ್ಟಿಲ್ಲ.
No reply was given.
No,
Very well.
instead of replying the notice, my lord, they directly filed a suit against the plaintiff suit for partition.
Correct.
ಇದು sixth section.
What is the effect of you not giving a reply to the quit notice?
Lord, the point is, my lord, now,
No, what is the effect of you not giving a reply to the?
Lord, if there is no relationship of landlord and tenant, my lord, then this notice itself has absolutely no meaning in law, my lord. Lord, there is no, my lord, their brothers living in a joint family.
Can't it be considered as an admission to the averments made in the?
Lord, it cannot be considered as an evidence, my lord.
It can't be.
Lord,
considered
because
as-
I have specifically stated, my lord, that I am not a, my lord, tenant.
What is the effect of not giving a reply?
Lord, if your lordships would say, my lord, that it would amount to admission, my lord, then that would be a difficult situation, my lord, because there are several cases where, my lord, the legal notices are either served or they're managed not to serve.
You don't dispute the fact that quit notice was served on you.
Lord, it was served, my lord. We are in the same family, it's in the same house, my lord.
Took up the plea that you are not the
Lord,
tenant.
therefore, my lord, I filed immediately a suit, my lord, asking for partition of the properties, and there, my lord,
If you succeed there, you will get possession.
no, my lord, I am in possession, settled possession in the family.
You first hand over possession. In the event
Lord.
you succeed, you will get possession again.
Lord, I am living in two rooms in a joint family property, my lord, in the, my lord, in a family property where I've been living since childhood, my lord.
That is to be established. They have a registered document in their favor.
No, my lord, I
You don't
show
give-
from the document, my lord, there is nothing in law, my lord, called settlement deed, my lord. Settlement, my lord.
There
He
is
is not
some
the joint owner, my lord, the property was purchased by the father.
Your suit will not be determined here.
Correct,
You
my
filed
lord.
a separate suit.
Lord, in fact, my lord, I have shown to your lordship, my lord, that the small cause court, my lord, had no jurisdiction, my lord. Section 8, I have read, Article 4 of the schedule I have read. my
Get
lord.
jurisdiction because you did not give a reply to the quit notice. There is a deemed admission that you accepted the allegation that you are a tenant.
Lord, I have immediately thereafter, my lord, within a few days after this, I filed the suit, my lord. If your lordships are going to say, my lord, that I have, my lord, admitted the contents of the notice, my
For the
lord.
purpose of this suit, I'll say I'll review reserve liberty for you to urge all the contents
No,
available.
no,
to
that
you in
liberty is always there with me, my lord. In fact, mine is the first suit. This suit ought to have been stayed. This is the second suit, my lord.
Should have done that.
My lord, what they could have done, my lord, is a different issue. But, my lord, in law, my lord, your lordship is holding the settlement deed against me, my lord.
No,
Now, kindly see.
I am holding the non-issuance of a reply against you.
My lord, if there is no relationship, my lord, this is a statutory notice under section 106 of the Transfer of Property Act, my lord. For that to apply, my lord, there should be a relationship of landlord and tenant, my lord. Now, they have completely failed, my lord. The finding is in my favor that there is no, my lord, proof of tenancy. There is no proof of payment of rent, my lord. And just because they have issued a notice, and my lord, if that is to be held against me, my lord, that I am, my lord, I am admitting the tenancy. I am not admitting the tenancy, my lord.
Not denying it.
I am denying it, my lord. Kindly see, my lord, I have.
Not in the written statement.
No, in the written.
Purpose of issuing a quit notice, it's statutory nature.
Lord,
It
since
says
he claimed to be a landlord, my lord, since he claimed to be my own brother, he suddenly claims to be a landlord. Therefore, my lord, I filed the suit for partition, my lord. Lord, they may not have been properly advised, my lord, but that should not come in the way, my lord. I am in settled possession, my lord, since my childhood. I am living in this house since 1981. Father purchases in 1981, my lord. They say that in the 1981 itself there is a partition. In that partition,
not going to that at all.
Lord, then your lordship will have to hold that he is a landlord.
The purpose of this suit, because of the fact that you did not issue a reply, I'll hold that he is the landlord. We'll reserve liberty to you to get possession in that suit for partition that you have filed.
No, my lord, kindly see, my lord. But my lord, that will be inequitable for this reason.
If it's admitted that you're a tenant for the purpose of this suit, that will not take away your right.
No, my lord, I am not admitting at all, and there is a finding in my favor.
Then if it is admitted.
Kindly see the finding, my lord. Kindly see the finding, my lord. At para 13, my lord.
ನಿಮ್ಗೇನ್ ಕಾಸು ಬೇಕಾ ಖಾಲಿ ಮಾಡೋದಕ್ಕೆ ಏನ್ ಬೇಕು?
No, my lord, I am, my lord, sir, family, my lord, they are living in, I am occupying 2 rooms in the entire property. 5 by 10 and 15 by 10, my lord. Lord, it is a dispute between brothers. It is a dispute between brothers. And there's very clearly there, even the, my lord, the plaintiff's own witness says that since childhood we have been living in this house, my lord. They are living together. And today, my lord, one claims to be a landlord on the basis of a settlement deed. The settlement deed, my lord, if your lordship is going to hold that, my lord, as a, no, I am not saying that your lordship are going to hold whether it is proved or not. But the point is, my lord, if your lordship at least prima facie see it, my lord, that document cannot, my lord, be considered as a gift, my lord. It is not in terms of section 123.
I cannot make any observation regarding that because that is not the subject matter of this particular proceeding.
Yes, my lord.
That you are interpreting the document in one way, he's interpreting another way. That you will adjudicate in that original suit. As far as this suit is concerned, it's only 2 rooms. You give up these 2 rooms. In the event you succeed, you'll get a major portion of the property as your share. Why are you feeling shy?
No, but Lord, to be, Lord, removed from a family house, my lord, is something, my lord, which.
If it was a family house, if he's.
It is, my lord. I'll show the admissions.
If his argument is accepted, then it can't be his family house if it's his property.
So, my lord, your lordship is then going back to the settlement deed where he's saying it is.
Hypothetical basis, since you said it is family property, that is the reply.
Yes, my lord. They admit that, my lord, the father has purchased it in 1981. They say, my lord, within a few days after he purchased it, my father settled it on me. And he did not give any property to the elder brother because the elder brother says that, no, I want only the business, my lord. He is 10 years old, my lord. It is admitted. Your lordship saw that, my lord, at page 15. The elder brother is 10 years old. Why he asked for only the business when he was 10 years old, my lord? My lord, it's an entire story is cooked up, my lord. And my lord, even the document is not in terms of section 123 of the Transfer of Property Act. It cannot, my lord, confer title on him. That's all I can say. Lord, your lordship may at least then give me some time, Lord, to vacate.
Time.
30 days time, 1 month time.
Lord, it's a residence, my lord. I'm living there in 2 houses, my lord, 2 rooms.
Rupees rent, my lord, he has not paid since the date of yours.
No, you have not proved that I have paid even a single rupee rent any time.
Court, my lord, observed with regard to the tenant, my lord, and he has not paid the rent, my lord.
If you want a larger time, you'll have to withdraw the revision, file an undertaking.
No, my lord, I cannot, I don't have instruction to withdraw the. Your lordship may give me some time, lord, some reasonable time.
This is a revision filed challenging the order passed with the trial court by which a decree of ejectment has been passed against the petitioner. These facts are not in dispute. The petitioner is the elder brother, while the respondent is the younger brother. Next. The younger brother instituted a suit seeking for, the younger brother issued a quit notice calling upon his elder brother to quit and deliver vacant possession of the suit property, which are 2 rooms situated in the property bearing municipal number 13. In the quit notice, the younger brother contended that these 2 rooms, which were in the possession of the petitioner, constitute a portion of the property which had been settled in his favor by his father under registered settlement deed dated. Yeah. What is the date of this?
1 month.
9/7/1981, my lord.
9?
9/7/1981.
And notwithstanding the settlement in his favor, he had permitted the elder brother to stay in the premises, subject to him paying a monthly rent of rupees 10,000. To this quit notice, the elder brother did not issue any reply. On the other hand, he proceeded to institute a suit seeking for partition in OS number
471.
OS number 474/2021, which is stated to be pending consideration.
But on 6/1/2021, I filed it.
On appearance, the elder brother took up the contention that he was not a tenant and there was no due relationship between him and his younger brother. He contended that the property was a family property and therefore the court did not have jurisdiction to entertain the suit for possession. Next, the trial court, on consideration of the evidence, has come to the conclusion that the younger brother had proved that he was the landlord of the suit property and that he had legally terminated the tenancy in favor of that he had created in favor of his elder brother, and that he was entitled for a decree of ejectment. It is accordingly decreed the suit and directed the elder brother to vacate and hand over vacant possession within 2 months. Being aggrieved, the present revision is filed. Learned counsel appearing for the petitioner vehemently contended that the elder brother had taken up the specific stand that the property was the family property and there was no tenancy between the brothers. He also highlighted the fact that the trial court had recorded a finding that there was no evidence to indicate the payment of rents, and it was also an admitted fact that there were no documents evidencing the payment of rent, and therefore the trial court would not have entertained the suit, which was basically a suit for possession, as it was beyond the jurisdiction of the small causes court. Next, learned counsel appearing for the younger brother on the other hand contended that the elder brother chose not to give any reply to the quit notice, and therefore this amounted to a deemed admission of the tenancy. He submitted that even if this did not amount to a deemed admission of the tenancy, it did admit of the fact that the tenancy was not denied. He submitted that the subsequent suit, he submitted the suit filed thereafter for partition would have no relevance for the present suit in view of the fact that the tenancy was not denied on the issuance of a quit notice. He also submitted that in the event the elder brother were to succeed in the suit for partition filed by him, he would get possession in accordance with law under the decree, and he could not resist the suit for ejectment. Next, brother. The trial court has come to the conclusion that the tenancy had been proved, and it has also come to the conclusion that the younger brother was the landlord and has proceeded to grant a decree. Next, brother. In my view, this decree granted by the trial court does not deserve any interference in the section 18 of the Small Causes Court Act. It is to be borne in mind that in a proceeding for ejectment, the principal question which are determined as to whether the defendant was a tenant and whether the tenancy was determined. In the present case, it is not in dispute that the quit notice alleging that the elder brother was in possession of the property as a tenant was served on him, and yet he did not choose to give any reply. The non-giving of a reply essentially establishes the fact that the tenancy as asserted by the younger brother was not denied by the elder brother, and the issuance of the quit notice determines the tenancy and thereby entitles the younger brother to file a suit for possession. So in my view, since these two facts have been established, the decree for ejectment cannot be gone into. I find no reason to entertain this revision. The revision is therefore dismissed. It is however made clear that the dismissal of this revision would not in any way be construed as rendering an opinion on the merits of the claim of the elder brother regarding his entitlement of the property in the suit that he has instituted seeking for partition. Next, brother. 3 months' time is granted to the petitioner to quit and deliver vacant possession of the premises.
My name is correctly
Huh?
KHA. My name is correctly mentioned.
Obliged. Petitioner, my lord.
I request your lordship to
In
continue
this
to the
petition,
speak, madam.
is challenging the dismissal of the application, suit for partition, my lord. That is surprising. Even kindly see the plaint government's document number 2.
You are the which defendant?
I am for the 8th defendant. I am the purchaser.
When was the sale made?
The property was purchased by the 3rd defendant, Gaurama, who is the wife of the 2nd defendant. Kindly plaint government page number 22, relationship. The Shivraju and Venkatesh are the brothers.
Who is D1?
D1 is the mother of the defendant number 1 and 2. The property was purchased in the.
Neevu Shivraj alva?
I am for the 8th defendant.
Plaintiff is Shivraj.
Yes, my lord.
He is son of Bhairappa.
Yes.
So first defendant is the mother.
Yes.
Second defendant is the brother.
Brother.
Who's the
Third defendant is wife of the 2nd defendant.
So that is the sister-in-law.
Sister-in-law. The property was purchased by her in year 2005. And thereafter in 2012, that was exchanged with the 4th defendant, Veeranna.
Who's Veeranna?
That is, he was the owner of the survey number 61/1. And there was an exchange deed between the Gaurama and the 4th defendant.
Gaurama's property
was given to the 4th defendant. Now the subject matter is only the property which was given to the Veeranna. That is only the targeting, and it is bogus litigation, because after even the Gaurama received the property
from the Veeranna under exchange it.
They admit that the property was exchanged in favor of Veeranna in the plaint.
Ah, yes,
Where have they said that?
in the para number 5, my lord. Thereafter, the plaintiff made inquiry with regard to the document pertaining to the scheduled property, and then he came. Now they are saying that whatever the property received by the Gauramma from the Veeranna.
Can you seek for partition respect of a sister-in-law property?
My lord, it was purchased out of the joint family property. That's the reason, my lord, in the first instance, I asked for time because
The NR section 14 ಬರುತ್ತಲ್ವಾ ಅವ್ರದ್ದು?
I will make out.
Especially that how is it that you can ask for?
In fact, that's the reason I did not have the complete papers. That's the reason, in the first instance, I asked for time. Your lordship, I kindly have it next week. I'll secure all the papers.
Lordship, because the injunction order is operating against me.
7 rule when application is rejected.
Next week.
First week.
Lord, defendant's application, defendant number 18 before the trial court, application for rejection of plaint.
Suit for?
Suit for declaration and partition. Consequential relief is partition. The sale deed in my favor is, my lord, sought to be.
Plaint? Where is the
Plaint is at page number, my lord, 81.
81?
Yes. But kindly see, at the relevant paragraph is page number 92,
You are which defendant?
18th defendant.
18th.
Yes. Paragraph, page number 92 may be seen, my lord.
101.
My lord, 18 dependent, page number 84. 17 dependent is my vendor, Lakshmi Puri. My lord, I have purchased property in the year 2002.
When did the 17th defendant purchase the property?
He is purchased in the year 2002, man. My lord, that is dated. My lord, 10/10/2002.
Where do you get that?
Page number 65. Page number 65. Page number 65, the relevant schedule is, my lord, page number 874.
There shall be an interim stay of all further proceedings. Council is permitted to take out notice on the counsel who represents the plaintiffs before the trial court. ಬೇರೆಯವ್ರಿಗೆಲ್ಲ notice ಬೇಡ ಅಲ್ವಾ?
ಬೇಡ.
To the they could notice on the counsel who appears for the plaintiffs, that is respondents 1 to 4 before they with the counsel who appears before them for them in the trial court. Notice to respondents 5 to 26 is deferred for the present. Petitioner is however permitted to serve a copy on the counsel who appears for them in the trial court.
Please.
Statement. Petitioner. The last occasion, my lord, the BBMP was taken as the party. And during pendency of this writ petition, my lord, of operation of the interim order, the BDA has assigned the suit schedule property to the BBMP.
What is the prayer in the petition?
The land acquisition cancellation, my lord. There is no notice served or nothing is done. So I applied subsequently relating to.
1990 notification you're challenging now.
Yes, not now, immediate, there was no notice served. And my land is there and it is taken as the government land and so notification was made, my lord. This one, my lord, the challenging
What was the acquisition for?
Acquisition for formation of the residential layout.
Now layout.
BTM 6 stage.
Huh?
BTM 6 stage.
Who was the notified khatedar?
BDA, my lord.
Notified khatedar ಯಾರಾಗಿದೆ?
Bank ಅಂತ ಖರಾಬ್. Sorry.
Where is the notification?
I produced, my lord.
It's government land, my lord. Government.
They are saying government land.
Where is the notification?
71, my lord.
Page?
71.
Serial number?
Serial number 185.
Kharab tank.
Kharab tank, it is the
Tank.
accurate tank.
Karab Tank, C. Narayan Reddy. Please. Deep book. How do you claim ownership of this property?
This was granted to me during 1966, my lord. The revenue records were also there, grant certificate is also produced, 1966-67. That is Annexure B, my lord. My humble submission, my lord,
As of the year 1990, where is the RTC?
I produced, my lord.
Where? 1990 RTC.
My lord. Annex page number 29 to
ಸರ್ಕಾರ ಅಂತಾನೆ ಇದೆ.
ಸರ್ಕಾರ 2000 ನಲ್ಲಿ ಸರ್.
ಅಲ್ಲ, ನಿಮ್ಮ ಹೆಸರೇನು?
ನಮ್ಮ ಹೆಸರು ಶ್ರೀಕಂಠ ಸ್ವಾಮಿ.
ನಿಮ್ಮ ಹೆಸರಲ್ಲಿದೆ.
That is my father, my lord. He died, my lord.
ಇಲ್ಲ, Annexure D. Annexure D1 is the first one ಅಲ್ವಾ?
ಹೌದು.
ಅದರಲ್ಲಿ
prior to that, my lord, I produced Annexure C series.
ಅಲ್ಲ, in the RTC was your name entered as of 1990?
No, my lord, much earlier to it also.
Because you are producing 8990. Only Narayan Reddy's name is shown. Where is your name? The RTC. If your name was not there in the RTC, that means the question of you being notified would not arise.
My lord, there is an order of grant and other things.
But how will they know if there's an order?
The
of grant?
1968, my lord, the first page number 29, my lord.
No, but under section 17, they're only expected to notify those persons in whose name the revenue records are standing, isn't it?
68, 69, my lord, there is a ink page number 29, my lord, RTC, showing the name of the father of this petitioner.
No, this is 93-94 afterwards. As on the date of, what is the date of the 71 notification?
That's not 71.
18 ನಲ್ಲಿ ಹೆಸರಿದೆ ತೋರಿಸಿ. 18 ನಲ್ಲಿ 89ರಲ್ಲಿ.
ಇದೆ ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದು ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 32, 75, 76, 77, 78, 79, 33 ink typed copy. Then page number 33, my lord. 32 is the typed copy and 31 is the RTC.
18 ನಲ್ಲಿ ಇತ್ತ ನಿಮ್ಮ ಹೆಸರು, ನಿಮ್ಮ ತಂದೆ ಹೆಸರು?
ಹೌದು ಹೌದು ಹೌದು.
ಎಲ್ಲಿದೆ ತೋರಿಸಿ?
That is ink page number 37, my lord.
ಯಾವ ಇಯರ್ ಅಂತ ಆಗ್ತಾ ಇಲ್ಲ ಅದರಲ್ಲಿ.
ಹೌದು ಹೌದು. But it is there continuously till 2002, my lord. I produced the RTC from 1967.
Was his name in the records?
Objections have been filed, my lord, pointing out survey number 34, which is the subject matter in question. The subject matter, lords, it is the tank. It is Arkere Lake, my lords. It is the lake itself. In fact, my lords, along with the statement of objections which has been filed, my lords, the village map also has been produced. It is the lake. Survey number 34, Annexure R1 ನಲ್ಲಿ
ಯಾರು ಅವ್ರದ ಅಬ್ಜೆಕ್ಷನ್ಸ್?
BDA the objections ಇದೆ.
ಯಾವತ್ತು ಹಾಕಿದ್ರಿ?
ಇದು my predecessor has filed, my lords. I do not have the date, I'm sorry. Once this is 2015, objections ಹಾಕಿದ್ದಾರೆ. 14th October 2015. And my lords, in 2010, my lords, this, since it is being a lake, my lords, BBMP hands it over to BDA. I produced the communication issued by BBMP.
That regard, my lord, I have to.
Lord, we kindly
amendment. The challenging that particular handovering of the food property to the BBMP. That
This
is
is
why I am
2010.
seeking time, my lord, to
10/6,
bring necessary
2010.
amendment by collecting that impugned order passed between the BDA and the BBMP, my lord.
Annexure R3, my lords.
I have already applied for that particular thing. The revenue documents are there. I paid this one, my lord, the relating to the grant. There is an order. Even they have challenged that particular grant under section 136 of Land Revenue Act, my lord. It was dismissed by this honorable court. That order. Set aside the order of the deputy commissioner.
If the
During
entries are made illegally, that has been set aside.
Yes, my lord. The relating to that particular aspect, they have challenged before the deputy commissioner, special deputy commissioner has passed the order, contending that it is a lake area. And the entries found in this particular name of this petitioner and
No, if
another
the-
one person.
If the deputy commissioner has found that the entries were illegal.
Yes, my lord.
And were
That
fraudulent
was
entries.
challenged before this honorable court and the writ petition was allowed. I will place that record.
Where is that order?
That I will place it, my lord.
Then what is this WP 414542?
Yes, probably that will be the order. I will place it.
Did you state that in the writ petition?
No, it was subsequent to my writ petition. It was.
No, this was in 2015.
Yes, my lord. Mine is 14. My lord.
Now, did you inform the court regarding the cancellation of the entries?
Yes, my lord.
Where is this copy? WP 4542?
I will place
I
it.
don't have notes. I'll get that notes. Objections were filed earlier.
Office to place the papers pertaining to WP 4542-43 of 2015. Relist on.
I have applied that particular alleged cancellation, assignment of the property, and I have to bring necessary.
Now, I'll get the writ petition file, then let us see.
First better for me. See, after 10th, my lord, because I am not available.
Day after tomorrow.
Please.
Yeah.
Respondent in this matter. Next week, may I kindly have it for next week.
Okay.
ಸ್ವಲ್ಪ ಪರ್ಸನಲ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದೆ ಇವತ್ತು. ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಒರಿಬೇಕಾದ್ರೆ ತಪ್ಪಾಗಿ ಹೊಲ್ದ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅದರಿಂದ ಈಗ ಚೆಕ್ ಮಾಡ್ತಾ
Second matter, here R4. Who's R4 in the second matter?
R4 is an authority. R4 is.
ಇಲ್ಲಿ ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರೆ?
ಇಲ್ಲಿ ಯಾರು ಬರ್ತಿಲ್ಲ.
CGSC.
ನಾವೇ ಅಪೇರ್ ಆಗ್ತಿದ್ವಿ ಅಲ್ಲಿ ಮಿಕ್ಕಿದ ಅವರು R4 ಗೆ.
I have put for the respondent number 3 and 4, my lord.
Central government ga?
Yes, my lord.
Person Vishwakumar to accept notice for respondent number 4 in WP 19069/2014. Release. Give him a copy.
Obliged.
Waiting for petition.
Petition. Government advocate has been directed to secure the records. We have communicated, my lord, we have not yet secured. A short accommodation may kindly be.
ಯಾವ್ದು ಆರ್ಡರ್ ಮಾಡಿದ್ ಮೇಡಮ್?
There, so was ordered on 22, my lord. In the year 22, but communication has gone from my office.
Released on so and so, by which time the records as directed by this court on 23/11/2023 shall be secured.
Senior is held up in next court, my lords. Kindly,
Petition is the.
senior is held up in next court, my lords. He is on legs.
Correspondence 7 to 10.
Kindly have it on 1st of April.
What is the matter about?
It's about passing of resolution. We have challenged the resolution in Annexure R, my lords.
What is Annexure P?
Annexure P is a government order which is passed in following Annexure Q. my lords.
Objections ಹಾಕಿದ್ರ ನೀವು?
ಇಲ್ಲ ಹಾಕ್ಬೇಕು.
Be list on so and so, by which time objection shall be filed by the respondents.
For 2 weeks. 1 week time.
ನೀವು ಯಾರಿಗೆ?
Petitioner.
Relist.
My lord, I am for the petitioner, my lord. I am engaged service of exchange counsel, my lord. Yamaraj Kopa held up some other court, my lord. Can you have this next week, my lord?
Simple matter.
Some other court, my lord.
Relist next week. ಅಲ್ಲ ಸುಮ್ಮನೆ ಟೈಮ್ ತಗೊಳ್ತಾ ಇದ್ದಾರೆ. The reason is
Sir,
a suit of
change
year
counsel held up some other court.
2004.
That's why at the advice of the change counsel.
Reserve ಮಾಡ್ಲಾ?
Next week, my lord.
CAP will stay there. Next matter. First time ನನ್ನ ಮುಂದೆ ಬಂದಿರೋದಲ್ವಾ ಇದು? Next time ನೋಡೋಣ. Date may be fixed.
The interim order can be extended, my lord.
Remote to continue the next date.
Please, my lord. The BDA council informed me that the officer is on election training for 2 days, Monday. Next 3rd or 4th of April, it will be posted. Please, my lord.
Petitioner. Yes, sir. My application for change of land use has been given an endorsement.
Where is he?
Through.
L and K na? Objections ಹಾಕಿದಾರಾ?
ಹಾಕಿದ್ದಾರೆ. In pursuance of the Supreme Court order, a circular has been issued. Based on a circular, they have said change of land use is not permissible. They have interpretation.
The Supreme Court?
The Supreme Court judgment, my lord, I have produced along with my writ petition at page number 78. The facts of the Supreme Court judgment, my lord, was that in survey number 30 of at page number 78.
Annexure K na?
Annexure L1.
Actually, the circular, my lord, issued by the state government, quoting the
Supreme
Supreme
Court order is at
observation.
ಇಲ್ಲ, what are you challenging Annexure K?
Yes, ma'am.
Challenge.
K-
Supreme
K-
Court judgment is at page number 78, based on which a circular was issued.
Please read annexure K first.
Annexure K, my lord. Relevant paragraph is second paragraph. ಪರಿಶೀಲಿಸಲಾಗಿ ಸಿವಿಲ್ ಅಪೀಲ್ ನಂಬರ್ 3600/2011 ಪ್ರಕರಣದಲ್ಲಿ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯವು 26/8/2009 ನೀಡಿರುವ ತೀರ್ಪಿನ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಹೊರಡಿಸಲಾದ ಉಲ್ಲೇಖ 2 ಸರ್ಕಾರದ ಸೊತ್ತುಲೆಯಲ್ಲಿ ಅನುಮೋದಿತ ಬಡಾವಣೆಯಲ್ಲಿ ನಿವೇಶನಗಳನ್ನು ಇತರ ಉದ್ದೇಶಕ್ಕೆ ಭೂ ಉಪಯೋಗ ಬದಲಾವಣೆ ಕೋರಿ ಸರ್ಕಾರಕ್ಕೆ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಬಾರದೆಂದು ಸೂಚಿಸಲಾಗಿದೆ. ಪ್ರಸ್ತಾವಿತ ನಿವೇಶನವು ಕರ್ನಾಟಕ ಗೃಹ ಮಂಡಳಿಯವರು ನಿರ್ಮಿಸಿರುವ ಯಲಹಂಕ ನ್ಯೂ ಟೌನ್ ನ ಬಡಾವಣೆಯಲ್ಲಿ ಕೈಗಾರಿಕಾ ನಿವೇಶನ ಆಗಿದ್ದು, ಉಲ್ಲೇಖ 2ರಂತೆ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆಯನ್ನು ಸದರಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಪರಿಗಣಿಸಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ ಎಂದು ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ. That circular is at page number 76, next page. May I read, madam?
This is only in respect of parks, playgrounds and
Civic communities.
other civic communities. How can you apply it to?
Generally, they have instructed in the appellate court, my lord, any kind of change of land cannot be considered.
Any change of land use with relation to this
Yes,
park?
ma'am. CA site and all, it cannot be considered. That is the observation made by, but the BDA has issued based on its circular saying
ನಿಮ್
that
ಸರ್ಕ್ಯುಲರ್ ಮೇಲೆ ಕೊಟ್ಟಿರೋದು.
ನಮ್ ಸರ್ಕ್ಯುಲರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು, they could have applied their mind.
ನೀವ್ ಅಪ್ಲೈ ಮಾಡಿದ್ರೆ ಅವ್ರು ಅಪ್ಲೈ ಮಾಡ್ತಾರೆ.
ನಾವು ಹೇಳಿದೀವಿ ಸ್ವಾಮಿ ಆತರ CA ಸೈಟ್ ಆ ತರದೆಲ್ಲ ಬಂದಾಗ ಕನ್ವರ್ಷನ್ ಕೊಡ್ಬೇಡಿ ಅಂತ ಹೇಳಿ. Because now they want it changed from the industrial to residential.
Residential.
That may not be permissible because BDA has to tell that aspect, whether it is feasible to convert it from industrial to residential.
ನೀವ್ ಹೇಳಿದ್ರಿ ನಾವು ಮಾಡಿದ್ವಿ.
CS rating ಮಾಡ್ಬೋದು ಅಂತ ಹೇಳುತ್ತೆ.
ಎಲ್ಲದಕ್ಕೂ ಇದೆ.
So you have to tell that industrial ಇಂದ residential ಗೆ convert ಮಾಡ್ಬೇಕು.
ಎಲ್ಲರೂ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇತ್ತು ಸೇರಿ.
ಚೇಂಜ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಯೂಸ್ ಮಾಡಬಾರದು ಅಂತ ಎಲ್ಲಿ ಇಲ್ಲ ಅಲ್ವಾ?
42 paragraph.
ಓದಿ. ಬರೀ ಪಾರ್ಕು ಪ್ಲೇ ಗ್ರೌಂಡ್ ಕಮ್ಯುನಿಟಿ ಅಷ್ಟೇ ಸೀಮಿತವಾಗಿದ್ದೀವಿ. ನೀವು ಎಲ್ಲದಕ್ಕೂ ಅಪ್ಲೈ ಮಾಡ್ಬಿಡ್ತೀರಾ?
ಇಲ್ಲ, ಇರೋದೇ ಅದು.
ಓದಿ. In that case, they had.
In the layout approved by the BDA, in the layout formed by BDA, in the layout approved by BDA of any other authority. Now here is a case, we have approved the layout found by KHB. It was reserved for an industrial purpose. I mean, I filed my statement of objections, paragraph number.
Your entire basis is the circular of the government, isn't it? Which is again based on the decision of the Supreme Court. Please read para 42.
We make it clear that henceforth, the planning development authorities in the state of Karnataka, including the BDA, shall not permit change of land use within the layout formed by the BDA, or the private layout formed under section 32 of the BDA, or the layout formed by any other authority contrary to the scheme sanctioned by the state government, or the layout plan approved by the competent authority. Full stop. The BDA or the other planning development authority shall not venture to alter the sanctioned scheme approved layout plan in any manner. The BDA and the other planning development authorities, Bharat City Municipal Corporation Bangalore, or any other authorities in the state of Karnataka authorized to sanction the plan for construction, the building shall not sanction any plan for construction contrary to the sanctioned approved layout plan. Full stop. The sites reserved for parks, playgrounds, or for providing any other amenities shall be used strictly for the purpose of which they were reserved. Be
So
it noted
this is
the
all-
violation of any of.
This is what they were concerned with. 3 categories. Not for the whole of the area. 3 categories you will not change. If it's a park or if it's a civic community, playground, you will see that it is given effect to. ನೀವು ಎಲ್ಲದಕ್ಕೂ ತೆಗೆದು
Kindly it may be-
The upper portion.
Alan,
it
kindly
appears
it
the
may be
language
read.
is just very positive in nature.
My-
Otherwise, the Supreme Court would not have said so.
The language is with reference to the last 3 lines.
Kindly permit me to read para number 39,
Para?
39 of the same judgment. It is also noted that here that the area reserved for civic community should not be diverted for any other purpose other than the purpose which was reserved in the sanction scheme. It is referring to that
I think
civic
it's being
community.
read out of context. ಇವಾಗ ಇಂಡಸ್ಟ್ರಿಯಿಂದ ರೆಸಿಡೆನ್ಶಿಯಲ್ ಮಾಡಕ್ಕೂ ಬೇಡ ಅಂತಂದ್ರೆ ಇಟ್ಸ್ ಗುಡ್ ಅಲ್ವಾ ಇಟ್ಸ್ ರೆಸಿಡೆನ್ಶಿಯಲ್.
Kindly see the below the statement map produced ಮಾಡಿ.
What was it originally reserved for?
Industrial purpose only.
It is fair. It is.
Paragraph number 3 of my statement of objections.
Next year R1 na?
ಅದಕ್ಕಿಂತ ಮೊದಲು the share of concerned. The fourth respondent formed township consisting, paragraph number 3 of my statement of objections. The fourth respondent formed township consisting of industrial, commercial and residential sites. In approved township, 39.33% of site is reserved for residential purpose, 1.63% for commercial purpose and 7.85 for industrial purpose. The said area earmarked for industrial use, the scheduled site was allotted in favor of so and so. So the percentage of reservation is this.
ಇಲ್ಲ ರೆಸಿಡೆನ್ಶಿಯಲ್ ಜಾಸ್ತಿ ಆದ್ರೆ ನಿಮ್ಗೆ ಯಾಕಲೆ ಖುಷಿ ಆಗ್ಬೇಕಲ್ವಾ?
ನಮ್ಗೇನ್ ಖುಷಿ ಇಲ್ಲ.
ಅಲ್ಲ, ದಟ್ ಇಸ್ ರೆಸಿಡೆನ್ಶಿಯಲ್ ಇಂದ ಕಮರ್ಷಿಯಲ್ ಮಾಡಿದಾಗ ತೊಂದರೆ ಆಗುತ್ತೆ. If it's for residential, how can you be aggrieved?
Entire area is already been, change of land use is permitted. Page number 96 ಅಲ್ಲಿ ನಾನು already ಬೇರೆಯವ್ರಿಗೆ ಅಕ್ಕಪಕ್ಕದವ್ರಿಗೆಲ್ಲ change of land
Larger
use
dimension
ಕೊಟ್ಟಿದ್ದಾರೆ.
site, larger dimension sites. Illi the apartments will come up. The sites which.
If it is permissible in a residential zone, then yes.
No, it is not under permissible. Now they are seeking for permission. Suppose if it is under a category of the master plan ಅಲ್ಲಿ zonal regulations ಪ್ರಕಾರ permissible limits ಅಲ್ಲಿ ಇದ್ರೆ there is no issue.
There was one amendment, isn't it, which said that no permission necessary if it's from industrial to come to residential. Only the reverse was necessary.
200 by 100 ಏನೋ ಸೈಟ್ 100 ಫ್ಲಾಟ್ ಕಟ್ಟಿದ್ರೆ 300 ಜನ ಬದುಕ್ತಾರೆ, 400 ಜನ ಬದುಕ್ತಾರೆ. ಇಬ್ರು ಬದುಕದ ಹೆಂಗೆ 400 ಜನ? What is the difference?
But ಇನ್ನೊಂದು coordinate bench has referred to this.
ಏನಂತ ಹೇಳಿದಾರೆ? ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳಿದಾರೆ.
Refer to this provision has not said that this is in a true spirit of what your lordships have said, it is applicable for last 3 lines.
Then the entire industrial area there in Rajanagar, nothing can be done now.
No,
All the apartments will have to be pulled down.
Henceforth, then, Supreme Court has said henceforth.
Residential is one of the uses permissible under the zone regulations alva.
ಹೌದು, ಆ permissible limits ಅಲ್ಲಿ ಬಂದ್ರೆ they should make an application under section 15 ಆಗುತ್ತೆ. 14 ಅಲ್ಲಿ change of land use ಕೇಳ್ತಾರೆ.
ಇಲ್ಲ, come to this regulation, industrial zone. Regulations, permissible land uses, one main land use category I3. Ancillary land use, residential, commercial 3, T2 and U4. So if residential use is permissible.
In an industrial layout.
So therefore, how can you refuse change of land use?
No, it should change of land use, only permissible limits, my lords, in zonal regulations.
Actually, change of land use is better, if this can be used for ancillary purposes. Change of land use is necessary when it is beyond the permissible use. This is one of the permissible uses. In an industrial area, if you can use this land for residential purpose also, then where is the question of change of land use?
ಅದು 10% ಇರುತ್ತೆ ಅಷ್ಟೇ. ಇವ್ರದ್ದು ನೋಡ್ಬೇಕು. ಇವಾಗ
10% ಅಂತ ಬರ್ದಿಲ್ಲ.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ I3 ಅಲ್ಲಿ ಪರ್ಸೆಂಟೇಜ್ ಹಾಕಿರ್ತಾರೆ.
ಎಷ್ಟು ಪರ್ಸೆಂಟೇಜ್ ಮಾತ್ರ ಪರ್ಮಿಸಿಬಲ್ ಲಿಮಿಟ್ಸ್
ತೋರಿಸಿ.
ಸೇಮ್ ಬುಕ್. Ancillary use allowable up to 10% of the total land area. Industrial category 1 general. Lordships have referred to that.
ತೋರಿಸಿ.
Ancillary use allowable up to 10% of the total land.
ಇಲ್ಲ ನಾನು ಇದ್ರದಲ್ಲಿ ಹೇಳ್ತಿರೋದು. ಇಂಡಸ್ಟ್ರಿಯಲ್ ಹೈಟೆಕ್ ಅಂಡ್ ಇದು ಯಾವ್ದು ಅಂತ ಕ್ಲಾಸಿಫೈ ಮಾಡಿದ್ರೆ ನೀವು?
ಹೈಟೆಕ್ ಅಲ್ಲ.
ಅಲ್ಲ, ಇಂಡಸ್ಟ್ರಿಯಲ್ 4 ಕ್ಯಾಟಗರಿ ಇದೆಯಲ್ಲ. ಇದು ಬರೀ 1, 2 ಮಾತ್ರ ತೋರಿಸಿದ್ರು.
Purple in the map, my lords, it's shown
ನೆಕ್ಸ್ಟ್
as-
ಒಂದು ಇಂಡಸ್ಟ್ರಿಯಲ್ ಹೈಟೆಕ್ 1H.
ಇಲ್ಲ ಬರೀ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಅಂತಿದೆ. Map which I produced as per annexure R1, my lords, the purple color.
Look at this, right side. There's no percentage prescribed there. What is the total extent here? ಎಷ್ಟು ನಿಮ್ಮ extent ಎಷ್ಟು?
Around 50,000 square feet will.
ಎಷ್ಟು?
50,310 square feet.
258 into 250.
1 ಎಕರೆ ಅಂದಾಜು.
ಒಂದೇ.
ಸುತ್ತಮುತ್ತ ಎಲ್ಲ ಕೊಟ್ಟಿದಾರ?
ಸುತ್ತಮುತ್ತ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ?
96 ಇವರ BDA ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾರಿಗೆ?
ಪಕ್ಕದ ಸೈಟ್ ನಂಬರ್ 19, ಪೇಜ್ ನಂಬರ್
One site
96.
ಮಾತ್ರ ಕಾಣುತ್ತೆ sir. ಇಲ್ಲಿ the map which I produced.
Annexure R1.
ಬಿಟ್ಟು
Residential zone ಇದು.
ಅವ್ರು ಹಾಕಿರೋ ಸೈಟ್ ಇದಕ್ಕೆ.
ಇಲ್ಲ, ಇವ್ರು ಕೊಟ್ಟಿರೋದು ಚೇಂಜ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಯಾವ್ದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ? ಯಾವ ಪ್ಲಾಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಅವ್ರು ಕೊಟ್ಟಿರೋ ಸ್ಕೆಚ್ ಅಲ್ಲಿ.
ಅವ್ರು ಕೊಟ್ಟು
Site number ಹೇಳ್ಬೇಕು.
But BDA would be welcome to move the industries away from, if they want to convert into residential purpose, you should have welcomed it all.
ಇಲ್ಲ ನಾವು ಇವ್ರನ್ನ ತೋರಿಸ್ತೀವಿ ಸ್ವಾಮಿ. What the government, based on government circular, we got it clarified. I produced annexure R2, my lords. We got it further clarification from the government with reference to the Supreme Court judgment.
R2. R2 is ಇನ್ನೊಂದು ಪ್ಲಾನ್ ಅಲ್ಲ.
Last annexure. R4.
ನಂದು ಅಡ್ಜಸೆಂಟ್ ಲ್ಯಾಂಡ್
ಸಂಬಂಧಿಸಿದಂತೆ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯವು ಸಿವಿಲ್ ಅಪೀಲ್ಸ್ ಪ್ರಕರಣಗಳಲ್ಲಿ 22 ನೋಡಿದ ತೀರ್ಪಿನಲ್ಲಿ ಅನುಮೋದಿತ ಯೋಜನೆ ಬಡಾವಣೆ ನಿರ್ದಿಷ್ಟ ಉದ್ದೇಶಕ್ಕೆ ಮೀಸಲಿಟ್ಟ ಭೂಮಿಯನ್ನು ಅನ್ಯತಾ ಉದ್ದೇಶಗಳಿಗೆ ಭೂ ಉಪಯೋಗ ಬದಲಾವಣೆಗೆ ಅನುಮತಿಸುವಂತಿಲ್ಲವೆಂದು ಸುತ್ತೋಲೆ ಈಗಾಗಲೇ ಕಟ್ಟುನಿಟ್ಟಾಗಿ ಪಾಲಿಸುವೆಂತು.
ಕರೆಕ್ಟ್, ಅದು ಪಾರ್ಕ್ ಸಿವಿಲ್ ಕಮ್ಯುನಿಟಿ ಸೈಟ್ಸ್ ಅದ್ರದ್ದು. ಎಲ್ಲದಕ್ಕೂ ನೀವು ಜನರಲ್ ಆಗಿ ಅದನ್ನ
ಇಲ್ಲ, that state should say, my lords, because by reading of that passage, my lords, in the upper portion which clearly says in a mandatory language, it is applicable for all.
Now, can you diverse the context of the entire judgment and say, pick out one sentence and ignore the remaining portion of the paragraph and say, then you will become crippled. You can't do anything.
ಅದರಲ್ಲಿ substantial portion with reference to that. Only last 3-4 lines which refers to CSI.
The entire case dealt with the usage of a civic community site, isn't it? In that particular case. In that context, they said, you will not allow it to be changed no matter what.
ಅದು ಒಬಿಟರ್ ಡಿಕ್ಟ್ ಅಂತ ಅನ್ಕೊಳಕ್ ಆಗಲ್ಲ ಸ್ವಾಮಿ. ಇಲ್ಲಿ ಪ್ಯಾರಾ 42 ಅನ್ನು ಓದಿದ್ರು. Suppose I also thought in that way, maybe it's a passing reference. Does not appear to be so.
as per their annexure 3, ನನ್ನ adjacent
What
land.
is your stand, madam?
Lord, because when going through the beginning paras of the para 42. it
counter
seems
ಹಾಕಿದ್ದಾರೆ.
that I have not yet filed.
File your counter
Yes.
and get correct instructions, because I don't think this is what the Supreme Court meant.
Because the
And there was
BDA
also an
said-
amendment to the KTCP Act which said that you don't require change of land use in respect of industrial to residential.
And the zonal regulations clearly says that, my lord, it is at the industrial area only. So we can't, because
No.
the sketch.
Earlier,
produced by
you
Madam-
had to seek for change of land use. But I think they made an exemption from industrial to residential. You don't have to seek, it's deemed to have been granted. Provided you pay that, make an application and pay that requisite amount, it is deemed to have been converted.
ಅಲ್ಲ, ಈ 14A ದಲ್ಲೇ ಪ್ರಾವಿಷನ್ ಇದೆ. ನಾವು in
14A ಬರೋದು, you have to make an application. ಅದ್ರಲ್ಲಿ, if I remember right, it only said, if you make an application, then there's deemed change of land use from industrial to residential. Reverse is not true. That was the intent.
Okay.
ಅದನ್ನ ಚೆಕ್ ಅಪ್ ಮಾಡಿ. I'll have it next week, by the time get ready.
10 days.
Relist.
ಫಸ್ಟ್ ಬರುತ್ತೆ. ಫಸ್ಟ್ ಬರುತ್ತೆ ಬೇರೆ. ಓಕೆ.
Number 57.
Yes.
That has been heard. It's also directed to BDA council to whether the site number 3184 is vacant or not. They have submitted the report saying that no, the still it is vacant. So that's the next one.
47 ಏನಿದೆ ಮುರುಗೇಶ್?
The engineers have sent a report stating that the site is vacant, eligible for allotment.
ಕೊಡ್ಬೋದ ಅದನ್ನ?
But ಅದನ್ನ ಕೊಡ್ಬೋದು ಅಂತಂದ್ರೆ he has to complete certain other formalities, blood of the BDA of the payment of the value. And my lord, he has to file an affidavit as per Junjama's case that as on today, he has not been allotted any site in the
Pick it up at 2:30.
lodge. Sometime little later, 3:30, 2:30 some.
Come at 4:30.
Please, oblige.
Serial number 46, my lord.
Yes.
This matter pertains to NHAI, my lord, where they have taken possession of the petitioner's land without acquisition. Lord, I heard it last week and directed that the matter may be placed.
But I appear for NHAI, my lord, in that matter. But what has happened is they say the excess land has been acquired, my lord, and they have also produced a DLR report, I believe. Yeah.
Not acquired, but without acquisition.
Without,
they're using
they
our land.
allege that it has been acquired without following the due process of law, my lord. But however, my lord, in response to that report, my lord, we have written a letter to.
Your lordship, SLO has written, the concerned SLO has written the letter to the ADLR, seeking some clarification from that report. Because the end points and the recommendations have been not clear on that, your lordship. That letter has been written.
We're waiting for a response from the ADLR, my lord.
You first take land and then you decide whether the lands are yours
And
or
it's a
not.
joint
So
survey,
what
my lord,
happens
which was
is-
done with them. ADLR and the NHI do a survey, prepare a report saying 11 guntas.
4:30. 4:30.
Please.
Continue ಆಗುತ್ತಾ? List continue ಆಗುತ್ತಾ?
ಬೆಂಚ್ ಆಫೀಸ್ 48 ಇದೆಯಲ್ಲ ಒಂದು ಚೂರು ಫೈಲ್ ನೋಡ್ಬೇಕಾದ್ರೆ ಸೀರಿಯಲ್ ನಂಬರ್ 48 ಚೂರು ಫೈಲ್ ನೋಡ್ಬೇಕಾಯ್ತು ದಯವಿಟ್ಟು ಒಂದೇ ಒಂದು ನಿಮಿಷ.
ಸರ್ ಧಾರವಾಡ ಬೆಂಚ್ ಇದೆಯಾ ಸರ್ 2:30ಗೆ?
Sir, Dharwad bench.
48 ಸರ್.
ಹೌದು ಸರ್.
ಇವೆಲ್ಲ ಅರ್ಜೆಂಟ್ ಆಗುತ್ತಾ? ಡೇಟ್ ಕೊಟ್ಬಿಡಿ.
Sir, 49 on date. 49 on date.
Yeah. ಇದು ಲೆಕ್ಚರ್ ಸೀನ್ ಅಲ್ಲ.
Final
Election
meeting
B.
members attend ಆಗ್ತಾವ. But take ಮಾಡ್ಬೇಕು. Final meeting members.
ಸರ್ ನೋಡಿ. ಸರ್ ಸರಿ, ಯಾವ ಡೇಟ್ ಕೊಡ್ತೀರಾ? ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ದಿಸ್ ಥಿಂಗ್, ಏಪ್ರಿಲ್.
ಅದು ಸೀರಿಯಸ್ ಇತ್ತಲ್ಲ, ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ 18th ಲಿಸ್ಟ್ ಆಗಿತ್ತು. ಅವಾಗ ಸಾಹೇಬ್ರು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದ್ರೆ ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ರು. ಸೊ ನಾನು ಒಂದು ಬಂಚ್ ಪೇಪರ್ಸ್ ಹಂಗೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೆ, ಅದು ರಿಟರ್ನ್ ಬರ್ಲಿಲ್ಲ. ಆ ಫೈಲಲ್ಲೇ ಇರ್ಬೇಕದು. ಹಾ 32 ಅದು ಡಿಸ್ಪೋಸ್ ಆಗೋಯ್ತು. ಹೌದಾ, ಅದನ್ನ ಎಲ್ಲಿ ಸರ್? ಬಿಕಾಸ್ ಅದು ಲಾಸ್ಟ್ ವೀಕ್ ಕೊಡ್ತೀವಿ, ಅದ್ರಲ್ಲಿ ಇದೆ ಇಲ್ವ ಅಂತ ನೋಡಿರುವಲ್ಲ. ಅದು ಹೋದ್ರೆ ಹೋಗೇ ಬಿಡುತ್ತೆ. Because vote record ಅಂತ ಅನ್ಕೊಂಡು ಅದ್ ಇವತ್ತು ಹಾಕಿದ್ದು. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಒಂದು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಒಂದು ಓದಕ್ ತಗೊಂಡಿದ್ರು ಸಾಹೇಬ್ರು. ಇಲ್ಲ ಅದಿಲ್ಲ, ಅದು ನಿಮ್ಗೆ ಸಿಂಪಲ್ ಪೇಪರ್ಸ್ ಇದಾವೆ. ಹಾ ಅದು ಹೌದು. ಹಾ ಇದು ಲಾಸ್ಟ್ ಟೈಮ್ ಸಾಹೇಬ್ರು ಓದಕ್ ಕೊಡಿ ಅಂತ ತಗೊಂಡಿದ್ರು. ಅದು ಡಿಸ್ಪೋಸ್ ಆಗೋಯ್ತಲ್ಲ ಅದು. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಹಲೋ ಸರ್, ಧಾರವಾಡ ಬೆಂಚ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್, ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರಾ?
ಸರ್, ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಒಂದ್ ನಿಮಿಷ ನೋಡ್ತೀನಿ. ಇನ್ನ ಬಂದಿಲ್ಲ ಸರ್ ಅವರು.
ಬಂದ್ರೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಸರ್.
ಮಾಡ್ತೀನಿ ಸರ್.
ಇದೊಂದು ಸಮಸ್ಯೆ.
My lords, also. Secondly, serial number 11, my lord. My senior son wedding, my lord. Functions are starting.
Number?
Serial number 11, my lord, second list. I'm for the petitioner.
List.
My lords, kindly, my lord, serial number 6, my lord. 5 weeks time, my lord, as of now, today I'm not keeping well, my lord. Serial number 6, I'm for the petitioner, my lord.
2013.
Please, my lord, I'm not keeping well today, my lord. Next week, next Monday, my lord.
All right.
Please, my lord.
Dharwad bench matters, serial number 1, Shri Ram P. Gorpade.
Lordship, may I make a suggestion that the matter may come tomorrow, Lordship. Since I'm not feeling well, Lordship, the matter take tomorrow, Lordship.
1st April.
Relist.
Yes.
For further consideration, serial number 2, Shri Deshpande.
My lord, time for the petition, my lord.
Yes.
Your Lord, appeal for respondent, your Lordship. Day after tomorrow, your Lordship. Wednesday, your Lordship.
When?
Day after tomorrow, your Lordship. Wednesday.
Day after tomorrow?
Yes, your
My
Lordship.
lords, my lords, the matter may be reserved, my lords. It has been heard for at length, my lords. They are seeking time again and again, my lords.
Give one more opportunity. Let us see what you will do. Wednesday.
My lords, I pray before this honorable court to reserve the matter for judgment, my lords.
Right. Wednesday.
Grateful, my lords. My lords, interim order may be extended, my lords.
Yes.
Grateful, my lords.
Serial number 20. Serial number 38.
My lords. Another password, my lords. Another password.
In the morning of.
I have hearing matters. I can't wait. ಏನ್ matter?
My lord, it is an acquisition of the land in favor of the housing board. My name, my lord, though I was a Khatedar, as per MR, during 2006 itself, my lord, my name was mutated at Annex A, my lord. In respect of the land bearing around 39 bar P2, 1, another 39 bar P2, annexure, next document, my lord.
39 bar P2.
Yes, my lord. P1 and P2. P2, then my lord.
P1 ಏನಿದೆ?
ಅಲ್ಲ ಒಂದು ಎಕರೆ.
P2.
Yes, my lord.
1 acre 32 guntras.
Yes, my lord. Another extent, my lord, 39 bar 5 at page 17. MR 55 2005.
Page?
6. 17, page 17.
17.
MR number 55 2005 2006 on the basis of the sale deed. It is in respect of 39 bar 5. Now the notification, my lord, has been issued to acquire the land in serial number 39. Code has not been mentioned. My name has also not been shown at all. At page 26, my lord.
Acquisition for?
Housing board. Page 26, my lord. Respect of the land bearing serial number 39. Donnenahalli.
Page?
26, my lord. Ink page 26.
Twenty-six.
26.
Next.
Annexure B, my lord.
Serial number ಎಷ್ಟು?
702.
ಸರ್ಕಾರಿ ಬೀಡು ವೆಂಕಟೇಶ್.
My name has not been shown. Even in the final notification, it has also not been shown. Now, last may kindly come to annexure D, my lord. Their contention, my lord, it has not been coded in the statement of objection, and but my lord, at page 30, annexure D, they say.
Next.
D, my lord. It was issued on 11/1/2019.
Page number ಎಷ್ಟು?
Page 32, my lord.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಬೆಂಗಳೂರು ಜಿಲ್ಲೆ, ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು, ತಾವರೆಕೆರೆ ಹೋಬಳಿ, ದೊಣ್ಣೇನಹಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 39ರಲ್ಲಿ 1 ಎಕರೆ 32 ಗುಂಟೆ ಭೂ ಸ್ವಾಧೀನ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಐತೀರ್ಪು ರಚಿಸಲಾಗಿದ್ದು, ಉಲ್ಲೇಖ ಪತ್ರದನ್ವಯ ಭೂ ಸ್ವಾಧೀನ ಕಾಯ್ದೆ ಕಲಂ 12(2) ನೋಟಿಸ್ ಅನ್ನು ಹೊರಡಿಸಿದ್ದು, ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿ ಪರಿಹಾರವನ್ನು ಪಡೆಯಲು ಸೂಚಿಸಲಾಗಿರುತ್ತದೆ. ಆದರೆ ನೀವು ಇದುವರೆಗೂ
Name was not notified. How can you issue a notice to them under 12(2)?
My lords, when we acquired the property, my lords, at that time, the name of the respondent was, the petitioner was not shown. Later on.
No, but the revenue notice indicate his name was there, isn't it?
ದೇ ಅಡ್ಮಿಟ್ ಇನ್ ದಿಸ್ annexure did they admit ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರದಲ್ಲಿ ಅಲ್ಲೇ ಒಪ್ಕೊಳ್ತಾರೆ ಅವರು. ಅದಕ್ಕೆ ನಾನು
Much later, my lord, when
ಬಾಲಾಲು ಗ್ರಾಮದ
determined the
ಸರ್ವೆ ನಂಬರ್.
compensation and, they were one of the claimants who showed up after the final notification.
ಅಲ್ಲ, ನಾನು I have not approached.
To annexure D.
No, I have not approached. Sorry.
It is not,
I don't know. I did not know till.
Pay them afresh, that is all.
my lords, the difficulty is this, whether and to what extent of land they hold is in doubt, my lords, because the
The RTC that they have produced indicates that they, their name was muted for 4 acres and for 1 acre 32 guntas.
my lords may see
39
page
bar
11
feet.
of my statement of objections. The actual RTC is that.
Are you saying that this is a duplicate
It
RTC?
is not duplicate, my lord. This is part RTC that is running parallelly with respect to some.
Whose mistake is it? If you don't look at all the RTCs.
My lords, this is the principal RTC, my lords. We have looked at the village map. My lord, in the sense, my lord, if there is a POD that is done, POD that is affected,
You
my
need
lord,
to
then,
take care of all that.
my lords,
You need to take care of all that. You can't wash your hands up and saying whatever I was furnished, I should have. The fact that you know about this now,
now we know about this after he has filed the writ
will give you
petition.
liberty to issue a fresh notification and then proceed against him.
Insofar as the final notification is concerned.
Both notification, I have to give an opportunity.
Then now that you.
Set me back by this is of the year 2011, 12, 11 to 13, my lords.
The petitioner is
Kindly,
challenging. How can you get over this?
my lords, there's an RTC with respect to the land, the entire extent of land, which is at page number 11. Kindly permit me to show
I'll
that.
give you liberty if I issue a fresh notification if you want.
My lords,
Petitioners are challenging.
my lords, my lords, page 11 of my statement of objections.
Yes.
Thirty-nine, 36.24 is the entire extent. Now, my lords, in that, his claim is that his property is, forms part of this. Except for one stray RTC, there is no other document that is there in his
There is a
custody.
mutation record of the year 2005.
My lords,
Mutation record. MR is of the year 2005, 2006.
my lords, his name is not there.
Yes.
His
At
name is
page
RC Subhash.
Come to page 11. MR 56/2005-2006. He has purchased on 29/5/2006.
Yes, my lords. He doesn't have, my lords, he claims that he owns 1 acre 30
Has
guntas.
purchased it and registered sale it. He is under no obligation to inform the authorities about change of kata. It is their responsibility. That is what the KLR Act says. If he has paid the POD fee, their responsibility ends.
My lords,
If
it
they
is not
don't
that
do-
I have been negligent at that stage, my lords. Because the RTC, his situs of the land is not known. The boundaries of the lands are not known
Not
because
know
they,
because you may not know
because he has not taken efforts. He has purchased the land with respect to which there was no POD. So
fact that
today,
the RTC, the fact that the RTC indicates that the entry of his name in respect of a particular sub number of the survey number
Yes, my
indicates POD was done.
my lord, there was no POD that was done.
B2.
How else will they
If
issue?
a POD is done, my lord, the number will not be a sub number under 39, like 39
You should
P1,
ask-
P2.
You should ask them. Can the purchaser,
My lord, for POD to be done, my lord, the procedure is this, in case of a grant, there is supposed to be a distinct survey that is done whereby his property is clearly identified
ask them?
pursuant to a grant.
How can you hold him
My
responsible?
lords, insofar as that is concerned, my lord, may I be permitted to place one judgment on record, my lords? Only to the effect that I am not required to do a roving inquiry into who's the title holder. I have looked at the RTC that is available.
I agree with you.
Yes, my lord.
You are bound to make an effort, at least to put the name of those people in whose name the revenue record stood.
My lords, that effort I have made immediately upon coming to know that there is somebody who is claiming.
You need
So
to
I
be,
issued the
notice to him. But taking away somebody's land, be a bit more careful. You can't say that some Tahsildar gave me something, you are aware there's a joint survey conducted.
Yes, my
You know
lords.
what is the land to be acquired. You need to make a verification of all the records and then notify it, or else what is the purpose in you doing whatever you think is right? He is a person who has purchased the property. His name is entered into the records pursuant to his purchase. What is he required to do? Can he ask?
My
them
lord,
to-
the diligence that was required on his part, my lord, was that he should have got the POD done. A distinct survey number ought to have been identified, and his actual extent to which he is entitled should have been.
If I purchase an agricultural land and pay the necessary fee at the time of registration, that is all that I am required to do.
My lord says.
It's not my job to get it.
My lords, when
For
there
the
is a
purpose
grant
of
land,
change
as
of-
distinct from a normal land, my lords, that may be true, my lords, if I'm purchasing an agricultural land which is got a distinct survey number, distinct survey sketch, etc. But this is a case where there is a larger boundary of government land within which his land forms part.
Then you tell me, you explain to me as to how this RTC was issued.
My lord, this is a parallel RTC that is running, my lord. This is not with respect
Who's
to distinct
responsible?
survey number, my lord.
Who's this is a government record. How can you just wash your hands up and say?
My lords, we are not washing hands of my lords, but we have demonstrated our diligence, my lord, as of that date. Because even today, my lords, the strange thing is, even in the writ petition, he is not able to say where the boundaries are. My lords may see the scheduled property. If that further shows that there is no distinct demarcation of his property, he has not produced the sale deed, because sale deed will not have the boundaries. My lords will see at page 11.
Issue a fresh notification.
My lords, unless my lords, he's gotten a distinct extent identified under his name.
Commissioner is challenging the notifications issued under section 4 and 6 of the Land Acquisition Act, by which land sparing survey number 39/5 and 39/2B of Doninade village, Tavarekere Hobli, Bangalore South Taluk, has been notified for acquisition.
One last
This
bit
case,
submission.
that though his names were entered in the revenue records pursuant to his purchase on 29/5/2006 via MR 56/2005-2006, in the impure notifications, his name has not been notified. He submits that since the lands, the revenue records in respect of his land stood in his name, the authorities were bound to notify him, and without including his name in the notification, the acquisition cannot be sustained. The housing board, on the other hand, contends that no doubt the name of the petitioner was entered in the revenue records, but that was a parallel entry, and there was no POD as such done in accordance with law, and therefore the name of the petitioner was not included in notification. It is submitted that only if a POD in accordance with law had been conducted and a separate serial number was demarcated against the petitioner, the petitioner would be entitled to get a notice of the acquisition. In my view, the submissions made by the housing board cannot be accepted. It is settled law that once a person acquires an agricultural property, property under registered sale deed, his obligation to get the kata changed ceases the moment the necessary fee is paid at the time of registration of the sale deed. Sale deed is the name dile.
I have not produced.
The fact that the authorities have acted upon the sale deed on dated 29/5/2006 and inserted the name of the petitioner in the year 2005-2006 itself in MR 56/2005-2006 is indicative of the fact that the petitioner had in fact complied with the requirements of the Land Revenue Act. So once the name of the petitioner was found in the revenue records, his name ought to have been notified in the notifications. Next, but the argument that there was no proper survey conducted and a proper POD made cannot be attributed to the petitioner. The petitioner, being a purchaser, is only required to follow the procedure of paying the necessary fee. And once the revenue authorities choose to give a sub-number to the land that he has purchased, he cannot be expected to demand a separate survey number be assigned to him. The assignment of a new survey number or the procedure to be followed is within the domain of the revenue authorities. And if they choose to give a sub-number, the same cannot be used to prejudice the rights of the petitioner. And therefore of the view that the notifications cannot be quashed, cannot be sustained, and they're accordingly quashed. Liberty is however reserved to the housing board to notify the lands afresh after including the name of the petitioner in the proposed notifications. Subject to the above, the petition is allowed.
Serial number 7, your lordship may kindly have some other.
Serial number?
Serial number 7. Islam.
2014.
Inno Islam. Much obliged.
My lord, the petitioner herein filed miscellaneous petition under order 12, order 20, rule 12. My lord, and sought for, my lord, the sum of rupees 18,315.
In challenge madidra?
ಇಲ್ಲಿ ಏನಾಗಿದೆ, pursuant to the ejectment suit, the same has reached its finality. The determination of mean profits has been filed, order 20, rule 12. And the petitioner herein is claiming 18,315, a sum of rupees 18,315 towards the use and occupation of the suit scheduled property. My lord, the property in question, my lord, the shop premises, the same was purchased by the petitioner, my lord, in the year 1995. My lord, from the respondent herein, my lord, he is due a rent from 13/12/1995. There onwards, my lord, the petitioner herein filed ejectment suit. The suit decreed, my lord, on 6/1/2001. And
you obtained a decree for ejectment.
yes, my lord.
Where is the decree?
The same was not a part of, my lord, but this petition is concerned, my lord, for determination of the mean profits.
Does the decree permit that?
Yes, I will furnish, my lord, order. OS 374 of 98, my lord, the same was decreed, my lord, on 6/1/2001.
Please read from para 18. From para 16, sir. Page 33.
He got produced the certified copy of the decree passed in OS 374 of 98 and RA 10 of 2001, marked as Exhibit P1 and P2 respectively. He got produced the certified copy of the judgment and decree passed in RA 120 of 2006, marked as Exhibit P3 and P4 respectively. The respondent has denied the case of the petitioner. He is also denied the fact that he is liable to pay damages at the rate of 300 per month from the date of filing of OS 374 of 98, and he is liable to pay a sum of rupees 18,315 as on the date of filing the petition, and also liable to pay the interest at 24% per annum on the said amount. The learned counsel for the respondent subject PW1 for cross-examination. In the cross-examination, PW1 has admitted that he filed OS 374 of 98 only for recovery of possession of the suit scheduled property from the hands of the respondent by terminating the tenancy. And he has not sought for arrears of rent. He also admitted the suggestion that he has not sought for arrears of rent for the use and occupation of the petition scheduled property, and admitted that the said suit came to be decreed in his favor. PW1 admitted that the respondent was inducted as a tenant from the original owner on Jevrai. PW1 has stated in the cross-examination that he is not aware whether the respondent has paid the rent rupees 135 and also paid an advance of rupees 1,000 to Jevrai. He admitted the fact that he has purchased the petition scheduled property in the year 1996, and after purchase, the respondent has issued notice to him by clearly stating that he has paid the entire up-to-date rent to the original owner Jevrai at the rate of 150, and he is ready to pay 150 per month from the date of purchase of the petition scheduled property. He also admitted the fact that the respondent got produced the notice in OS 374 of 98, same is marked as Exhibit P2. PW1 has categorically admitted that in RA 10 of 2001, the respondent has paid the arrears of rent amounting to rupees 2,850 on 16/2/2001. And as per the order of the Honorable High Court of Karnataka, the respondent quit and deliver the vacant possession of the petition scheduled.
Where is the decree for determination of mean profits?
No, my lord, on the earlier occasion, my lord, I have placed these two rulings, my lord, the.
Rulings bitti decree ತೋರಿಸಿ first decree ಇರ್ಬೇಕತಾನೆ ನಿಮ್ಗೆ.
Alla, my lord, the.
20 rule 12. There must be a decree which enables
Future,
it.
my lord, the future mean profit, it include, which is an incidental to the relief of possession.
Was that relief?
There is
granted
no
to you?
decree, my lord, so far as, my lord, for determination, my lord, order 20 rule 12 petition has been
If a
filed.
decree is granted, then yes. If there is no decree granted, how can you ask for mean profits?
My lord,
ಈ ಸ್ವಾಧೀನ ಸಿಕ್ಕಿದೆಯಲ್ಲ, why are you fighting unnecessarily?
ಇಲ್ಲಿ ಏನಾಗಿದೆ in the similar,
18,000 ರೂಪಾಯಿಗೋಸ್ಕರ.
ನಾನು ಹೇಳಿದ್ದೀನಿ, in the similar circumstances, my lord, if the future my lord, kindly pass, I may be permitted to pass on this, my lord.
I'll impose cost here because both of them impose cost. I'll impose cost here also. Both the courts have imposed cost, isn't it?
ಹೌದು.
ಇಲ್ಲೂ ಬೇಕಾ cost?
I will get the instructions, my lord.
ಏನ್ ಬೇಡ instruction. This revision is filed challenging the order passed by the trial court, which has also been confirmed by the appellate court. It is not in dispute that the petitioner had instituted a suit in OS 374/1998 for ejectment against the respondent here. It is also not in dispute that this suit was decreed and is also confirmed in appeal and also in second appeal before this court. Next part. The petitioner, after the dismissal of the second appeal, filed a petition seeking for determination of mean profits on the ground that the petitioner was in unauthorized occupation and was therefore entitled for determination of the mean profits. The trial court has recorded a finding that the decree passed in OS 374/98 is only for recovery of possession. And the petitioner had not in fact sought for arrears of rent. It is also noticed that the petitioner admitted that the suit was only for recovery of possession and he had not sought for arrears of rent. The trial court as well as the appellate court have also taken note of the fact that the decree that was passed in favor of the petitioner did not grant him a decree for determination of mean profits. It has also taken note of the fact that the petitioner admitted in the regular appeal that had been filed by the respondent that the respondent had paid the arrears of rent amounting to rupees 2,850 on 16/2/2001, and he had also delivered vacant possession as ordered by this court. In view of the fact that both the courts have recorded a clear finding that there was no decree awarding damages of a determination of mean profits from the orders passed by the courts below cannot be found fault with. I find no reason to deny the petition. Petition is therefore dismissed.
For the petitions in this matter, my lord. Lord, I am withdrawing the petition, my lord, because in the trial court, evidence has been commenced and plaintiff's evidence is concluded and defense is.
Counsel for the petition, checking permission to withdraw the petition.
May I make one submission, my lord?
Revision is dismissed as withdraw.
May I make one submission, my lord? My lord, since the suit is of 2008, my lord, a direction may be given to dispose of the matter within
You kept it,
arguments.
in a time limit. My
but
lord,
you kept it pending for 8 years now.
my
stay ಆಗ್ಲಿಲ್ಲ.
basically, my withdrawal will not come in the way of the merits of the suit.
That is, this is against order 7-11, isn't it?
Yes,
Needless to state that the decision rendered on the application of order 7-11 will not be construed as rendering an opinion on the merits of the claim of either of the party.
obliged.
Appeal for the petition, my lords. Small accommodation may be given, my lords. Appeal for the petition of small accommodation may be given.
2016,
My lords, senior is not well, my lords, for that
you are
reason.
well considered. You
My
argue,
lords,
I'll permit you to argue, I'll put your senior's name.
my lords, small submission, small accommodation may be given, my lords.
You have an interim order here.
No, my lords, stay if not.
Now stay here. And you have an unconditional interim order. For 8 years, you've got an interim order.
My lords, small accommodation, kindly 1 week time may be given, my lords, we'll argue over the matter and.
You admitted that the loan was taken by your husband and he has signed exhibit P1 and P2.
Yes,
Then
my
what
lords.
remains? And you have taken compassion appointment. Therefore, you have succeeded to the estate of the deceased.
Yes, my lord, but.
Want to pay that 1 lakh.
But according to section 6, my lords, according to section 6 under Hindu Succession Act, my lords, it is that the grandson and the legal heir are not liable to pay the.
Wife, isn't it?
Yes, my lords.
Defendant is a wife.
Petitioner is the wife, my lords. LR.
No, defendant is the wife of that KJ Ramesh, isn't it?
No, my lords.
Yes. KJ Ramesh was the defendant.
Yes, my lord. In this petition, my lords,
She admits in the cross examination that her husband had borrowed 1 lakh and he had signed on that exhibit P1 and P2.
Yes, my lord.
And she also admits that she had received his benefits.
Yes, my lord.
Then
That small accommodation, we will say 1 week time, we will, I'll.
take tomorrow.
Yes, my lord. Much appreciated.
Appear with the petitioner.
Another
An
appeal
application
for the
filed by the
respondent.
petitioner for rejection of the plaint has been rejected.
My,
The
with
said
my lord's
order has-
kind leave, my lords, if I may submit.
Yes.
My lord, there's some personal inconvenience for senior today, my lords. The matter may kindly.
2016
be
matter,
next
madam.
week. My lord, I pray for a small accommodation, my lords.
2016, I can't keep on adjourning it. It was adjourned on the last occasion also.
My lords, on last two occasions were adjourned at the behest of the petitioners, my lords. I just seek a one accommodation, my lords, kindly.
So he gets one chance, you get one chance.
No, my lords, I
Yen matter ena?
My lord, the plaintiff had questioned the adoption of the first respondent. And he has sought for declaration of the said adoption as illegal and honest in the EF law.
Where is the plaint?
Plaint is at page 26, my lord. Cheduranga Kantrajaras. The plaintiff, my lord, is the son of Srimati Gayatri Devi, the eldest daughter of His Highness Sri Jayachandra Jindram Vadiyar.
Plaintiff is challenging the adoption of the first defendant.
First defendant. He has no cause of action.
On what ground?
On the ground, my lord, his adoption has created a disturbance in the Mysore area and other things, and therefore it is wrong. Lashma, kindly see, the prayer is at page 31. Declare that the alleged adoption of the first defendant by the second defendant as illegal, void, and non-est in the EF law. Permanent injunction restraining defendant number 1 from purporting to do and act as adopted son of Srikatadatta Narasimharaja Vadiyar, including dealing with the privileges, perquisites, estate of royal family.
No, this declaration.
My lord, he has no low caste and as such.
Declare the adoption of the first defendant as non-est in the area of law.
Yes, my lord. It was, the adoption as per the sermon has taken
You
place
are
on
for-
23/2/2015.
You are for the second defendant.
I, Pramod Devi, my lord, for the adopted
High
mother,
Court has
rejected that application. There is a judgment of this on court, my lord. It is only the adoptive father or adopted persons can challenge.
Do adoption.
There is no locus standi as such. Age is not the bar because there is a custom, my lord. There are, I have narrated certain instances. Customs prevailing in adopting the age above the prescribed age in the Adoption Act. Section 10, my lord, the customs is permissible. Before the Lashmi kindly see the written statement, my lord, there I have narrated adoption of persons above the age of 15 years. At page 47. The customs in the royal family.
How is the plaintiff interested in this adoption?
No way. The only thing, Lashmi kindly, the averments in the plaint at page paragraph 5, my lord. Page 29. Plaintiff is the member of the erstwhile royal family, is interested in preserving its fair name, traditions, etc., and also its proper representation to the outside world by a person who is entitled to represent the same, both in law and otherwise. This is especially so since such accredited person is expected to interact with all, including the public authorities and government. Since the first defendant does not fulfill the requirements, both in fact, much less in law, the plaintiff is constrained to file the suit to challenge the alleged adoption. It is submitted that the alleged adoption is neither true nor correct in fact, and is therefore no adoption ipso facto, and indeed void ab initio. You can understand ಅವ್ರು ಏನಾದ್ರು ಅವ್ರನ್ನೇ ಮಾಡ್ಕೊಳ್ಬೇಕಾಗಿತ್ತು ಅಂತ ಏನಾದ್ರು ಇದ್ರೆ ರಾಯಲ್ ಫ್ಯಾಮಿಲಿ ಕಸ್ಟಮ್ ಪ್ರಕಾರ I could have understand that he has got some locus standi to challenge this adoption. The age ಹೇಳ್ತಾರೆ. Age, my lord, in the previous, my lord, there are certain instances, various instances adopting the person above the age of 15 years. I have narrated in my written statement.
Yes, madam.
My lords, I pray for some time. My lords, maybe listed tomorrow, my lords. Senior will appear and address arguments.
Tomorrow.
Much obliged.
Kindly pass out. Okay, my colleague will argue. Huh? My colleague earlier, the V.S. Kumbar is there. In matter, no?
Matter with regard to the land acquisition.
6 ಅಲ್ಲ?
No, 5 number.
5 ಅಲ್ಲ 6. Number 6 ಅಲ್ಲ?
83 dismiss ಆಗಿದೆಯಾ?
LAC that
Why is it dismissed?
that is dismissed because of that the one MFA 5197 was remanded back to the lower court only with regard to redetermine the compensation and after affording opportunity both the parties and dispose the matter expeditiously. That is a 7th par.
Is barred by time ಅಂತ ಹಾಕಿರಲ್ಲ?
Barred by time antala. He has taken once again full the case into this. Only the 7th para, my lord, MFA is remanded back. Your lordship may kindly see the 7th para of the MFA order. MFA 5197 of 2012. 7th para, it stated that foregoing reasons the instant appeal is allowed. The impugned judgment and award dated 10/2/2012 passed in LAC 110/2002 on the file of the principal civil judge, Bangalore Rural District, Bangalore, hereby certified. The matter stands remitted back to the reference court to redetermine the compensation after affording the opportunity to both the parties and dispose of the matter. It is only redetermine the.
This is submitted LAC 17/2000 was dismissed as not maintainable.
That is because of that.
You had sought for reference earlier?
Yes, madam. Your lordship may kindly, this is how the 82, the notification has passed for land acquisition. It's only a 14 guntas by the housing board.
What is this LAC 71/2000?
75 or
71/2000?
18
ಅವ್ರದೇನಾ?
ಅದು dismiss ಆಗಿದೆ.
After it was dismissed, how can you seek for reference again?
that is what, my lord, I've got some confusion on this point there. So my colleague will, he is also.
This case, my lord, petition against the respondent 1 to 6 is also already withdrawn, my lord.
1 to
6, only 7th petition is remaining. Others are after filing the petition, they have received the compensation consent, withdrawn the writ petition.
7th yaru?
7th, only 7th petition.
Third matter ಇದೆ? There are 2 matters.
ಅದು ಇದು KDB. ದಾವಣಗೆರೆ. Only 7th petitioner. He claims, my lord, they has 22 guntas.
Other than 4 ಜನ ಇದರಲ್ಲಿ first matter ಅಲ್ಲಿ.
Sorry, connected second matter, 5694.
P1A, 2H dismissed as withdrawn. P2 and 3 ಉಳ್ಕೊಳುತ್ತಲ್ಲ.
ಅದು ನಾನು ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಇರೋದು. ಅದಲ್ಲಿಯೂ ಕೆಲವರು ವಿಡ್ರಾ ಮಾಡಿದ್ದಾರೆ.
ಏನ್ ನೋಟಿಫಿಕೇಶನ್ ಇದು?
ಇದು KDB for acquisition for the industrial purpose ಮೇಲೆ in ದಾವಣಗೆರೆ.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ ಅವ್ರಿಗೆ?
ಎಂಟ್ರಿ ಮಾಡಿದೆ. Entry ಮಾಡಿ not to dispose ಅಂತಿದೆ, but meantime they have settled the matter and withdrawn the second petition ಅಲ್ಲಿ only seventh petition is.
Are they coming regularly? ಏನಾಗ್ತಿದೆ?
ಬರ್ತಾರೆ.
ಪಾಸ್ ಅವ್ರು ಮಾಡ್ಲಿ ಏನ್ ಮಾಡ್ಲಿ?
ಇವತ್ತು ನೋಡಿಲ್ಲ. ಪಾಸ್ ಅವ್ರು ಇವತ್ತು ನೋಡಿಲ್ಲ. ಯೂಶುವಲ್ ಬರ್ತಾರೆ, ಇಲ್ಲೇ ಇರ್ತಾರೆ.
ಪಾಸ್ ಅವ್ರು ಮಾಡ್ತೀನಿ ನೋಡಿ.
Petitioner, but here I had sought for benefit under the incentive scheme. This court by order dated 7th November 2013, page number 30. Page number 30. What happened was they took possession from me.
What was the extent that they took possession of?
My entire extent, 3 acres, 18 guntas. My lord, what happened was on 29/1/2003, they took possession. On the same day, my wife and myself filed separate writ petitions challenging, asking for under the Junjamma case. Starting point effectively would be the order of this court dated 7th November 2013, page 30. Where the contention has of the BDA is that at para 4, page 33, it is also for submission that notwithstanding the fact that he had filed the writ petition earlier, petitioner had not really resisted handing over possession. I didn't resist it, they didn't take any coercive steps, they took possession. Then, my lord, para 6, I was given liberty to make a representation.
Now what have they done?
But they issued one more endorsement as per Annexure A. Lordship, may please see page number 9, saying that no, you filed a writ petition. We are not going to give you the benefit. And also they say, we have given benefit to your wife, we are going to take back that also. They have not challenged the order of this court.
Rule 3, my lord says, my lord, the incentive site is.
But you not challenge this order, isn't it?
No, they have not
The order
challenged.
which permitted him to make a representation.
Yes, that representation we considered, and this was the.
No. This court recognized the right, isn't it?
No, this court.
Court did not allow you to dismiss it on the ground that they have filed a writ petition, challenge the acquisition.
My lord, because the rule says, my lord, kindly see the rule 3. Rule 3.
What does the judgment say?
My lord, judgment, my lord, the last step, it says, my lord, make the representation for.
Adar munche, this court took note of the fact that at paragraph
4, we had disclosed that we had filed a writ petition on the same day.
That is a submission, my lord.
this argument was advanced by you only in para 3.
Yes, para 3, there are also the.
ನೀವೇ ಹೇಳಿದ್ರಿ ಅಪ್ಲೈ ಮಾಡಿದ್ರೆ ನೋಡ್ಕೊಳ್ತೀವಿ ಅಂತ. ಈಗ ಅಪ್ಲೈ ಮಾಡಾದ್ಮೇಲೆ ಇಲ್ಲ ನೀವು ರಿಟ್ ಹಾಕಿದ್ರೆ ಅದಕ್ಕೆ ಕೊಡಕ್ಕಾಗಲ್ಲ ಅಂತ.
If the petitioner met the criteria prescribed in Junjamma's case.
Then you should have said, no, we will not consider because he had challenged the acquisition. You misled the court.
No, my lord, if the petitioner met the criteria.
You should have, you knew that he was litigating. In his writ petition, you made the statement. ಸುಮಾರು ಕೇಸಲ್ಲಿ ಕೊಟ್ಟಿದ್ರಲ್ಲ, ಎಲ್ಲ ವ್ಯಾಜ್ಯ ಆದ್ಮೇಲೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ನನ್ನ ವೈಫಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
But rule 3, my lord, this says, my lord, the incentive side, the intention of the incentive side.
In the light of this order, how can you even bring in rule?
Here only said, my lord, to consider their representation because the under
This binds you. You can't get over this order. You gave an assurance to the court that if he gives a representation, we'll consider, thereby giving
no,
the
not on
its
representation.
entitlement, not on the ground that he is eligible or ineligible.
They said, my lord, the seeks allotment, if the petitioner met the criteria prescribed in the Junjamma's case, and therefore if the petitioner should make a representation, it should be appropriate to consider in accordance with the law.
In the endorsement issued, they don't say you have not met the criteria of Junjamma's case.
Junjamma case ಕೊಡು.
I produced it.
ಅದೆಲ್ಲ litigate ಮಾಡಿರೋ ತಾನೆ ಜುಂಜಮ್ಮ ಕೇಸ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದು. Junjamma's case was an outcome of the litigation. In that case, they said grant.
Junjamma case ಅಲ್ಲಿ incentive
Good.
said, my lord, site owners and land owners are concerned. The alternative site. Here, my lord, they are seeking the under incentive site rules under rule BDA rules incentive.
Compensation ತಗೊಂಡಿದ್ದಾರೆ ಅವರು.
Compensation ತಗೊಂಡಿದ್ದಾರೆ. Civil court ಅಲ್ಲಿ enhancement ಗೆ ಹಾಕಿದ್ದಾರೆ, enhancement ಅದಾದ್ಮೇಲೆ ತಗೊಂಡಿದ್ದಾರೆ.
Incentive scheme rules ಕೊಡು.
BDA Act ಅಲ್ಲಿ, BDA Act. Petitioner also, my lord, the property was transferred to the trust, my lord. They have already,
That was just,
they are not the owner, my lord. They have already transferred. Before that, it was transferred to the trust and trust become the owner. Now, trust is not before your lordship, when the petitioners are.
Trust ಗೆ ಕೊಡಿ, ಯಾರೋ ಒಬ್ರು ಕೊಡಿ.
The trust is not before, the individual right ಅಲ್ಲಿ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
trust transfer ಆಗಿಲ್ಲ. There was a proposal, but after all this, nothing happened.
Produce the letters given by the petitioner themselves. Rule 3 and 4.
When rule 3 says I should voluntarily hand over, I voluntarily handed over.
No.
29/1/2003. It is not that.
When did you issue the notice under section 9?
My lord. Section 9 notification, my lord. That I have not produced, my lord. But they earlier, my lord, they filed the writ petition WP 33,671 of 2003, challenging the petitioner and his wife, both of them, my lord, filed the writ petition challenging the acquisition notification. There, my lord, interim order stay was granted.
No, it's all
On
29/1/2003 possession was taken. 29/1/2003 writ petition was filed. On the date when possession was taken, no coercive steps were taken. We handed over.
Was the award notice?
My
You
lord,
have the copy of the award notice?
award was passed on 5/12/2002, my lord.
Then you handed over possession immediately.
No, we have taken position, my lord, the position on 29/1/2003.
Date ಎಷ್ಟು?
My lord, the position was taken on 29/1/2003. The award was dated 5/12/2002, my lord.
5/12?
2002. Award amount deposited in the civil court on 18/3/2002.
No, when was the award notice sent to him under section 9 for him to hand over possession?
My lord, that notice.
Because the rule says,
Yes, my lord.
if in response to the notice,
Yes.
if you don't give him a notice and you take over possession voluntarily,
For that notice, I have not produced, my lord.
where have you said that that is the criteria, isn't it? If you were to argue,
That is the criteria.
ಕೊಡಿ ಕೃಷ್ಣ ಸುಮ್ಮನೆ ಯಾಕೆ ಇದಕ್ಕೆಲ್ಲ ಜಗಳ ಮಾಡ್ತೀರಿ ನೀವು? They've given up their land. For them also, if you deprive them, the prayer in this petition. the petitioners here challenge the endorsement dated 6/7/2005, thereby their request for grant of sites under the BDA incentive
Scheme for voluntary.
voluntary
surrender of-
surrender grant rules 89 has been rejected. By the impugned endorsement, the BDA has refused to grant the petitioners whose lands were acquired incentive sites on the ground that the petitioners had challenged the acquisition in WP 36245/2003.
My lord, 33671/2000.
36245 was the earlier one where the direction was given to give the representation.
That is the reason given, isn't it? Page 10.
One bit ಹೋಗಿದೆ 33671
ಅಲ್ಲ ಇಲ್ಲಿ ಬರ್ದಿರೋದು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ರಿಟರ್ಜಿ ನಂಬರ್ 36245 ಆದೇಶದ ಉಪಾಯುಕ್ತರು ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ನಡೆದ ಉಪಸಮಿತಿ ಸಭೆಯಲ್ಲಿ ಪ್ರಕರಣ ಪರಿಶೀಲಿಸಿ ವಿಶೇಷ ಪ್ರೋತ್ಸಾಹಧನಕ ಯೋಜನೆಯಡಿ ಕೃಷ್ಣ ಕೋರುವ ನಿಮ್ಮ ಮನವಿಯನ್ನು ಉಪಸಮಿತಿಯ ಸಭೆ ತೀರ್ಮಾನದಲ್ಲಿ ತಿರಸ್ಕರಿಸಲಾಗಿತ್ತು.
But the petition number is.
Their subcommittee approves giving me a site, but then they issue an endorsement.
Second paragraph ಅಲ್ಲಿ
And therefore they would not
WP
be entitled for
33671
the grant of incentives. The petitioner herein had challenged the endorsement dated 1/7/2012. The earlier endorsement alvada,
ಯಾವ್ದು earlier endorsement?
by which his claim for grant of incentive sites was rejected. In this writ petition, the BDA had contended that the petitioner had never made a representation seeking for the benefit of the direction issued in Junjama's case. And if the petitioner met the criteria, he should make a representation, same would be considered. The petitioner in that writ petition had categorically stated as follows, para 4, page 33. This court ultimately disposed of the writ petition in the following terms, para 6. As could be seen from the above, it is clear that this court took note of the fact that the petitioner had questioned the acquisition proceedings earlier in WB 3367-3369/2003. And notwithstanding
3367 ಆಗಿದೆ.
the 3367,
Mistake ಆಗಿದೆ. 67 in their petition also 671.
ಅಲ್ಲ ಈ ಆರ್ಡರ್ ಹಂಗೆ ಇದೆ
Order ಅಲ್ಲಿ ಅದು one ಬಿಟ್ಟು ಹೋಗಿದೆ.
number. And also took note of the fact that the BDA itself stated that if an appropriate representation was made, the same would be considered. In the light of the fact that the BDA itself had stated that the petitioner's claim for grant of sites would be considered, the impugned endorsement cannot be sustained. There is yet another factor which has to be taken note of in this case. The BDA incentive scheme for voluntary surrender of land rules indicates that if in response to a notice given under section 9 of the Land Acquisition Act, the landowner voluntarily hands over to the Deputy Commissioner possession of the land free from any objection, then then that person would be entitled for allotment of incentive sites. In this case, it is admitted that the award was passed on 5/12/2003, alva?
2002.
2002. And the possession was taken on 29/1/2003. This indicates that possession was taken immediately after the award was passed. There's nothing produced by the BDA on record to indicate that a notice was issued to the petitioner and he refused to surrender possession. The fact that the possession was taken within about 1.5 months of the award being passed, coupled with the fact that this court accepted the submission of the counsel appearing for the petitioner, that the petitioner had not resisted the handing over of possession, in my view, entails the petitioner for allotment of sites under the BDA incentive scheme for voluntary site routes. In this view of the matter, the impugned order is quashed and the respondents are directed to consider the case of the petitioner in accordance with the incentive scheme rules and make necessary allotments within a period of 3 months. Date of receipt of a copy of this order. Yes.
Excuse me, Lord. The petitioners is the owner of 2 acres in the gunters of land at.
Who's opposing you?
Naik.
Ashok Naik.
Ashok Naik. Plus still I'm in possession, my lord. RTC stands in my name. I'm paying tax regularly till today also.
You are challenging the 28/4 notification.
28. Well, I was not given opportunity being heard, and under section 28(3) is mandatory that I should be heard.
What is the date of 28/4 notification?
28(4) notification.
2010.
Yes, 2012.
You
Well,
filed a
six
petition
July
6 years.
2010, ma'am. Still I'm in possession.
What is the extent of land?
2 acres in the.
ನಿಮ್ಮ ಹೆಸರಿತ್ತ ಖಾತಲ್ಲಿ?
Yes, ನನ್ನ ಹೆಸರಲ್ಲಿ ಖಾತೆ. ಎಲ್ಲಿ ಈ RTC ಎಲ್ಲ ಈಗಲೂ ನಮ್ಮ ಹೆಸರಲ್ಲೇ ಇದೆ ಸರ್. ಟ್ಯಾಕ್ಸ್ ಪೇ ಮಾಡಿ ಅವಾಗಲೂ ಸರ್, ಅವಾಗಲೂ ನನ್ನ ಹೆಸರಲ್ಲಿತ್ತು, ಅದಕ್ಕಿಂತ ಮುಂಚೆನೂ ನನ್ನ ಹೆಸರಲ್ಲಿತ್ತು. I constructed house in that agriculture premises ಮೇಲೆ. It is agriculture land ಮೇಲೆ. I got 60 mango to other trees, it's ಇಲ್ಲಿ, even now it is there.
Objections ಹಾಕಿದಾರಾ?
Objections ಹಾಕಿದ್ದಾರೆ.
ಏನಂತ ಹೇಳ್ತಾರೆ?
Objections ಇಲ್ಲಿ ಡೀಟೇಲ್ ಮಗುಮ ಹಾಕಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ನನಗೆ ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ಟಿದ್ದೇನು ಹೇಳ್ತಾ ಇಲ್ಲ. 28 2 ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ 28 4 ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. 1/12/2009 ಅಲ್ಲಿ ಪಬ್ಲಿಷ್ಡ್ ಇನ್ ದಿ ಗಜೆಟ್ ಅಂತ ಹೇಳ್ಕೊಂಡಿದ್ದಾರೆ. ಪಬ್ಲಿಕೇಶನ್ ಮಾಡಿದ್ವಿ, ಆಮೇಲೆ ಸಿಟಿ ಸಿವಿಲ್ ಕೋರ್ಟಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಕಾಂಪನ್ಸೇಷನ್ ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ. ಅಂಡರ್ ಸೆಕ್ಷನ್ 13. ಬಟ್ ನನಗೆ ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ಟಿದ್ದ ಬಗ್ಗೆ ಏನು ಹೇಳ್ತಾರೆ ಸರ್? I have filed my objections. ಅದೇ next B ನಲ್ಲಿ objections file ಮಾಡಿ ಹೇಳಿದ್ವಿ. It's an agriculture land. I have constructed a house. I'm staying there. I'm cultivating the land ಅಂತಾನು ಹೇಳಿ.
You say that they have taken possession also.
Possession ತಗೊಂಡಿಲ್ಲ ಇನ್ನು. Possession is still in my.
ಬರ್ದಿದಾರಲ್ಲ ಅವರು.
ಬರ್ದಿದ್ದಾರೆ, but still in RTC also in my name. The latest tax receipts also there.
ಇಲ್ಲ 2010 ನಲ್ಲಿ RTC ನಿಮ್ಮ ಹೆಸರಲ್ಲಿತ್ತಾ?
ಇದೆ.
ಎಲ್ಲಿದೆ ಅದಕ್ಕೆ?
ಅಲ್ಲೇ ಅನ್ನಕ್ಕೆ ನಾನು ಅನ್ನಕ್ಕೆ ಹಾಕಿನಿ ಸರ್.
2014 ಹಾಕಿದ್ದಾರೆ. ಅರ್ಲಿಯರ್ ಎಲ್ಲಿದೆ?
ಇದೆ ಹಾಕಿನಿ ಸರ್. Earlier 2004 5.
What is the date of the preliminary notification?
ಎಲ್ಲ
Preliminary notification date ಎಷ್ಟು? Preliminary notification.
preliminary notification to 9 ಅಲ್ಲೇ ಇದೆ ಸರ್.
Serial number ಯಾವುದು ನಿಮ್ದು?
23/12/2009. Annexure senior. 9 preliminary notification. I filed my objections within 2.
ಸರ್ವೆ ನಂಬರ್ ಯಾವುದು ನಿಮ್ದು?
Annex
ಸರ್ವೆ ನಂಬರ್?
Survey number 99. 2 acres 25 gunters.
99 ಅಲ್ಲ?
99. Item number 55 ನಲ್ಲಿ ಸರ್. 55 preliminary notification.
ಸರ್ವೆ ನಂಬರ್ ಎಷ್ಟು ನಿಮ್ದು?
Survey number 99.
ರಂಗದಾಮಯ್ಯ.
Now he is dead, is LR comment.
Where's Ashok Naik?
I have latest RTC records on the file can produce it also.
Written come, I'll pass out.
Next week, we'll have put the additional document also, latest RTC also. I'll put this list. Next week.
For respondent number 4. What is the next surety? Objections ಹಾಕಿದ್ರೆ ನೀವು?
Kindly have it taken tomorrow.
Next week.
File is not there, at least. Somewhere it will be placed, day after tomorrow.
No, the fact that there were trees on the land is not in dispute. ನೀವು ಕೊಡಿ ಅವ್ರು ಕೊಡಿ ಅಂತ ನೀವು ಯಾರು ಕೊಡಿದ್ರೆ
Day after tomorrow. Day after tomorrow.
Let's discuss.
Pertaining to Chitradurga.
There are
Petition
total extent of 82 acres have been notified for acquisition by the respondent authority, my lords, for the industrial purpose. Let's preliminary notification has been passed in the year 2009, my lords. Final notification has been passed in the year 2010. And my lords, there was a proposal from the authority, my lords, to the government to drop the proceedings, my lords. And subsequently, my lords, they have not taken any action to move further. And even they are not determining anything, my lords, and they are also, they are not proceeding with the acquisition proceedings, my lords.
So what do you want to do now? You want them to quash the proceedings?
Crash the proceedings, my lords, because my lords, final notification has been passed in the year 2010, my lords.
And you come to the court 6 years thereafter.
Please, please. My lords, we have waited, my lords, repeatedly they were trying, my lords. So, and they were also requesting
What is
them.
your
to
stand?
consider-
For KDB.
Huh?
Page and service.
Award pass ಮಾಡಿಲ್ವಾ?
No, my lords. Award has not been passed. And when we have made a request, my lords, they have issued the endorsement stating that, my lords, they have also requested the authority to, with a recommendation, my lords, to stop the proceedings. as per
ಸರ್ಕಾರದವರು
annexure-
ಒಪ್ಕೊಳ್ಳಿಲ್ವಂತೆ.
as per-
Government didn't agree to give up.
So, please, please. And as per annexure J, my lords, there was a proposal for not to proceed with the acquisition proceedings. Recommendation for dropping the proceedings. And we have also made a request, my lord, subsequently. They have said, my lords, they have not at all issued any notice thereafter also. With regard to that also, they have issued the endorsement.
Where's the endorsement saying that they don't want the lands?
My lords, it is as per annexure J, my lords, in page 54, my lords. There was a proposal. And the last paragraph, my lords.
18 is, what is the date of this?
My lords, this is. There is.
Annexure J 51. 51.
As per annexure K, my lords, endorsement issued by the They have not even issued the notices to them, my lords, the petitioners.
ಜಮೀನು ಇದೆಯಾ ಅದ್ರಲ್ಲಿ?
Please, and the petition.
Number?
Total extent is 26 acres of the land belonging to the petitioners, my lords.
The page 56.
Yes, there are the petitioners 1 to 11 minutes.
The page number 56 lands, huh?
Please.
What is page 56?
Page 56 minutes, annexure J minutes. Please, minutes, in this also minutes, total extent is 72 acres, 31 guntas. Out of this minutes, the petitioners are 1 to 11 are owning the extent of 26 acres minutes about.
No award is passed so far?
No, my lords.
That in this case, is Chandrasekhar P. Chandrasekhar arguing the matter in the court, the RSA matter, my lord. He seeks next week, my lord. He requested, my lord, to.
For 14 years, they have not passed an award.
ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅವ್ರು he is arguing the matter on the RSA.
Award pass ಮಾಡಿದಾರ?
Award pass.
Is the new.
Release.
Advocate on record is not well, lordship. Kindly tell me.
What is the matter about?
It is about allotment of site. In year 1987, site was allotted by the BDA to the petitioner.
ಪ್ರಭಾಕರ್ ಇದು? ಏನ್ ಪ್ರಭಾಕರ್ ಕೇಸ್ ಇದು? ಸರಿ.
In 11/9/57 at annexure A, page 10 lordship. In subsequent to that allotment, the petitioner has approached various time to the BDA to.
ಸೈಟ್ ಇದೆಯಾ? ಇನ್ನೂ ಸೈಟ್ ಇದೆಯಾ?
Site ID.
Site ಇಲ್ಲ, site ಕೊಡ್ಲಿಕ್ಕೂ ಬರೋದಿಲ್ಲ. Is directly covered by the judgment of this honorable court as well as the Supreme Court. Under the rules, my lord, within the particular time, he has to pay the full amount. He has not paid that amount.
Lordship,
He has not sought for extension of time also.
they issued the notice to the petitioner, but that notice has not.
Notice is
for-
inconsequential.
They are admitted in their order itself, in annexure E. They are admitted that notices are not served to the petitioner. Without hearing the petitioner, without providing opportunity of her to the petitioner, that annexure E order has been passed.
No,
I can,
you-
I
you are-
kindly see annexure B lordship, B and C. Various occasions, petitioner approached the BDA and filed representations for the.
ಅವಾಗ?
In year 1989, 1988, 1999,
ಇದೆ?
92, page 15. At annexure C2 and annexure C3 on 1991.
88 ಕೊಟ್ರಲ್ಲ ನೀವು? Did you at least pay the money at annexure B, page 16? You ask for the site, let us assume they received it. So you are
But
aware of the
but they're
allotment?
not confirming us to pay it.
Now,
What is the
please-
amount are you?
Please read the first paragraph. A site measuring 40-60 site, measuring so and so. First stage was allotted to me. So you are aware of the allotment,
Page number.
16. ನೀವು ಕಾಸು ಕೊಡ್ಬೇಕಂತ ಗೊತ್ತಿರ್ಬೇಕು ತಾನೆ?
I have been allotted the side bearing number 413 of
first stage of so and so block in all initial amount deposit have been fulfilled the requirement. So far, I have not received any information from your regard site. I am ready to pay the balance amount cost of the site. Please arrange to issue the possession of the site earlier. I have requested Annexure C3, case 16,
Page 16, 1991.
Annexure C, let's see.
B ನೋಡಿ first.
The site measuring 40 into 80 bearing number 413 of so and so allotted to me. I meet several occasions to the concerned person on your office. I am not given proper reply. Position of the site is also not given to the site is also not given.
So you are aware of the allotment in year 89 itself.
Yes, sir.
ಮತ್ತೆ ಕಾಸು ಕಟ್ಬೇಕು ತಾನೆ.
ಅದು ಎಷ್ಟು ದುಡ್ಡು ಕಟ್ಬೇಕು ಏನ್ ಅದು ನಮ್ಗೆ ತಿಳಿಸ್ಲೇ ಇಲ್ಲ.
ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಆಗಲಿ ಎಷ್ಟು ಕಟ್ಬೇಕು ಎಷ್ಟು ಬಾಕಿ ಇದೆ ಅಂತ ಹೇಳಿರ್ತಾನೆ.
ಕೈಂಡ್ಲಿ
ಸೈಟ್ ಏನಾಗಿದೆ ಅದು? ವಾಟ್ ಇಸ್ ಹ್ಯಾಪನ್ಡ್ ಟು ದಟ್ ಸೈಟ್? ಆ ಸೈಟ್ ಏನಾಗಿದೆ?
ಸೈಟ್ ಸ್ಟಿಲ್ ಇಸ್ ಪೆಂಡಿಂಗ್ ಲಾರ್ಡ್ಶಿಪ್.
ಸೈಟ್ ಬೇರೆಯವರಿಗೆ ಅಲರ್ಟ್ ಆಗಿರ್ಬೋದು.
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಕರೆಕ್ಟ್ ಆಗಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಏನಂತ ಹೇಳಿದಾರ?
ಇಲ್ಲ ಇದು annexure A kindly be seen.
No, if
Allotment letter itself says.
If the site is not allowed to anybody, give it to him with interest.
No, it cannot be given, cannot be given. My lord, under prescription law, that lapses. It is not.
ಅದಕ್ಕೆ ಹೇಳಿದೆ, if you have allotted to somebody, I'll close. If it's not allotted.
Even if it is not allotted, he will not be entitled. My lord, the reason is this, my lord, he has not paid anything except the registration fee. Annexure A kindly be seen, my lord. Annexure A.
Then how did you allot?
My lord, it lapsed in 1987 itself.
No.
He says he has made representations. These representations are not there. It's a got up done document.
ಇಲ್ಲ 2,500 ರೂಪಾಯಿ ಅಲಾಟ್ಮೆಂಟ್ ಇದಲ್ವಾ ಅವರು ಕೊಟ್ಟಿದ್ದು?
2,500 ರೂಪಾಯಿ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಫೀ.
ಇಲ್ಲ 1,500 ಅದು ಬೇರೆ.
2.5
ಅಲ್ಲ 2,500. ನೋಡಿ annexure A ನಲ್ಲಿ 3rd ಕಾಲಮ್ ಮತ್ತೆ ಉಳಿದಿದ್ದು 47,400 ರೂಪಾಯಿ ಕೊಡ್ಬೇಕಾಗಿತ್ತು. 90 ದಿವಸದೊಳಗೆ ಕೊಡ್ಬೇಕಾಗಿತ್ತು, ಕೊಟ್ಟಿಲ್ಲ. ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮಿಂಗ್ ಇದೆ, ಅದಕ್ಕೂ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿಲ್ಲ.
ಇಲ್ಲಿ ಕಮ್ಯುನಿಕೇಶನ್ ಗ್ಯಾಪ್ ಏನಾಗಿದೆ ಅಂದ್ರೆ
and the prescription law says it lapses. And the registration fee, what is the initial fee?
Where have you said in it?
That has been discussed by the division bench in that judgment, my lord. And
objection ಅಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿದಾರೆ ಅದು ಅಲಾಟ್ ಆಗಿದೆ ಬೇರೆಯವ್ರಿಗೆ ಅಂತ?
ನೋ ಲೋರ್ಡ್ಶಿಪ್.
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದೆ ಅದರಲ್ಲಿ
ಹಾಕಿದ್ದೀರಾ?
Make a statement as whether the site is available or not.
No, I'll make a statement, my lord, but it cannot be, my lord, is because of that judgment, my lord, Lakshmi kindly go through those two judgments. Because once the law says, my lord, I have no power or authority, my lord, I can't open this fence to somebody come and grace their cattle there.
In their objection, they are not told whether that site
It
is
is-
allotted to
it's
the
very clearly-
somebody else.
very
It's
clearly
vacant
said-
lordship. And we are adhered to all terms and conditions which is imposed by this honorable court.
ಇದ್ರಲ್ಲೆಲ್ಲ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ರು ಆತರ? ಇದ್ರಲ್ಲೆಲ್ಲ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ರು. ನೀವೇನಾರು ಕೊಟ್ಟಿದ್ರೆ ಶೋಕಾಸ್ ನೋಟಿಸ್?
ಶೋಕಾಸ್ ನೋಟ್ ಕಳಿಸಿದ್ದು ಎಲ್ಲವೂ ರಿಟರ್ನ್ ಆಗಿದೆ, ಯಾಕಂದ್ರೆ he has left the registered.
ಎಲ್ಲಿದೆ ಅದು?
ನಾನು ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ, ನನ್ನ 7/3/24ಕ್ಕೆ ಸಾರಿ.
Now make a statement regarding the present status of the site and also produce the allotment file, let us see. ಏನಾರು ಮಾಡಕ್ಕಾಗುತ್ತಾ ಅಂತ.
ಅಲ್ಲ ಅಲಾಟ್ಮೆಂಟ್ ಲೆಟರ್ ಬರೋದಿಲ್ಲ ಮ್ಯಾಮ್.
State as to whether
12/12/2022 ನಲ್ಲಿ
site bearing number 413 IM 413 situate in HPR first stage, second block, has been allotted to any other person. And also produce the original allotment file relating to IM 413, relist on. If it's allotted to somebody,
But it is vacant, Lordship, now.
First, we kindly see those two judgments, my lord.
ನೋಡ್ತೀನಿ ಫೈಲ್ ತೋರಿಸಿ first.
Those, kindly record that judgments, my lord.
I'll consider everything first, produce the documents, then let us see.
Lordship, record that, my lord.
I don't consider
For
for
a
the
particular reason, my lord.
files and memo along with two judgments. One judgment ಅಷ್ಟೇ ಅಲ್ವಾ?
Lordship, they have
Two
only
judgments have-
disputed regarding the addresses only.
Last time also I produced it, my lord. For some reason,
The file and the status, what exactly has happened ಅದನ್ನ ಹೇಳಿ.
please, my lord. I'll try to get it, my lord. The reason is this, my lord. I got some pressure from the inside. That is how, that's why I am saying this.
ಅಲ್ಲ ಫಸ್ಟ್ ಸೈಟ್ ಇದ್ರೆ let us see if something can be done. If the site is not there, I'll close him.
Even otherwise, my
Please,
lord.
please, Lordship.
Law cannot be, see, I cannot violate even the.
ಮಾಡ್ಬಿಡಿ, ನಾವಿರ್ತೀವಲ್ಲ ನಾವು
ಅಲ್ಲ,
ಆರ್ಡರ್
ನೀವು ಸಹ ತಪ್ಪು ಮಾಡಿದ್ದು ಹೇಳಕ್ ಆಗಲ್ಲ ನಾನು.
ಇಲ್ಲ, ಏನೋ ಒಂದ್ ಸೈಟ್ ಸಿಕ್ಕಿರುತ್ತೆ, ಅವ್ರಿಗೆ ಕಾಸು ಕೊಡಂಗಿದ್ರೆ ಇವಾಗ ವಿತ್ ಇಂಟ್ರೆಸ್ಟ್.
ಲೀಗಲ್ ಫ್ರೇಮ್ವರ್ಕ್ ಪ್ರಿಸ್ಕ್ರಿಪ್ಷನ್ ಲಾ ಅದನ್ನ ಬಿಟ್ಟು ನಾವು ಮತ್ತೆ ಇದು ಏನಾಗಿದೆ ಅಂಡರ್ ಬಾಕ್ ಓಪನ್ ಆಗಿ ಒಂದು
ನಾನು
ಬ್ಯಾಚ್ ಆಫ್ ಪಿಟಿಷನ್ಸ್ ಈಗ ಇಟ್ ಇಸ್ ಬೆಂಡಿಂಗ್ ಸ್ಟೇಟ್ ಇಟ್ ನಾವು.
ಆ ಸೈಟ್ ನೀವು ಅಲಾಟ್ ಮಾಡಿದ್ರೆ ಇಷ್ಟು ವರ್ಷ ಸುಮ್ನೆ ಕೂತ್ರೆ ನಿಮ್ದು ತಪ್ಪಾಗತ್ತಾನೆ.
ಅಲ್ಲ ಅಲಾಟ್ಮೆಂಟ್ ಇಸ್
87ನೇ ಇಸ್ವಿ
ನೆವರ್ ಗೆಟ್ಸ್ ಎ ರೈಟ್ ಟಿಲ್ ಇಟ್ ಇಸ್
Correct. You cannot sit on the property for 20 years and then bring forward all this argument. You should have also taken steps in accordance with law. You are also bound by the law.
a person who has not paid a single pipe, he cannot
Okay.
come and say he has no
They
legal
should
right.
have immediately sent him a notice saying that it is cancelled.
My lord,
And you should have allotted to somebody
Annexure
else.
A may kindly be seen, my lord, that itself is the notice. Annexure A. Thereafter, my lord, my lord, I will point out that I have stated in my
File produce ಮಾಡಿ.
12/12/22.
Produce the file.
Statement, my lord, I have said para 14, my lord. Para
Produce the file, let us see.
Please, my lord.
Please, please, please.
Take April.
File ಕೊಡು.
ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ ನನಗೆ ಬಹಳ ಥ್ರೆಟನಿಂಗ್ ಇದೆ.
ಯಾರು?
ಸಂಬಡಿ ಇನ್ಸೈಡ್
ಇನ್ಸೈಡ್ ಅಂದ್ರೆ BDA ಇನ್ಸೈಡ್.
ಕೊಟ್ಬಿಡಿ ಮಾಡಿಬಿಡಿ ಅಂತ.
ನೀವು ಆ ಸೈಟ್ ಅಲಾಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ನಾನು ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ. ಯಾರು
Even otherwise, my lord, I will argue to that extent, my lord, because
that is why you are so angry.
please, I am sorry.
ಯಾಕ್ರೆ ನೀವ್ ಯಾಕ್ರೆ ಅವ್ರನ್ನ ಥ್ರೆಟನ್ ಮಾಡಕ್ ಹೋಗ್ತೀರಾ?
ಇವರಲ್ಲ ಒಳಗಿನವರು
ಅವರೇ
ಇವರಿದ್ದಾರ ಇಲ್ಲೋ ಗೊತ್ತಿಲ್ಲ. ಅಲ್ಲ, this has become a racket there.
I know.
This has become a racket.
ನಾವು ಅಡ್ರೆಸಸ್ ಕೊಟ್ಟಿರು ಸಹ ನಾವು ನಮ್ಮ ಅಡ್ರೆಸ್ ಸರ್ವ್ ಮಾಡಿಲ್ಲ.
ಆಯ್ತು. Passed over once, isn't it? You have to argue. Seal number 5. Which is your serial number? Ready to argue? I have tomorrow.
There is second set of writ petition where Mr. Krishna appears. There I have withdrawn, every petitioners have withdrawn the writ petition. Seventh petitioner is remaining, it seems, but my learned friend points out, 7 petitioners' land is not acquired. So, my lord,
Record your statement, 7th respondent's land.
My
is
lord,
not-
seventh response there is no land, my lord. My lord, kindly see the page, my lord, 40, ink page, my lord.
Page?
Ink page, my lord, I think 40, my lord, in second petition. My lord, in the second
set of writ.
second set.
51474.
In the cause list.
How the other
it's
lay.
dismissed as withdrawn, dismissed as withdrawn.
Only the seventh petitioner is concerned, my lord. My lord, your lordship kindly see.
Serial number ಎಷ್ಟು?
Serial number 21 ಬರ್ತದೆ preliminary.
ಇಲ್ಲ, ನನ್ನ ಹತ್ರ page 41 ಇರೋದು
40 ನಮ್ಮ ಅದರಲ್ಲಿ 40 ಅಂತಲ್ಲ preliminary notice. Serial number 21 ಬರ್ತದೆ. Page 40 ನಮ್ಗೆ ಗೊತ್ತದಲ್ಲಿ
ಕೃಷ್ಣಪ್ಪ.
ಕೆ ಕೃಷ್ಣಪ್ಪ ಬಿನ್ ಯಂಕಪ್ಪ 22 ಗುಂಟಾಸ್. ST ಚಂದ್ರಶೇಖರಪ್ಪ ಬಿನ್ ತಿಮ್ಮರಾಯಪ್ಪ 18 ಗುಂಟಾಸ್. ST ಚಂದ್ರಶೇಖರಪ್ಪ is the 7th petition ಅಲ್ಲಿ 18 ಗುಂಟಾಸ್. My lord, kindly thereafter, my lord, kindly see in the ink page, my lord, the 100. Ink page 100. My lord. That is the 18-3 order, my lord. The relevant page, serial number 21, my lord.
100.
21, your lordship.
Page number 100.
Page number 100, ಅದರಲ್ಲಿ serial number 21.
The internal page ಏನು?
Internal page 9. ಅಥವಾ 85 ಏನೋ ಎರಡು ನಂಬರ್ ಇದೆ. ಅದರಲ್ಲಿ serial number 21.
ಕೆ ಕೃಷ್ಣಪ್ಪ.
ಕೆ ಕೃಷ್ಣಪ್ಪ ಬಿನ್ ಯಂಕಪ್ಪ ಬಿನ್ 22 ಗುಂಟಾಸ್ ಹಾಜರು. ST ಚಂದ್ರಶೇಖರಪ್ಪ ಬಿನ್ ತಿಮ್ಮರಾಯಪ್ಪ 18 ಗೈರು ಹಾಜರು. ಆದೇಶಿತ ಕಾರ್ಯದಾರರು ಹಾಜರಾಗಿ ನಮ್ಮ ಜಮೀನು ಫಲವತ್ತಾಗಿ ಪ್ರದೇಶವಾಗಿದ್ದು ಭೂ ಸ್ವಾಧೀನದ ಪ್ರಕ್ರಿಯೆಯಿಂದ ಕೈಬಿಡಲು ಕೋರಿರ್ತಾರೆ. ಸದರಿ ಖಾತೆದಾರ ಹೇಳಿಕೆಯಂತೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಇವರ ಆಕ್ಷೇಪಣೆಯಲ್ಲಿ ಯಾವುದೇ ಸಮಂಜಸವಿರುವುದ ಕಾರಣವಿರುವುದಿಲ್ಲ ಮತ್ತು ಜಂಟಿ ಅಳತೆ ವರದಿಯಂತೆ ಸರ್ವೆ ನಂಬರ್ 94 1 ಎಕರೆ ವಿಧಿ 28(1) ಅಡಿಯಲ್ಲಿ ವಿಸ್ತೀರ್ಣ ನಮೂದಿಸಿದ್ದು ಈಗಿನ RTC ಅಂತೆ ಕೇವಲ 22 ಗುಂಟೆ ಕೆ ಕೃಷ್ಣಪ್ಪ ಬಿನ್ ಯಂಕಪ್ಪ ಇವರ ಹೆಸರಲ್ಲಿ ಖಾತೆ ಇದ್ದು 18 ಗುಂಟೆ ಪ್ರದೇಶ ST ಚಂದ್ರಶೇಖರಪ್ಪರ ಪಾಣಿ ರದ್ದಾಗಿದ್ದು JMCಯಲ್ಲಿ ಈ ಪ್ರದೇಶವನ್ನು ತಗ್ಗಿಸಲಾಗಿದ್ದು ಇದನ್ನು ಭೂಸ್ವಾಧೀನದಿಂದ ಕೈಬಿಟ್ಟು ಉಳಿಕೆ 22 ಗುಂಟೆ ಅಂತಿಮ ಭೂಸ್ವಾಧೀನಗೊಳ್ಳಲು ಆದೇಶಿಸಲಾಗಿದೆ.
Only acquired 22 gunters.
22 gunters. My lord, the final notification is, my lord, 11th page is page 76, my lord. Maybe page 76, but the page number may not be. Final notification, there also serial number 19.
Number?
19, serial number 19. Sorry, my lord, the page number is.
ಕೆ ಕೃಷ್ಣಪ್ಪ.
ಕೆ ಕೃಷ್ಣಪ್ಪ ಬಿನ್ ಯಂಕಪ್ಪ
22 gunters.
22 ಗುಂಟಾಸ್. ಅವರದ್ದು ಲ್ಯಾಂಡ್ ಇವಾಗ 7th petition ಲ್ಯಾಂಡ್ ಇಲ್ಲ, ಇವನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
The petition was originally filed by 7 petitioners challenging the acquisition of various extents. The 7th petitioner is one T.S. Chandrasekhar and his land measuring 22 gunters in survey number 96/4P3 was
his land is 18 ಗುಂಟಾಸ್.
stated ಅಲ್ಲ, ಇಲ್ಲೇನೋ ಆತರ ಬರ್ದಿದ್ದಾರೆ.
ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ. ಆ ಪಿಟಿಷನ್ ಅಲ್ಲಿ 22 ಗುಂಟಾಸ್ ಅಂತ ಹೇಳ್ತಾರೆ.
In the name of
22 ಗುಂಟಾಸ್
the
ಬಿಲಾಂಗ್ಸ್ ಟು
petitioner
ಫಸ್ಟ್
is
ಪಿಟಿಷನ್.
T.S. Chandrasekhar. Lord Consul, the petitioner points out that under the preliminary notification, as serial number ಯಾವುದು?
Serial number 21, my lord.
The land measuring 22 gunters of K. Krishnappa and the land measuring 18 gunters of ST Chandrasekharappa were notified. ಮತ್ತೆ ಹೆಸರು ಟ್ಯಾಲಿ ಆಗಲ್ವಲ್ಲ?
ಅಲ್ಲ ಇಲ್ಲ, ಇದರಲ್ಲಿ ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಕೆ ಕೃಷ್ಣಪ್ಪ.
ಅಲ್ಲ, ಇಲ್ಲಿ T.S. ಚಂದ್ರಶೇಖರ್ ಅಂತ ಇದೆ, ಇಲ್ಲೇನೋ
serial number 19 ಕೃಷ್ಣಪ್ಪ.
ಅಲ್ಲ, ಅದು
ST ಚಂದ್ರಶೇಖರಪ್ಪನ ಜಮೀನು ಎಕ್ವೈರ್ ಆದಂಗ್ ಕಾಣಲ್ಲ, ಕೃಷ್ಣಪ್ಪಂದ್ ಎಕ್ವೈರ್ ಆದಂಗ್ ಕಾಣಲ್ಲ.
ಅಲ್ಲ, ನೀವು ಇಲ್ಲಿರೋದು ಯಾರೋ ಚಂದ್ರಶೇಖರ್ ತಾನೆ?
ಹೌದು.
ಇವ್ರು ಯಾರು, ಅವ್ರು ಯಾರು?
ಅಲ್ಲ, ಅವರೇ ಇವರು. ಅಲ್ಲಿರುವ ಚಂದ್ರಶೇಖರ್, ಇಲ್ಲಿರೋ ಚಂದ್ರಶೇಖರ್.
ಅಲ್ಲಿ TS ಅಂತ ಹೇಳಿದ್ರೆ ಇಲ್ಲಿ ST ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಯಾರ್ಯಾರು ಬಂದು ಕೊಡ್ತಾರೆ ಅವಾಗ ಹಾಕ್ಬೇಕಾದ್ರೆ.
ಈ ಕೃಷ್ಣ has been notified in the 28-1 notification. He points out that the ST Chandrasekharappa that is referred to in the preliminary notification is actually the seventh petitioner and the initials have been misplaced and he has been notified as T.S. Chandrasekhar. Land Counsel for the petition also points out that in the land acquisition officer passed an order under section 28(2) in the following terms. Page
100, serial number 21. Serial number 21.
96 ಅಲ್ಲ?
86, page 20, serial number 21.
Page 85.
85.
It is also pointed out in the final notification. The extent of only 18 guntas of
22 guntas.
22 guntas of K. Krishnappa has been included and therefore the lands of the petitioner has not been notified. A perusal of the notifications as well as the orders passed by the land acquisition officer makes it abundantly clear that the land of S.T. Chandrasekharappa in 96/4P measuring 18 guntas has not been notified. Though the name of the Khatedar is shown as S.T. Chandrasekharappa instead of T.S. Chandrasekhar. In my view, since the land of the seventh petitioner has not been acquired, there would be no need to quash the notifications except clarifying that the lands of the seventh petitioner have not been notified and therefore his lands cannot be taken over by the KADB. Writ petition accordingly disposed of. Either 8 57231.
Please, there not only two petitioners are pressing the writ petition. The rest is rejected. So far as these two petitions are concerned, Lord, page 5 of the writ petition, the details of the lands acquired are shown, Lord. Second petitioner, village Sarthi, Lord, 4 survey numbers which are subdivisions of 100/3 and 100/1. Lord, the crop that is grown, Lord, also shown, Lord, in the last column. So far as third petition is concerned, also same Sarthi village, subdivisions of survey number 100 and 96, Lord, are acquired. Lord, paddy, coconut, sugarcane, jawar, and cotton is grown. Now, Lord, notifications are annexure A, B, and C, Lord. Now, our contention is this, there is a tank, big tank, Lord, Pondachi Kere, from which Kere, Lord, tank water, Lord, comes to this Sarthi village. Entire Sarthi village, Lord, is in fact is a fully developed agricultural lands. Now, state government had invested 60 lakhs to bring this water channel, Lord, to this village. And as a result, Lord, all the record of rights shows, Lord, growing paddy crops and the like, Lord, the lordship says annexure G1, the record of rights. Annexure G, Lord.
What was the total extent of land notified? 97 acres.
297
Total. They formed an industrial area now?
Please, Lord.
Industrial area ಆಗೋಗಿದ್ಯಾ?
ಏನಿಲ್ಲ, ಅದು ಇಲ್ಲಿ ಬಿಟ್ಟು ಹರಿಹರ ಟೌನ್ ನಲ್ಲಿ it is about 10-12 kilometers from this village. Vast lands they have acquired. All those lands are lying fallow. Those they have acquired not decades ago. All industrialists, some industrialists were started, they closed. Kirloskar factory also started, they closed. No industries are there. Only vacant lands are there, still lying, Lord, unused. Now this land, Lord, which is a fertile land, are sought to be acquired because some of the villagers, Lord, sold their soil to the brick factories and made money. Now there are 5 to 6 feet depth, Lord, the level has undergone. some of these persons who have sold my lord soil in conjunction with the local politicians have my lord influenced the KDB my lord to acquire this land. Per acre, they will get 25 to 30 acres. That is the scheme, my lord, how lot of money and the jurisdiction is being wasted, my lord, is our
Other
case.
petitioners are also recipients of that money.
Petitioners, so far as we are concerned, my lord,
Other petitioners.
the two petitioners, my lord, there is borewell in our land, the present two petitioners, and there is fertile crop is grown, my lord, your lordship says.
ಏನ್ ಮಾಡಿದಾರೆ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಏರಿಯಾ ಮಾಡಿದಿರಾ?
ಅದರಲ್ಲಿ ನಾನೇ ಪೇರ್ ಆಗ್ತೇನೆ.
ಯಾರ ಪೇರ್ ಆಗ್ತಾರೆ?
ಅಂಬರೀಶ್ BN. ಅಂಬರೀಶ್ BN.
ಬರ್ತಾರ ಅವ್ರು ಅಂಬರೀಶ್ ಅಂತಾರ.
ನಂಬರ್ ಇಲ್ಲ.
I'll ask him to fill an affidavit as to what exactly is the status of this.
I will inform the law officer.
Please.
I have produced the photographs of these lands, my lord, where
Counsel for the petitioner submits that though the lands were notified to be acquired for the purpose of industrial area, and though some of the landowners have accepted compensation, no industrial area has been formed, though more than 11 years have elapsed. Learned counsel also places reliance on the photographs to indicate that possession has remained with the petitioners and they are cultivating the lands which are fertile lands.
paddy, sugarcane.
In view of the said statement, the KDB to file an affidavit and state as to whether industrial area has been formed in 257 acres, 35 guntas of land acquired in Sarthi village and Kruparli. We list on notified preferably along with a sketch indicating the formation of the industrial area. Please inform him.
I will inform.
The case, my lord, where the lands which are not even acquired are being put to use, my lord, from August of last year. Matter has come up on several occasions, my lord, and I've relied upon Annexure L, which is the joint report along with NHAI, my lord, page 149. It's the report of the ADLR. Page 149, please.
It's an admitted fact that, my lord,
Next
excess
year,
land has been made use of. Last occasion, I made my submission saying that excess land has been made use, and the dumping yard, it has become the dumping yard by storing the water, and now it has, all the debris have been removed. Now, whatever the excess land has been used, it will be, compensation will be given as per by following the due process of. That is the information received by the.
When?
That is NHAI has to.
My lord, I'll answer that. My lord, now, my lord, the instructions that I've received says, my lord, that admittedly, my lord, certain lands have been acquired, put to use in excess of what was acquired. Now, the remedy, that now I've been instructed that there is a bridge has also already been constructed there. Now, my lord, now, since that it has been done in public interest, my lord, so what, the only remedy that the respondents would otherwise also have would be compensation.
No, I can ask you to remove the bridge and give back the land.
My lord,
You cannot do an illegal thing in public interest.
Yes, my lord, I agree, my lord, but then now what we propose to do is, my lord, we'll have to acquire this land now. We'll have to issue 3A notifications and 3D notifications, and then issue the fresh notification notifying that these lands would be acquired, my lord. But, my lord, before that, proceeding with that, my lord, we have also sought an additional clarification from the ADLR stating that to what extent the reference point to show exactly from where to where, from which starting point to what points have the excess land been acquired, because the same certain lands belonging to the petitioners were acquired by following the due process of National Highways Act. In excess of that, certain additional lands, 12 guntas of land been acquired. So from where to where this 12 guntas of land has been.
Shouldn't you know that? You knew what, to which point you had acquired lands. Excess you should know. Why do you want?
What happened is transpired is the concessionaire, while constructing, had encroached. There is no change in alignment. Alignment, what had originally been proposed is being followed. But what happened is due to a human error on part of the concessionaire went on to construct a little bit extra, over and beyond what was proposed by NHAI.
What is the total extent according to the report?
According to the report,
11
it's
guntas,
11
my lord. 11 guntas. And this is a farmer, my lord, agricultural
7
land.
guntas has been acquired. Over and
What was the cost that you paid there when you acquired the land?
My lord, even that, they've still not passed the award. We have moved a contempt, my lord, that the division bench had directed the NHAI to pass an award within a certain time. They directed the petitioner, you give possession within 15 days, they will pass the award. In February last year, we gave possession within 15 days. Till date, my lord, they have not yet passed the award.
When was this done?
My lord, if I can just take my lord.
Give me the date.
Yes, my lord. My lord, at page 135, annexure J, that's the division bench order.
Just give me the date.
Yes, my lord. The division bench order was 3rd February 2023.
Until today, award is not passed.
Please, my lord. Thereafter, they sought for an extension of 1 month. A 1 month extension was given to them, which got over in November. Till now, they have not passed the award. And again, this petitioner, my lord, has been forced to file a contempt petition to try and move the division bench to at least get the award passed in that.
order, we have to pass it under the RSCT.
This, my lord, is the extension that they sought for.
What was the total extent that was acquired under the notifications?
Please, my lord.
The award has been passed, the initial award.
In square meters, my lord. It's at page 90. It's extracted in the single bench order. Page 90, please. The second page of the. And even the first round, my lord, though they are bound by the 2013 Act, the petitioner is compelled to come to this honorable court to get a declaration as such. Page 90, please. Para 2. These are the lands that have been acquired from the petitioners.
Who's your head of the department?
The project director, National Highway would be.
Ask him to be present before the court.
I can ask for clarification regarding why compensation.
Is he above the law?
No, Milord.
Then he says November 23, the contempt court. Direct an award to be passed. That is not passed. You admit that you, by error, took over somebody's land.
The award has to be passed by the SLA, appointed by the central.
Now, what about this?
SLA has to pass an award, then he has to forward it to the National Highway Project Director, then he releases the fund.
So you shoot first and then ask questions later as to who was the person you shot.
The award has to be passed by the SLAO.
Whose job is it to get the award passed? If you want the land, should you not have any interest in this?
Quasi judicial body appointed by.
Let both of them come and be, let them be present.
Yes.
So for the acquired lands, my lord, no award. And over and above the acquired lands, now they've taken possession, my lord.
Third respondent, huh? SLAO.
NHAI.
Your lordship, one humble submission.
Let both of them come and.
Third and fourth respondent.
One humble submission, your lordship. If your lordship can see the annexure E of their page number 39 of their writ petition, the initial award was passed by the SLAO, your lordship. But then subject to that, they had challenged it in the WP. They had filed a writ before enhancement of compensation, against which we had preferred an appeal. But then we withdrew the same, your lordship. That enhancement award was supposed to be passed within the stipulated time as ordered by this honorable court. So regarding that, again, the orders would have been passed. We will seek instructions on that, your lordship. One accommodation.
Let them be present. Let both of them be present. Because you seem to be taking it very casually.
No, Lord, we undertake then, my lord, 1 week, not 1 week's time, because now we've asked to pass a fresh award and also to pass another notification, my lord. Another notification.
What is the probable cost of this acquisition?
Lord, what is
11 guntas?
11 guntas, we'll have to go, my lord, how it is calculated is this, my lord.
Probable cost.
Your lordship will have to
see previous 3 years of sale deeds have taken.
You know all that. What is the compensation that you paid for the abutting lands? Do you have any idea as to what is the amount that is paid?
I'll find that out, my lord. Because for us, my lord,
Deposit that money now, pending framing of an award.
Yes.
Let both of them be present.
My lord, may kindly avoid.
Why?
I shall undertake, my lord. I shall undertake that.
No, I'm not doubting your sincerity. I'm doubting their sincerity.
Lord,
That they can take the court for granted, they
No,
can
I-
take everybody for granted.
No, I shall convey, my lord, the court's, what court's observations I shall convey today itself, my lord. Now itself, my lord. I shall convey it in strong words, my lord.
I'll have it on Friday. By that time, if you don't have anything specific and positive, they'll appear before the court on Monday or on Tuesday.
But I shall.
Please. Relist on Friday. I'm doing this only because of your personal assurance. Because I think if they come before the court, then they'll realize the seriousness of this.
I shall convey it immediately, forthwith.
Friday.
Grateful, Your Lordship. If Your Lordship, sorry to interrupt Your Lordship, Friday.
Friday.
Friday, Rajana.
28th, Thursday.
Thursday, my lord.
Grateful.
Yes, Murugesh.
That they should comply with the terms of Junjamam.
ನಾನು ಡಿಸ್ಪೋಸ್ ಮಾಡಲ್ಲ, ಇಟ್ಕೊಂಡಿರ್ತೀನಿ, ಯಾವಾಗ ಕೊಡ್ತೀರಿ ಹೇಳಿ ಅವಾಗ ಮಾಡ್ತೀನಿ. ತಿರ್ಗಾ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ರಿ, ತಿರ್ಗಾ ಏನೋ ಅಂದ್ರೆ ಇಟ್ಟು ತಿರ್ಗಾ ಇಟ್ ವಿಲ್ ಗೋ ಆನ್ ಎಂಡ್ಲೆಸ್ಲಿ. When will you complete the formalities?
Will have to be after this one.
Site number?
Site, my lord, 1381 of 8th block Vishwasa left.
Number ಕೊಡಿ.
They are submitted to report after given direction from the court.
3181.
3181.
3181.
Yes,
3181.
How much time do you require?
After this election, after election,
After vacation?
after elections.
I'll record your statement.
Lordship may dispose it of directing us to give. One statement for the review.
The prayer in this petition is for a direction to be issued to the respondents to consider the application of the petitioner for allotment of site number 3181, first block measuring 30 by 40, or site number 1463, 8 situated in 8th block of Sir Vishweshwara layout. Lord Constable, the petitioner places on record the correct dimension report of site number 3181 and also produce the file noting to indicate that this site is available for allotment. Noting ಇದೆಯಾ ಇವರು ಕೊಡ್ಬೋದು ಅಂತ ಇದರಲ್ಲಿ?
ಇಲ್ಲ.
ಇದರಲ್ಲಿ ಇದೆಯಾ?
ಇಲ್ಲ. Noting it. It only says whether it's available for allotment and vacant.
Since it is not in dispute that the site of the petitioner was acquired and that she would be entitled for allotment of an alternative site, it would be appropriate to direct the BDA to allot to the petitioner site bearing number 3181 from a first block measuring 30 feet by 40 feet within a period of 2 months from today. Writ petition is accordingly disposed of, notwithstanding the said disposal, post this matter on so and so for reporting complaints. That day you will file a complaints report.
Yes. Not one request, subject to he complying Junjammas case direction.
Needless to state that the petitioner shall comply with the requirements as stipulated in Junjammas case.
28, public.
That one submission, my lord. On 3/1/2008, the interim order was modified in the suit filed in OS 732. On 4/1/2008, agreement of sale is executed. Agreement of sale is drafted by learned friend Mr. Parshuram Hattarkar. On 10/1/2008, the sale deed is executed. They drafted in his office, one of his colleagues has signed. Then he issues the legal notice of retiring from the case in the 732, in the month of June. Again, immediately after 2 months, he issues the legal notice and file the suit. And ಅದು ಏನು ಅಂತಂದ್ರೆ he is a party to the, he is a witness to the document. So there is element of pollution, one thing, and at the same time, when there is a conflict of interest, advocate should not appear for the parties. So there is a misconduct, professional misconduct also is there. So these are the facts I wanted to bring you to your lordship's kind notice.
Lordships asked me to read the order.
You want to read the order, ತುಂಬಾ ಜಾಸ್ತಿ ಇದೆ ಓದ್ತೀನಿ ಅಂದ್ರೆ ನಾನು I didn't want.
ಓದಿ ಅಂತ.
ನೀವು ನಂಗೆ ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳಿದ್ರೆ ಸಾಕಾಗಿತ್ತು, ನೀವು ಓದ್ತೀನಿ ಅಂದ್ರೆ ಅದಕ್ಕೆ.
I am sorry, then I am sorry, madam.
ನೀವೆಲ್ಲ ಬಂದ್ರೆ ನಾನು ಖುಷಿ ಆಗುತ್ತೆ, ಬೇಗ ಬೇಗ ಹೇಳ್ಬಿಡ್ತೀರಾ ಅಂತ. ನೀವು ಓದ್ತೀನಿ ಅಂದ್ರೆ ನಾನು ಏನ್ ಹೇಳಿ ನಾನು.
Your lordships, one thing your lordships doubted on that day, with reference to the transaction relating to the checks are concerned. Of course, on that day, I have no full instructions. I could not able to, any of my learned advocate on record, he said something. I wanted to take your lordships to, and logically and so far as those checks are concerned. You had the checks, my lord, issue, we said, my lord, it is based on an independent transaction, I said on that day. My lord, the checks are issued in the light of an agreement entered into between the parties to that effect. That is, my lord, on
10/1/2008.
10/1/2000.
Same date. Same day as the sale deed.
On same day, it is the sale deed. My lord, that check and the agreement, all those things are not even referred to in the compromise petition. It is because it is an independent transaction.
Checks are it.
1 minute. 1 minute.
Like the compromise as a reference that they'll withdraw the 138 proceedings. If they were not related, then the question of them being stated in the compromise.
No, what I wanted to say something. Those proceedings have reached a finality, I wanted to tell. And they says that according to Mr. Ashwath Narayan's on that day submitted, neither the checks are given to us, nor the amount involved in the checks. Now question of, I am handing over the checks would not arise because they are the complainant before the magistrate court so far as dishonor of checks are concerned. In those proceedings, my lord, we made an application for discharge of us. The trial court rejected that application. Then we filed a criminal revision petition before this honorable court. While criminal revision petition was pending before this honorable court, the compromise have taken place in the original suit OS 4023 of 2009. Then those compromise petitions are filed before this honorable court where the revision was pending. This honorable court passed an order saying that in view of closure of the suit between the parties, that pursuing the remedy proceedings under 138 would not arise. Therefore, the criminal revision petition was closed after passing a detailed order in their presence. Then, my lord, the consequent upon that, my lord, the trial court closed that 138 proceedings also. Those proceedings after closure, even after made an application here for reopening of the proceedings in the application under IL number 8,
They are not revived their proceedings, which is
ಇದು recall ಆದ್ಮೇಲೆ ಅದು restoring ಕೇಳ್ತಾರೆ.
regular.
ಇದು compromise recall ಆದ್ರೆ ಮಾತ್ರ they get a right because only then the suit.
I will submit that, I will come to that. Even assuming for a moment, I wanted to argue this, I wanted to address this proposition. Their own affidavit, they refer to that checks are issued in addition to the consideration determined under the sale deed. That appears to be their case.
ಅಲ್ಲ ನನಗೆ ಡೌಟ್ ಬಂದಿದ್ದು ಏನು ಅಂತಂದ್ರೆ, if a person is selling his property because it is being brought to a public auction, he is under distress, he is selling his property. A person who is selling his property is lending you 30 lakhs to purchase the property in the same day.
My lord,
ಅದು ಸ್ವಲ್ಪ ನನಗೆ I thought that's what
my lord, there is other.
If you had paid that 30 lakhs,
My lord, I would.
problem would have come to an end.
My lord,
For some reason you chose not to abide by that terms.
For that, I have got two arguments. Ethically, what your lordship suggested, if I paid 30 lakhs, there would not be any problem at all. And your lordship's mind would be free in asking such a question to me. It would not ask it to me at all, if that is happened. It was not happened. If not, it is happened. Still, my lord, my argument would be, could it be a reasons to recall the compromise?
That's what I will consider now.
That's what.
That's what I want
Now,
to consider.
what ultimately my submission to lordship is, it is based on an independent agreement. It is an independent agreement. Under the independent agreement, it's a loan transaction. There is no reference so far as it's a part of the sale consideration and other things. There is no reference either in the compromise or in the suit or wherever it is. Even in their application also, they refers to, there is a check was issued, it was dishonored, then we filed a complaint, they stopped there. The applications were filed in 2008-16. The criminal revision petition was closed before this honorable court in 2012. 4 years gap was there. It was not disclosed in their affidavit so far as the further things are concerned. They could have been stated. My submission, I wanted to say, my lord, how the things are playing at the hands of the other side. I wanted to bring to your lordship's notice. And ultimate my efforts is certain suspicions which your lordships having in mind so far as the compromise is coming. I am trying to eliminate to what extent it is possible. That is only the efforts I am rendering. My lord, that's what, my lord, the complaint was, my lord, the exhibit P17 at page 192. My lord. It is before the sub-registrar against undervaluation proceedings are concerned. That came to be dismissed, my lord, with our participation, holding that there would not be any undervaluation at all.
ನನಗೆ ಇದ್ರದ್ದು ಹೇಳಿ ಅದೆಲ್ಲ ಆಮೇಲೆ.
Yes.
On 10/1/2008, I have this doubt about the entire transaction.
My lord, I will submit.
I
My lord,
don't understand.
A PCR was filed.
I'll express my doubt so that it will be easier for you. On 4th of January 2008, admittedly, the registered sale deed. According to you, the sale consideration was 50 lakhs, out of which 48.5 lakhs is paid on the same day. 1.5 lakhs, just for 1.5 lakhs, there's no sale deed executed. Then within 6 days, the balance amount, there's nothing in the sale deed, but the entire amount is paid on the 10th. On the 10th, they give a loan of 30 lakhs to you. This is what is troubling me. If a person who is desperate to sell his property,
My lord,
to clear a loan, and you admittedly undertake to clear the loan,
if your lordship strictly examine the record, or I examine the record meticulously, my answer would be, I have no answer for your lordship's questions are concerned on the record. But off the record, there are other developments are there. If your lordship.
off the record, ನನ್ನ ಪ್ರಕಾರ ಅದೇನೋ ಒಂದು ವ್ಯವಹಾರ ಇತ್ತು.
ವ್ಯವಹಾರ ಇಷ್ಟೇನೆ.
ಅದ್ ಎಷ್ಟಿತ್ತು ವ್ಯವಹಾರ?
ವ್ಯವಹಾರ ಇಷ್ಟೇ. ಏನ್ ವ್ಯವಹಾರ ಅಂದ್ರೆ 50 ಲಕ್ಷ ರೂಪಾಯಿ ಬ್ಯಾಂಕಿಗೆ ಕೊಡೋದನ್ನ they indicated as a consideration in the registered instrument. Excess of that, what we have agreed to pay, they have represented to us that, and it is a matter of record, one of the son-in-law of their family is not honest. And they pleaded in their affidavit, at his instance, all these problems have been started and they become bankrupt because of his indulgence. That is their own affidavit. Then the respondent one, my lord, the Sunita is represented to us saying that if whatever the money addition to the sale consideration stipulated in the compromise or that shown, it is a possibility they can snatch that money from me and I would make it empty hand. Therefore, she suggested this arrangement saying that we will treat it as a loan and we can enter into an independent agreement that 30 lakhs, that is the context. Dr. Millard, am I right, Mr.? And on his instruction, I am making. this up.
30 plus ಒಂದೇನು reasonable interest ಮಾಡಿ ಕೊಡಿಸ್ಬಿಡಿ, I'll ask him to close the proceedings here. Reasonable interest. I'm not asking you for the sky. 30 with interest.
Settle ಆದ್ಮೇಲೆ ಎಲ್ಲ ಕೊಡ್ತಾರೆ.
ಅದ್ ಮಾಡಿದ್ರೆ
Maybe listed on Wednesday, my lord, not tomorrow. I will come with a concrete solution. I wanted to.
Where is the property?
Yeah, blood, it is in CT Street.
So ಆ ಪ್ರಾಪರ್ಟಿ ಅಷ್ಟ್ ಕಮ್ಮಿಗೆ ಹೋಗೋದು ಸ್ವಲ್ಪ
2000.
That is not the real fact. That is not the real fact.
Logical argument ಮಾಡಿದ್ರೆ I can disturb their case. Now consciously your lordships put me a question. Now
ನನಗೆ ನೀವು ಅಷ್ಟ್ ಮಾಡಿ, then I'll talk to you.
Very.
You tell me what is the reasonable amount. You are also much more experienced than me. With reasonable interest, I'll ask him to agree. If they don't agree, then let us see.
Please.
I will come back on Wednesday.
4:30.
Wednesday.
Not at
One
4:30.
The real fact is, my lord, see, at the hands of the son-in-law, all this has happened. So they were afraid. So in fact, the defendant number 2 and 3, when they questioned how you have got the execution of sale deed containing that it's a deed of redemption of mortgage, then they have said, in order to save the property, we have got it to our name. This is the fact.
The fact remains you have executed a sale deed. ನಿಮ್ಗೆ ಪೂರ್ತಿ ಕಾಸು ಬಂದಿಲ್ಲ, ಆ ಕಾಸು
Exhibit D52 and D53 is major evidence.
I've told you my mind, so it's up to you.
That is.
ನಾನು ಇವತ್ತು ಅದಕ್ಕೆ ready ಆಗಿ ಬರ್ತಾ ಇದ್ದೀನಿ.
ಅಲ್ಲ,
ಅವತ್ತು ಹೇಳ್ತಿದ್ದೀನಿ, ಬರ್ತೀನಿ ಅಂದ್ರೆ ಸರಿ ಆಯ್ತು.
Lord,
Whole Saturday and Sunday made sleepless.
ನಾನು ಅವತ್ತು ಫಸ್ಟ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದು 30 ಕೊಟ್ರೆ ಸರಿ ಹೋಗುತ್ತೆ ಅಂತಂದೆ. ಇಲ್ಲ 60 ಪೇಜ್ ಆರ್ಡರ್ ನಾನು ಓದ್ತೀನಿ ಅಂತ.
ಹಾಗೆಲ್ಲ.
ನಾನು ಆಯ್ತು ಕೇಳಿಸ್ಕೊಡ್ತೀನಿ ಅಂತ.
ಡೈರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿದ್ರೆ ನಾ ಶನಿವಾರ ಭಾನುವಾರ ಒಳ್ಳೆ ನಿದ್ದೆ ಮಾಡ್ತಾ ಇದ್ದೆ. ಹೆದರಿಕೊಂಡು I am afraid of that.
The property has to be saved, my lord. In the contrary, if there is any other viability.
Property to be saved now after the sale deed is difficult.
No, it's not. It's a fraud. There is a collusion. There is a collusion.
ನೀವು ಕಷ್ಟದಲ್ಲಿ ಇದ್ದಾಗ ಅವ್ರು ಬಂದು
ಅಲ್ಲ ಹಾಗಲ್ಲ. The same advocate. See, ಇಲ್ಲಿ ಇನ್ನೊಂದು important aspect I wanted to bring it to the notice.
ನಿಮ್ಮ ಮನೆಯವರೆಲ್ಲ ಸರಿ ಇದ್ದಿದ್ರೆ
D2 and D3 were placed ex parte and 411.
ನಿಮ್ ಮನೆಯವರೆಲ್ಲ ಸರಿ ಇದ್ದಿದ್ರೆ ಈ ಪರಿಸ್ಥಿತಿಗೆ ಬರ್ತಿರ್ಲಿಲ್ಲ.
ಹೌದು, ಅದು ಗೊತ್ತಿದೆ.
ಸೊ ಅದರಿಂದ
ಅದು ಗೊತ್ತಿದೆ.
ಎಷ್ಟಾಗುತ್ತೋ ಅಷ್ಟು ಇದ್ ಮಾಡೋಣ. ನೀವು ಪೂರ್ತಿ
ಆಗಲ್ಲ. Your lordship may kindly think otherwise. On 411 they were placed ex parte. So they have not been represented by any advocate. They are not represented by any advocate. ಇವರೇ advocate ಅಂತ ತಿಳ್ಕೊಂಡು ನಿಮ್ಗೆ ಯಾಕೆ ನಿಮ್ ದುಡ್ಡು ಕೊಡಿಸ್ತೀನಿ ಅಂತ ಹೇಳಿ ಮೋಸ ಮಾಡಿರೋದು.
Appear for respondent number 5, my lord, who is the defendant number 1 in the suit, my lord, wherein she has I filed my objection, my lord, wherein she has filed an HRC proceedings against the plaintiff, and the eviction order has been passed, my lord, that is annexure R1. And the compromise petition which is entered by threatening me, my lord, I has not given my consent to the.
What's your name?
P. Sunita, my lord, the defendant number 5 in the respondent number 5 in this petition.
You are also the person who sold the property.
Please, my lord.
No, they have not sold. They have not sold.
What has sold?
Indiramma and Nandakumar.
That compromise was
3 shares.
One item property still remains with them.
Vendors here.
It is in respect of 2 property.
Vendors ಯಾರ್ಯಾರು?
Indiramma and Nandakumar.
Vendors ಯಾರ್ಯಾರು?
Indiramma, Nandakumar and Vijayalakshmi.
ಅವ್ರ 3 ಜನಕ್ಕೆ 30 ಲಕ್ಷ. ಇವ್ರಿಗೇನು ಇದ್ದಿದ್ದು?
ಅವ್ರಿಗೆ ನಾವು ಪ್ರಾಪರ್ಟಿ ತಗೊಂಡಿಲ್ಲ, ನಾವು ಏನು ತಗೊಂಡಿಲ್ಲ, ನಾವು ಟೆನೆಂಟ್ ಅಷ್ಟೇ ಅವ್ರಿಗೆ.
There is a property still remains with her. That was not.
The remaining portion is 30/2 is remaining with her.
That was not.
We are a tenant under then, they have evicted me.
Two items which they are concerned, that is the subject matter of the dispute. One item which she concerned, which is nothing to do with the dispute.
You'll be safe. If your item is not,
As per the compromise terms,
Sir,
my lord,
that
no
is-
amount is paid to me, what as
that
expressed
is because your property is not sold.
No.
Your property is not sold.
with respect to my portion, my lord, but what are the
He's the
terms
LR.
of the compromise? They are supposed to pay me an amount which is not been paid by the plaintiff, my lord. And by threatening me, and there is a criminal case pending with respect to all the fraud paid by the plaintiff, my lord. I filed a CC number which is still pending.
Have you sold the property of yours?
Under the compromise, what are the terms, my
Have
lord?
you sold the property of yours?
Not under the same sale deed, my lord.
If you're not, it's a different sale, it's a different matter. You have not sold your property under the sale deed.
Under not, what is not
That
in
is subject
the.
matter of
this-
I'm only concerned with this
matter.
particular sale deed. Nothing more. They have come to the court challenging their sale deed. If that is set aside, only then they get some relief. I'm only focusing on that. Yours, let us consider afterwards.
Very well, complete.
Please.
Interim order will be kindly extended.
You want to continue to the next item.